Ma'am, court officer, court officer. Court officer. Can you hear me, court officer? Ma'am, ಒಂದ್ ರಿಕ್ವೆಸ್ಟ್ ಇತ್ತು. ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಮ್ಯಾಮ್? ನಾಟ್ ರಿಪ್ಲೈ. ಮ್ಯಾಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ.
ಒಂದ್ ರಿಕ್ವೆಸ್ಟ್ ಇತ್ತು ಸರ್. ಏನಂದ್ರೆ ನಮ್ದು ಸಿಂಗಲ್ ಬೆಂಚ್ ರಿಜಿಸ್ಟ್ರಿಯಿಂದ ಪರ್ಮಿಷನ್ ತಗೊಂಡು ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಅಲ್ಲಿ ಬರ್ತಾ ಇದೀವಿ ನಾವು. ಬ್ಯಾಂಗ್ಳೂರಲ್ಲಿ ಫೈಲಿಂಗ್ ಆಗಿರೋದು ಸರ್. FR ನಂಬರ್ 11066. ಮೆಮೊ ಕೂಡ ಪಾಸ್ ಮಾಡಿದೀವಿ ನಾವು. ಸರ್ ರೆಸ್ಪಾನ್ಸ್ ಕೊಡಿ ಸರ್. ಸೊ ರಿಜಿಸ್ಟ್ರಿಯಿಂದ ಪರ್ಮಿಷನ್ ತಗೊಂಡು ಬ್ಯಾಂಗ್ಳೂರಲ್ಲಿ ಫೈಲಿಂಗ್ ಆಗಿದೆ ಸರ್. ಸೊ ತುಂಬಾ ಅರ್ಜೆಂಟ್ ಇತ್ತು, ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದೆ ಅಂದ್ರೆ ಸಕ್ಸೆಸಿವ್ ಪೆಟಿಷನ್ ಇರೋದ್ರಿಂದ ಸಾಹೇಬ್ರ ಹತ್ರನೇ ಬರುತ್ತೆ, ಬಸವರಾಜ ಸರ್ ಹತ್ರ.
ಅದು ರಿಜಿಸ್ಟರ್ ಲೆವೆಲ್ ಅಲ್ಲಿ ಮಾತಾಡ್ಬೇಕು ಮೇಡಮ್, ARJ ಚೇಂಬರ್ ಕಡೆಯಿಂದ.
ಅಲ್ಲ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಸರ್, ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಅಲ್ಲಿ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಆಯ್ತು, ಬಟ್ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಅಲ್ಲಿ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ರು ಸರ್, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಬಂದೆ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಅಲ್ಲಿ. ರಿಜಿಸ್ಟ್ರಿ ಆಫೀಸ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರು ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಅಲ್ಲಿ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅವ್ರಿಗೆ.
ಇಲ್ಲ ಮೇಡಮ್, ನೀವು ಮೂವ್ ಮಾಡಿದ ನಂತರ ರಿಜಿಸ್ಟರ್ ನಮ್ ರಿಜಿಸ್ಟ್ರಿ ಅವರು ಜುಡಿಷಿಯಲ್ ಹತ್ರ ಪ್ಲೇಸ್ ಮಾಡ್ತಾರೆ. ಜುಡಿಷಿಯಲ್ ಬಸವರಾಜ್ ಸಾಹೇಬ್ರ ಹತ್ರ ಪ್ಲೇಸ್ ಮಾಡಿದ ನಂತರ ಅವರು ಒಂದ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಡ್ತಾರೆ ಲೀಸ್ಟ್ ಮಾಡೋದಕ್ಕೆ. ಡಿವಿಷನ್ ಬೆಂಚ್ ಇಲ್ಲಿ ಮಾಡಕ್ ಬರಲ್ಲ.
ಇವಾಗ ನಾವ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡೋದ್ ಬೇಡ್ವಾ ಅಂತ?
ಇಲ್ಲ, ನೀವು ರಿಜಿಸ್ಟರ್ ಲೆವೆಲ್ ಎಲ್ಲ ಮಾಡ್ಕೋರಿ. ಈ ಜುಡಿಷಿಯಲ್ ಅಂತಿದ್ದಾರೆ, ರಿಜಿಸ್ಟರ್ ಫಾರ್ ಜುಡಿಷಿಯಲ್. ನಿಮ್ ಕನ್ಸರ್ನ್ ಯಾರಾದ್ರೂ ಒಬ್ರು ವಕೀಲರು ಕಳಿಸಿದ ನಂತರ ಅವ್ರು ತಗೊಂಬಂದು ಬಸವರಾಜ್ ಸಾಹೇಬ್ರ ಹತ್ರ ಇಡ್ತಾರೆ.
ಓಕೆ ಓಕೆ, ಸರಿ ಸರ್.
ಅವ್ರು ಒಂದು ಡೇಟ್ ಬೇಕಾದ್ರೆ ಕೊಡ್ತಾರೆ. ನಿಮ್ ಬೇಕಾದ್ರೆ ವಕೀಲರು ಬೆಟ್ಟೆಗೆ ಕೇಳಿ ಜುಡಿಷಿಯಲ್ ಅವ್ರನ್ನ.
ಓಕೆ ಸರ್, ಇವತ್ತು ಬೇಡ್ವಾ ಸರ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡೋದು ಹಂಗಂದ್ರೆ VC ನಲ್ಲಿ?
ಮಾಡಿ ಹೇಳಕ್ ಹೇಳಿ, ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಮಾಡಕ್ ಬರಲ್ಲ. ಐ ಥಿಂಕ್ ಇಟ್ಸ್ ನಾಟ್ ಎ ಕೋರ್ಟ್ ಡೆಕೋರಮ್.
ಓಕೆ ಓಕೆ ಸರ್, ಎಸ್ ಫೈನ್.
ಎಸ್ ಎಸ್
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಎಸ್ ಮೇಡಮ್, ಎಸ್. ಹಾ ಅದೇ ಇವ್ರು ಕುಲಕರ್ಣಿ. ಹಾ ತಗೊಂಡು
ಯಾರು ಮಿಸ್ಟರ್ ಬಾಬುರಾವ್?
ಬಾಬರ್ ಎಸ್ ಮೇಡಮ್ ಅವರು ಜಸ್ಟ್ ಅವರು 12th or 13th or 14th ಫಿಕ್ಸ್ ಮಾಡೋದು ಸರ್ ಡೇಟ್.
ಮಿಸ್ಟರ್ ಬಾಬುರಾವ್,
seal number 45.
ಮಿಸ್ಟರ್ ಬಾಬುರಾವ್,
ಜಸ್ಟ್
ಬಾಬುರಾವ
ಇಲ್ಲ ಹುಷಾರ್ ಇದೆ
There, he is also in the mud. He is
Baburao. Baburao.
he is also
ಬಾಬುರಾವ್, ಮೈಕ್ ಆನ್ ಮಾಡ್ಕೊಳ್ರಿ.
ಸರ್ ಮ್ಯೂಟ್ ಆಗಿದೆ ಸರ್ ನಿಮ್ದು. ಬಾಬುರಾವ್ ಸರ್.
At the request of learned counsel, Shri Sanjay M. Joshi, release these matters. Batch matters, sir.
ಡೈಲಿ ಯೂಸಸ್ ಮ್ಯಾಟರ್ಸ್ ಮೇಡಮ್.
Huh?
ಆರ್ 100% DA and others benefits and
Release these matters on
14th.
14th of November.
Yes ma'am.
14th Rajay. 12th ಆಗ್ಬೋದು ಸರ್. 12th or 13th ಆಗ್ಬೋದು.
Yes sir. 12th.
12th ಬೇಕಿದ್ರೆ
12th yes.
ಯಾಕೆ why are you asking for such a long date?
ಅವ್ರು ಬಾಬರ್ ಅವರು ಹೇಳ ಸರ್ ಅವ್ರು ಇದಾರೆ ಸರ್. ಅಷ್ಟು ಇಶಿಯಲ್ ಬಂದ್ರು ಅವ್ರು ಇದಾರೆ.
ಏನಂತೆ? What is the problem?
ಅವರು ಬರ್ಲಿಕ್ಕೆ 12th or 13th ಇಡಸ್ ಅಂತ ಸರ್.
ಏನ?
ಅಲ್ಲ 12th or 13th ಇಡಸ್ ಅಂತ ಅವ್ರು.
Yes.
My lord,
Yeah, why are you asking for such a long date?
matter is listed many times, my lord, it is not right.
Why
No,
are you
or
asking
else
for a
kindly
long
have it
date,
seventh,
sir?
my lord, seventh.
Huh?
Kindly have it on seventh, my lord.
Seventh or eighth, no.
Seventh, my lord.
ಅಲ್ಲ 7th, but 12th ಬೇಕಿದ್ರೆ ಹಾಕ್ತೀವಿ.
Because the
12th
each
ಹಾಕ್ತೀವಿ.
time the government is saying that my lord, age has to come. We are
Release
each
this
time we
matter
were
on,
ready, my lord.
7th of November.
ಅಲ್ಲ 7th ಬೇಡ ಸ್ವಾಮಿ, ಇನ್ಕನ್ನು ಸ್ವಲ್ಪ AG ಅವ್ರು ಅಪೇರ್ ಆಗ್ತಾರೆ.
Seventh,
Huh?
seventh.
AG ಅವ್ರು ಅಪೇರ್ ಆಗ್ತಾರೆ.
Huh?
12th date
Yeah,
fix ಮಾಡಿ.
what is the difficulty on 7th?
This is the my lord, because this is the my lord, they are seeking the daily allowances and HRA, my lord. 100% they are asking, they are not entitled. We sanctioned 90% is sanctioned to them.
Why are you asking for a long date ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ?
ಇಲ್ಲ 12th ಗೆ ಒಂದು ಅವರೇ ಬರ್ತಾರೆ ಅಂತ first.
Huh?
ಅವ್ರು usually appear before.
Why only that date?
This is another
Why
matters.
not on 7th?
ಅಲ್ಲ other matters na ಅದೇ so.
Huh?
Other matters
Quickly, let us see. 7th of November. Yes.
Oblige, oblige, my lord.
Serial number 37, my lord.
Huh?
Serial number 37, I am for appellant, my lord.
Huh?
It may be taken on 5th, my lord.
Mr. Bhusare.
My lord, appearing for
You are
respondent.
appearing for the respondent, is it?
Appellant, my lord.
Appellant.
Connection going.
Mr. Bhusare.
Please, my lord, please.
Serial number 37 at the request of learned counsel for the appellant. Release this matter.
5th November.
Huh?
5th November.
ಏನ್ ಎಲ್ಲ ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇಟ್ ಗಳು ಕೇಳ್ತಿರಲ್ಲ, ಹಿಂಗೆ ಏನು ಸಮಾಚಾರ ಇದು?
Senior is
Huh?
not well, my lord.
Huh?
Senior is not well.
ಸೊ 5ನೇ ತಾರೀಕೆ ರೆಡಿ ಆಗೋದವ್ರು ಅಂತ. On 5th of November.
Yes.
Lordship, serial number 53.
My lord,
Lordship, serial
serial number 54, my lord.
Ah.
Press time for 2 weeks, my lord. And for appellant number 196, my lord. As my senior is no more, I need the consent of my client to move forward. I will consent and have it.
54.
Serial number 54, my lord.
Mr.
In that
Ishwar.
Yes, my lord, he is my senior.
Ah.
He is no more, my lord. I will consent with my client and I will move forward with this, with the arguments, my lord.
That is only for appellant number 1.
196, my
1
lord.
and 6.
Yes, ma'am. I kindly press time for 2 weeks, ma'am.
Serial number 54.
Much
At
obliged.
the request of learned counsel, Miss Ambika.
Ambika Chaudapur.
Ambika Chaudapur. Ambika S. Patil ಅಂತ
Yes,
ತೋರಿಸಿದ್ದಾರೆ ಇಲ್ಲಿ.
please, ma'am. Erdu
Ambika S. Patil.
Please, ma'am.
Relist this matter on 11th of November.
Please, ma'am.
Yes.
Lords, kindly, serial number 48, my lord.
Ah.
Lord, recently I have filed the wakalat, my lord, obtaining no objection from earlier counsel. Some instruction I have to get from the appellant.
Yeah, the final hearing matter 2014.
Clear, my lord, some other counsel was handling.
Ah.
Next week, any date maybe.
Who's on the other side?
After Mr.
Serial number
Lord,
48 at the request of learned counsel for the appellant. Relist this matter on 12th of November. Yes.
Lordship, serial number 53. A week's time may be granted, your lordships. It's a state appeal.
The other side,
We are a respondent. State is on the other side.
53.
Yes, your lordship.
57.
At the request of learned counsel for the respondents, release this matter on 13th of November.
Much obliged.
Yes.
Serial number 40, my lords.
Hmm.
For appellant, I have to produce the rules, relevant rules, kindly a week after next month. I am the appellant, inform the others.
Mr. Ravi Patil.
Yes, informed. There is no interim order.
Huh?
There is no interim order, inform the other side also.
We don't adjourn the matter unless the other side is here. Otherwise, when
Is
the
in,
matter is appeal at-
Please.
Yes. Yes, please
And
follow.
complaints of office objections from this time. CL number 1, Nankishore Bhu.
Lord, a week time may be granted, my lord. My lord, matter may be connected with writ appeal number 200249 of
200.
249 of 2024.
List this matter along with writ appeal number 200,249 of 2024. Full stop. In the meanwhile, office objection shall be complied with.
CL number 2, Nitesh Padiyar.
I prefer the petitioner, week's time will be granted.
Huh?
Week's time may be granted to comply the office submission.
A week's time is granted at the request of learned counsel for the complainant for compliance of office object.
CL number 3, Hiranbada Mali Patil.
Week's time.
A week's time is granted at the request of learned counsel for the appellant.
CL number 4, additional government advocate.
Lord, place a 2 weeks time, my lord, in this.
2 weeks time at the request of learned counsel, learned government advocate.
CL number 5, Harshavardhan R Mali Patil.
2 weeks time, my lord. The main office objection is regarding court fee lodge.
Yes, 2 weeks.
Please.
Yes,
CL number 6, additional government advocate.
6 and 7, my lord, 2 weeks time may be granted.
yes, 2 weeks time.
CL number 8, Mr. Ambedkar.
8 and 9, 2 weeks.
Huh?
8 and 9 serial number.
2 weeks.
Two.
CL number 10, orders, PB Patil.
Put the order sheet, put it. ಏನ್ರಿ 2020
So it appears, my lord, one of the respondent number 1 is dead. I'll,
put is to respond number 4 and 7. You
that,
not
that
taken
I'll
steps.
comply with the course of the day, my lord.
Huh?
4 and 7 course of the day I will comply, my lord.
Then it
For
comes
R1,
the
my lord, I
appellant
require some time.
submits that steps will be taken for service of notice on response number 4 and 7 during the course of the day. Stop. Next para. 2 weeks time is granted to the appellant to take steps for service of to take steps regarding deceased respond number 1.
Number 1.
CL number 11, DP Ambedkar.
Where for the respondent. Last occasion, my lord, your lordship is after hearing.
Copy of additional affidavit was not served, my lord. In this case, what has happened was the accused, my lord.
Yes.
The accused herein, accused number 1.
Your contention is that on that particular day election was not held.
Alla, hagalla.
Wants to contempt.
No, my lords, not like that.
Then?
Illa, ಏನಾಗಿದೆ? There was a panchayat election held
Yes.
for post of Adhyaksh and Upadhyaksh,
Yes.
Taj Sultanpur. In which, my lord, accused number 1 herein, he was appointed as a returning officer.
Yes.
What he did was he fixed a date
Yes.
for meeting,
Yes.
for electing the president and vice president.
Yes.
On that day, quorum was less than half. So, in spite of that, he ought to have done was, as per the rules, he ought to have waited for 30 minutes. In spite of waiting for 30 minutes, if there is no quorum, he ought to adjourn the matter for some other day.
He has stated very clearly that there was a galata.
No, my lords.
Not a, that was that
Adilla,
is
adide,
the
I will
information
explain.
provided.
I will
And
explain. my lord.
therefore, he fixed a next date, and on the next date, election has been held.
That's what I am trying to explain, my lord.
Yes.
On the first day, my lord, there is no quorum. There is no galat also. On the when it was originally fixed.
Your submission, sir.
Illa. In fact, my lords, on the
He
last
is on record filing an affidavit that this is what has happened. So therefore, I had to fix a next date. I have fixed the next date and I held the election. Elections have been held.
I'll just explain. I'll just explain. That is not what has happened. In fact, it is not his contention also. In fact, on the last occasion, my lord, before the previous bench, he submitted, in fact, they was asked to file a better affidavit.
Yes.
Because
You have seen that.
what has happened was, on the first day fixed.
ಇನ್ನೇನ್ better affidavit ಅಂತ ಏನ್ ಮಾಡ್ತಾರ ಅವ್ರು?
ಅಲ್ಲ, ಅದು ಹೇಳ್ತೀನಿ.
Can be done.
ಅಲ್ಲ, I'll just how he has grossly violated the order of the court. There was no quorum. Less than half quorum was minimum half quorum was not there. So instead of adjourning the matter, what he did was he received the nomination for one each for the post of president and vice president. And he fixed the next date just to declare the result. Since there was only one post for each and only one nomination was received. That, my lord, is contrary to the law laid down by the division bench of this honorable court. Therefore, we filed the writ petition stating that he has to conduct the election afresh. In fact, when there is no quorum,
Even if that is your contention, where is the question of contempt?
I'll just explain one.
Yes.
Therefore, my lord, I obtained the interim order, I filed a writ petition, obtained a stay and also obtained a final order. Wherein He was asked to comply with the direction in the division bench case of Shobha P versus Mohini and others, 2015.
What is the orders issued by this court, sir?
He was, the order is,
Order that are issued.
kindly page number 26.
We are talking of the events that have happened after the order was passed.
Yes, my lord, that's what is contempt. That's what he has committed contempt.
What is contempt?
I'll just go through my prayer in the writ petition.
So first read the operative portion of the order passed by the learned singleton.
My lord, kindly,
Is there an order of the division bench?
he has referred,
Single bench thane?
single bench.
Please see the directions issue.
Yes, kindly, my lord, first I'd like to take your lordship
At
to.
view of the matter, the returning officer is hereby directed to conduct election by
Yes.
fixing the next date,
Yes.
taking into consideration the rules provided therein. In this regard, the returning officer shall also keep in mind
The
the
judgment.
judgment of this court in the case of so and so,
Yes.
disposed of on so and so.
Yes,
In terms of the observation made herein above, the writ petition is disposed of.
yes, my lord.
Yes.
No, my prayer was kindly on page number 18. My prayer in the writ petition, maybe. Page 8.
Your prayer is not important, sir.
That.
Directions issued by the learned single judge is important.
Yes,
The contempt court is required to consider whether there is compliance of the directions issued by the court. That's
Yes,
all.
he was,
Not what prayer you have made in the writ petition. Yes.
my contention is, there was a specific direction to keep in mind the principle laid down in Shobha P versus Mohini.
ಏನ್ ಹಂಗಂದ್ರೆ?
ಅದರಲ್ಲಿ judgment ಇದೆ. Last page.
Therefore, if the directions are not clear,
Hmm.
we cannot do anything.
Direction was,
The judgment to the
in-
Supreme Court.
in that, my lord, so what it was held was, in case there is no quorum, no proceeding for election can be taken. Matter is to be adjourned on some other date. On that day, even if there is no quorum, he can proceed to accept the nomination paper and declare the results. What he has done here was, he accepted the nomination illegally when there was no quorum on first meeting. When we attended the second meeting, he told that he is just going to declare, he is not going to accept our nomination.
Are you talking of the events that have happened prior to the this order, or events that have happened after this order?
One event had occurred prior to this
We are
one.
not concerned with what has happened prior.
Yes, ma'am.
We are only concerned with the directions issued.
Yes, ma'am.
Yes.
Therefore, my lord, when this order was passed, the second meeting was fixed.
Direction is to fix the next date of meeting
Meeting.
and to go ahead.
Go ahead in light of the order. So in light of that division bench,
Yes. The direction should have been very clear that in view of this judgment, you are supposed to do only this,
yes.
nothing more. Atara direction illa.
Athra direction division bench judgment nalli ಇದೆ.
See, you can't rely upon what is said in the judgment if the operative portion is not clear. So he has said, accordingly, I fixed a date. On that day, there was a galata. I had to fix a next date.
Next date.
On the next date, I have held the election and I have declared the results.
He has not held the election. He just declared the results. He has just declared the result.
The affidavit that he has filed says so.
Para 7, my lord.
Yes,
Para 7 of the affidavit.
yes.
Additional affidavit have not been served.
Huh?
I'm reading the affidavit dated 4/9/2024.
He has reiterated the same thing.
Yes.
Nothing. He filing better affidavit on the ಈ ವಿಷಯದಲ್ಲಿ ಏನ್ better affidavit can he file?
I'll just read Para 7 of the affidavit. It is submitted that in pursuance of the calendar of events,
ಯಾವ್ದು ಓದ್ತಾ ಇದ್ದೀರಾ?
paragraph 7 of the affidavit dated 4/9/24.
4/9.
Yes.
This is the second affidavit.
Second.
First affidavit ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರು?
First affidavit is vague, my lord. Therefore, he was directed to file 8/12/23.
Yes.
Nothing was clearly forthcoming in that. Therefore, he was asked to file this affidavit. Paragraph 7 of the affidavit dated 4/9. May I read?
Please read from paragraph number 5.
5. It is submitted that Deputy Commissioner issued direction to me.
ಯಾವ್ದು?
4/9.
We are talking of the first affidavit.
First.
8/12/2023.
Yes.
Yes.
It is relevant to submit that on 4/9/23 members participated in election who were made galata and not allowed me to conduct the election. I also informed them.
This is the events that have happened after the directions were issued.
Yes, 4/9.
Okay.
Yes.
4/9/2023 is an event that has happened after the directions issued by the learned single judge.
Yes.
Please read.
Galata not allowed me to conduct the election.
What he said.
Ah.
Were made galata and not allowed me to conduct the election.
I also informed to them the Honorable Court directed me to conduct the election in spite of repetitive. All the members, they are not cooperated. Hence, I could not conduct the election. Proceedings which was taken place on same day was also entered in the register book. Copy of same is Annexure R2. It is further submitted that learned single judge directed me to hold the election. Accordingly, I fixed date on 22/9/23 for conducting election of Adhyaksha and Upadhyaksha of Gram Panchayat. On said day, all members participated. Accordingly, I completed the election and declared president and vice president.
Yes.
Copy of proceedings are so and so.
Yes.
My lord, this, my lord, now the fresh affidavit which has been filed. Here, my lord,
Allah, better affidavit file ಮಾಡಿ ಅಂದ್ರೆ ಅರ್ಥ ಏನು? He has
ಅದೇ.
simply narrated whatever has happened.
Yes.
Elections have already been held on 22/9.
yes, ma'am.
What can be done now in a contempt proceedings?
Yeah.
This is what we said in the previous date of hearing. So therefore, if you are agreed of the second action, you should have filed one more writ petition.
Please, that
That is what we said.
ಅದು ಏನಾಗಿದೆ ಇದರಲ್ಲಿ just I leave it to the court.
You see, you may be right. If something has been said in Shobha's case, that
Yes.
this is the procedure
To
that
be
is
followed.
required to be followed.
Yes.
And again, the same mistake has been committed.
Yes, ma'am.
Then cause of action is to file one more writ petition. You are alleging contempt.
Yes, ma'am.
Contempt will not stick in this matter because he has narrated whatever has happened. He had fixed a date on 4/9/2023.
Yes, ma'am.
He was not able to hold the elections. So therefore, he fixed one more date. On that day, elections were held, results were declared. So he is saying there is compliance of the directions issued by this court.
Please.
But you are saying this action is contrary to the
Direction
law
issued,
laid down by the division bench in
Yes.
Shobha's case.
which I want to.
Say it's a cause of action for filing one more writ petition.
With that observation, my lord, it can be discussed.
Perfect. This contempt petition arises out of
Just two paragraphs, if it is read affidavit nally, he clearly admits that he has committed contempt. In better affidavit which has filed on 4/9, two paragraphs ne ಓದಿದ್ರೆ it will clear that he has admitted on affidavit that he has committed contempt.
ಏನ್ contempt?
First, my lord, paragraph 7 ಅಲ್ಲಿ. Better 4/9 affidavit. He admits, it is submitted that in pursuance of calendar of events, a fixed date on 4/8/23 for accepting nomination from 10 to 12 p.m. Accordingly, Srimati Sajjada Begum, wife of Maula Sahab, submitted nomination to post of Adhyaksha, and Sanju Kumar Tippanna submitted nomination for Upadhyaksha. The said nomination has been scrutinized. The total number of 26 out of 12 are present. So less than half was present. Minimum quorum was 13. Less than half were present. So he could not have accepted the nomination. Still he accepts. That is the first wrong he has committed. Second is, my lord, hence adjourn the meeting by fixing date on 11/8/2023. One Sharan Basappa.
So this is the previous.
Yes, my lord. That's what.
We are not concerned with that.
ಅಲ್ಲ ಅದು ಎಲ್ಲನೇ ಓದ್ತೀನಿ. Continuity ಬೇಕು.
These are the proceedings that had happened
prior to filing.
Gave rise to the filing of the writ petition.
Yes, ma'am. I'll just.
Or in a contempt proceedings, we are required to consider.
I'll just 2 minutes of the court's time.
Consider madi, there is a direction issued.
Yes, my lord.
Yes.
Therefore, my lord, thereafter, hence adjourn the meeting to 11/8/2023.
Yes.
One Sharana Basappa, that is contempt petitioner, Ambanna has filed writ petition number so and so before the learned single judge, and learned single judge granted interim order of stay on 9/8/23. Learned single judge also directed not to conduct the election on 11/8/23 at 11 a.m. in furtherance of election notice dated 19/7 without permission of the court. It is submitted that writ petition came to be disposed of 18/8/23, directing me to conduct the election as per judgment referred in writ appeal number so and so. It is submitted that In pursuance of order passed by a fixed date on 4/9/23 at 10. That is subsequent to the
Same
order.
thing.
Ah.
He has repeated the same
Ah.
thing.
Now, my lord, she comes to that.
Yes.
It is submitted a request to the deputy commissioner to issue this thing accordingly and further to hold election as per this thing. That is relevant. Now, my lords, paragraph number 12. He says it is submitted that contention of complaint that on 20/9 I have to accept the nomination, proceed with the election, which is hereby denied. Since as per calendar of event issued by me, date fixed for submitting nomination on 4/8/23. Accordingly, the candidate has submitted nomination of Adhyaksha and Upadhyaksha on the 4 date itself, when there is no quorum. Since I have not hold election on subsequent, I have conducted the election 20/9, and there is no direction for issue of fresh calendar of events. That is entirely wrong.
There, see, he has proceeded in the manner as to how he has understood the order.
Yes.
He may not be correct.
Yes.
That may not be the position of law.
Yes.
But then the question is whether this would amount to contempt or gives rise for a fresh cause of action.
In fact, my lord, that's why, my lord, we are under impression that you would not understand the order. Therefore, as per Annex F to my contempt petition, I gave a detailed representation, extracting the necessary this thing and asking him to follow the rules. In spite of that, he has accepted that this thing, still he has this.
Directions issued by the learned single judge in petition number 202293 of 2023. Stop. The petitioner herein, the complainant herein was the writ petitioner. Who had approached this court, approached the learned single judge, assailing meeting notice dated 4/8/2023, while seeking directions to the returning officer to issue fresh calendar of elections to the post of Adhyaksha and Upadhyaksha of the Taj Sultanpur Gram Panchayat. Stop. Having regard to a judgment of a coordinate bench of this court in the case of Shobha P and others versus Mohini and others, reported in bracket 2015, close 8, Karnataka, CK 0198, in writ appeal number 2184-2205 of 2015, the learned single judge directed the returning officer to conduct election by fixing the next date, taking into consideration the rules provided therein. Full stop. Next para. It is the contention of the petitioner that despite such specific direction, that the returning officer should conduct the election by fixing the next date, taking into consideration the rules and law declared by the coordinate bench, the returning officer again committed a mistake in accepting the nomination papers from one candidate each for the post of Adhyaksha and Upadhyaksha when there was admittedly no quorum. Full stop. Further, on the date fixed for election, namely 4/9/2023, the returning officer did not hold the election. Full stop. On the other hand, another date was fixed on 22/9/2023, and the returning officer simply proceeded to accept the nomination papers at the hands of two individuals for the two posts which were filed on 4/9/2023 and declared the results on 22/9/2023. Full stop. Next para. On the other hand, the returning officer had filed an affidavit earlier before this court on 8/12/2023, stating that on 4/9/2023, although two individuals,
4/8.
Yeah?
4/8 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು.
ಅಲ್ಲ 4/9
4/8
sir.
ಕೊಟ್ಟಿದ್ದು.
Huh?
4/8 nomination has been filed. 4/8 nomination has been filed. 4/9 no proceedings took place as Galata took place. He has admitted. Para 11 ಅಲ್ಲಿ when there was no quorum, the nomination accepted on that day, they were declared as elected. 4/9 no proceeding took place.
ಏನ್ ಹೇಳಿದೆ? ಅಲ್ಲ, on 4/9/2023, though the date was fixed for holding the elections in terms of the directions issued by the learned single judge, nevertheless, the election process was disrupted by the members of the Gram Panchayat, and therefore he was not able to hold the elections on 4/9/2023. Full stop. He therefore requested the Deputy Commissioner and the Deputy Commissioner issued a show cause notice and thereafter directed the returning officer to hold the election by fixing another date. Full stop. Accordingly, on 22/9/2023, the elections were scheduled, and accordingly, on 22/9/2023, the returning officer declared the results of the elections. Full stop. Next para. Having regard to the facts narrated herein above, this court is of the considered opinion that the returning officer has placed on record all the relevant information and has stated clearly that on 4/9/2023, he could not hold the elections because the elections were disrupted by the conduct of the members of the Gram Panchayat. Full stop. Therefore, another date was fixed, and on that date, the results were declared based on the nomination papers filed by two individuals on 4/8/2023. Full stop. The question therefore is whether this would amount to contempt on the part of, this would amount to willful disobedience of the directions issued by the learned single judge. Stop. Having regard to the directions issued by the learned single judge, where it was directed that the returning officer shall fix the next date and proceed to conduct the elections. We do not find specific directions as to how the returning officer was required to proceed. Full stop. If the learned single judge was of the opinion that acceptance of the nomination papers which were filed on 4/8/2023 was not in accordance with law, then the acceptance of the nomination papers should have been set aside. Full stop. Without passing such directions, when directions were issued to the returning officer to fix the next date of election and proceed accordingly, we do not find any reason to accept the contention of the complainant herein that there is willful disobedience of the directions issued by the learned single judge. Full stop. Next para. ಅದು ಮೊನ್ನೆ ಇದ್ರದ್ದು ಕೊಡ್ರಿ ಅದು. In Jareshwar Prasad, Paul and another versus Taraknath Ganguly and others, bracket 2002, 5 SCC 352, the Honorable Apex Court has held that if the judgment or order does not contain any specific direction regarding a matter, or if there is any ambiguity in the directions issued therein, then it will be better to direct the parties to approach the court which disposed of the matter for clarification of the order, instead of the court exercising contempt jurisdiction, taking upon itself the power to decide the original proceeding in a matter not dealt by the court, passing the judgment or order. Full stop. In that view of the matter, here are the considered opinion that the contention of the complainant herein that there is willful disobedience at the hands of the returning officer, cannot be accepted. Full stop. The complainant should have sought for a clarification at the hands of the learned single judge, or he should have filed a fresh writ petition, since there is a fresh cause of action for the complainant to challenge the action of the returning officer. Full stop. Next paragraph. For the reason stated above, we are of the considered opinion that there is no willful disobedience on the part of the respondent returning officer. Full stop. Therefore, the contempt petition is dismissed.
Great. With liberty only.
ಅದು ಬಂದಿದೆಯಲ್ಲ
ಬಂದಿದೆ.
previous paragraph.
CL number 12, Jairaj, K book. CL number 12.
On 15/10/2024, the following order was passed. Extract not. Huh? Next para. Office objections have not been complied. There is no representation for the complainant. So, accordingly, the contempt petition is dismissed for non-prosecution.
For 13, Sachin M. Mahajan.
During the course of day. During the course of day,
Huh?
during the course of will be done.
Learned counsel for the appellant submits that that steps will be taken. Correct address ಕೊಡ್ಬೇಕಲ್ಲಮ್ಮ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ Finally, 2 weeks time is granted at the request of the learned counsel for the appellant to furnish correct address and take steps for service of notice on respondents number 1 to 3.
Case number 14, A.M. Nagar.
In this case, my lord, respond number 2 and 4 are refused, my lord, notice.
Huh?
Respond number 2 and 4, my lord.
Madam, previous matter. 20% award amount ಯಾರು ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಕಾಗಿರೋದು ನೀವೇ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಯಾಕೆ ಹಾಕಿಲ್ಲ ಇದೇನಿದು ಮತ್ತೆ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಡೆಪಾಸಿಟೆಡ್ owner of the vehicle. So there is a direction, stay is granted. Huh?
Company.
See, stayed subject to the condition that the appellant shall deposit with the tribunal within 8 weeks from today 20% of the compensation awarded by the tribunal. You are the owner of the vehicle. Compensation has been directed to be given by you. That is why you are before the court, isn't it?
Jointly.
Huh?
Jointly on company as well.
Jointly ಅಂದ್ರೆ ನೀವ್ ಯಾಕೆ ಬಂದ್ರಮ್ಮ ಮತ್ತೆ ಕೋರ್ಟ್ಗೆ?
Owner.
Huh?
Owner will hire.
ಇಲ್ಲಮ್ಮ. The petition as against respondent number 2, insurance company has been dismissed. Liability is fastened only on you. That is why you are before this court.
Next time.
Huh? Okay, correct. Therefore, the claim petition has been dismissed as against respondent number 2, insurance company. Respondent number 2 is a New India Assurance Company. The claim petition has been dismissed as against the insurance company. Full liability has been fastened only on the owner of the vehicle. That is why you have come to this court. There is non-compliance of the directions. You are not entitled for the stay then. Huh? Deposit ಮಾಡಿದಿರಾ? Why?
Total 4 claimants are there. Total 4 application is made.
Huh? ಏನಮ್ಮ?
Total 4 MSC is filed.
ಏನ್ ಮಾಡ್ತೀರಾ? You want to deposit or not? Huh? Allama, that order was issued in July 2023. Yes, Mr.
Filed an
Mahajan.
application for extension, my lord. I have filed an application
Why
for
have you not
extension.
deposited 20%?
My lord, the appellant, my lord, was at Rajasthan. There was a communication gap.
Ah.
Regretting that, my lord, he is seeking permission of this honorable court, my lord, to deposit forthwith, my lord, as soon as your lordship, my lord.
Application hakidira?
ಹಾಕಿದ್ದೀನಿ.
Huh?
My lord, there is an application filed for the.
Huh?
I'm not wrong. My lord, I have the affidavit, my lord. Today itself, my lord, during the course of the day, it would be done.
Huh?
Today itself, during the course of the day, it would be done. My lord, I have got the affidavit from Rajasthan. My lord, during the course of the day, I'll file it.
ಏನಿಡ್ದ? Next para. However, it is also to be noticed that there is non-compliance of the directions issued by this court on 11/7/2023. In as much as the appellant has not deposited 20% of the award amount as directed by this court. Full stop. Learned counsel, however, submits that the appellant seeks to file an application
for extension
of time to deposit the said amount, and affidavit in this regard have been received from the appellant who is residing in Rajasthan. Full stop. A week's time is granted to the appellant to file necessary application seeking extension of time for complaints.
Highly obliged.
Seal number 14, Hem Nagraj.
Pyramid. We have Nagraj. No, in this case, my lord, respondent number 2 and 4 are represented, my lord, and I will take steps to respond number 1 and also distill respond number 3, madam. No, in 2 weeks, madam.
Steps to be taken in respect of refused. Respond number 2 has refused.
2 and 4, my lord. Item number 4.
Please, both have refused. Notary. Respondents number 2 and 4 have refused to receive the notice, therefore, notice is taken as sufficiently served on respondents number 2 and 4.
Yes, ma'am. Lord, I'll take steps to respond number 1, my lord, and also discharge respond number 3, my lord.
A week's time is granted to the appellant to take steps while furnishing the correct address in respect of respond number 1.
1, my lord. And 2 weeks time for respond number 3, my lord, is
2 weeks are granted to take steps regarding deceased respond number 3. Yes.
Seal number 15, Deepak V. Barad.
In this matter, my lord, state prepare the model.
This-
My lord. Export. What else?
Yes.
Contempt is
matter, my lord.
filed for disobedience of.
I filed the memo, my lord, along with the extract of the, my lord, SLP diary number, my lord, which is filed before the affects court, my lord, against the order of the.
ಏನ್ ಮಾಡುದು? Merely because SLP is filed,
So
we should
now
not proceed, is it?
we are moving in, my lord, that matter, my lord.
Ah.
Get that matter, my lord, within 2 weeks, my lord.
The retirement benefits, my lords. So, my lords have passed order on 30/10/2023. And my lord, he is already retired from service. My lords have passed the order. Within 3 months, it has to be. I have made available the order of this honorable court to the respondent authority on 23/11/2023 itself, my lord.
Learned government advocate has filed a memo along with copy of the information taken from the website of the Honorable Apex Court. Stop. It is stated that a special leave petition has been referred by the state challenging the order passed in writ petition number 201342 of 2021. Stop. Next para. However, learned counsel for the complainant submits that the order was passed by this court on 30th of October 2023. but the SLP has been filed on 2nd of October 2024. Only after this contempt petition was filed by the complainant. Stop. Next para. Release this matter. On 13th of November 2024. Full stop. If no order of stay is passed by the Honorable Apex Court, this court will proceed with the contempt petition.
Please.
Bill number 16, Farid Ustad.
Lord, this is,
Here for the
Lord,
response.
I have, before learning single judge, I have made representation for regularization, my lord.
Complaints affidavit has been filed.
Hi, affidavit, they have filed an affidavit
Ah,
stating that there is no vacancy available.
No, not, no.
There is no.
contempt ಹೆಂಗಾಗತ್ರಿ?
They have sent a letter of 2/9/2020.
What are the directions issued?
Lord,
Andamus is issued to response number 1, 3 and 4.
Yes.
To consider the representation.
Yes.
Strictly in accordance with law within a period of 90 days.
Yes.
From the date of receipt. So to consider and pass necessary orders.
yes, ma'am.
Now they have passed orders.
No, what they say that,
You may not be happy with the order.
no, Lord, in 2022 itself, they have sent a letter. In 2022, even before filing the writ petition, my lord. They have
My
sent.
lord, this endorsement was, my lord, is dated 2/9/2022, which was sent to the writ petitioner.
I have considered the representation of the complainant and have issued endorsement dated 2/9/2022. And the same was sent through normal post to the complainant. However, the complainant has filed the present complaint. And therefore, I have once again issued the endorsement 2/9/2022.
If at all they have issued the endorsement, they should have submit before this
They have
honorable.
not submitted so before.
My lord,
the
it was,
learning-
my lord, it
single-
was not, it was mandamus, my lord, on the very, when the take notice was ordered,
Same day,
same day it was.
without permitting you to secure instruction.
Yes, yes, my lord. Before I could secure instructions, my lord, it was.
Lord, one more, one judgment, my lord, one judgment, my lord, I would like to rely upon.
Sir, you challenge the order. The complaint, the contempt petition arises out of writ petition number 202-889 of 2022, wherein directions were issued by the learned single judge to response number 1, 3 and 4 to consider the representations given by the petitioner herein and pass necessary orders within a period of 90 days from the date of receipt of a certified copy of the order. Full stop. Next para. Compliance affidavit has been filed at the hands of
Respondent. Respond number 3.
the Govind Reddy, respond number 3 herein, stating that an endorsement was in fact issued on 2/9/2022 itself And therefore, a copy of the endorsement dated 2/9/2022 is once again sent to the petitioner here. Full stop. Next para. Learned counsel for the complainant submits that if endorsement was issued on 2/9/2022, the same submission should have been made before the learned single judge. Full stop. However, learned counsel for the respondents points out that the matter was disposed of on the same day when the matter had come up for preliminary hearing, while directing the learned counsel on the panel to take notice for the respondents. Full stop. Therefore, no information was available at the hands of the learned counsel who appeared for the respondent before the learned single judge regarding the endorsement already issued by the competent authority. Full stop. Next para. We are satisfied with the explanation offered. Full stop. Further, since endorsement has already been issued by the competent authority in respect of the representations given by the petitioner, nothing further survives for consideration in this contempt petition. Full stop. It is also made clear that the petitioner is at liberty to challenge the endorsement dated 2/9/2022. Full stop. The contempt petition is accordingly closed.
Scale number 17, Ravi B. Patil.
Of maintainability, my lord, my friend has read objection on the other day, order 21 rule 58. May I take lordship to order 21 rule 58 for a.
Yes.
Adjudication of claims to
Order 21.
rule 58.
Yes.
Adjudication of claims to or objection to attachment of property.
Yes.
Where any claim is preferred to or any objection is made to attachment of any property attached in execution of a decree on the ground that such property is not liable to such attachment, the court shall proceed to adjudicate upon the claim or objection in accordance.
Other judgment ಇದೆಯನ್ರಿ
ಹೌದು, ಇದೆ, ಇದೆ.
ಅದು ಕೊಡಿ ಸಾಕು.
ಅದನ್ನ
Why you want to read the provision again?
ಇಲ್ಲ ಇದರಲ್ಲಿ ಡಿಫರೆನ್ಸ್ ಮಾಡ್ಬೋದು ಅಷ್ಟೇ. I just wanted to make out what is the relevancy of rule 4 and subclause 4 and subclause 5. That is the.
What
for that-
if it is decided, we'll consider that. What
ಇದು may. ಒಂದ್ ನಿಮಿಷ ಇದನ್ನ I would like to refer to the provision.
ಅದನ್ನೇ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಜಡ್ಜ್ಮೆಂಟ್ ಬರ್ತಿದ್ರೆ we will go through that one, sir.
Where the matter was under reference from the division bench. The question was the para 1. Whether against an order passed under order 21 rule 58 of the code in respect of claim or objection to the attachment of.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
Para 1 now.
Para
1.
Whether
against an order passed under order 21 rule 58 of the code in respect of a claim or objection to attachment of property, a regular appeal would lie as an appeal against the decree or a miscellaneous appeal against the order.
Yes.
There the reference was whether since there was a difference of two benches of division bench.
Yes.
May I take lordship directly to the discussion from para 11 or 11 onwards.
Please come to paragraph number 30.
3-0. Yes. To appreciate as to whether the view taken by the division bench in Nukraju case confirming the mechanism of appeals provided for under CPC, it is necessary to refer to the relevant provisions. CPC provides for two kinds of appeals from the adjudication undertaken by the court of a original jurisdiction, namely appeals against the decree and appeals against the orders. The former are provided for under section 96 and the later under section 104. Though the provisions are familiar, it is necessary. Then my lord, 31. These two substantive provisions are supplemented by order 41 and 43 for schedule 1 of CPC. Section 96 gets attracted only in such cases where the subject matter of the appeal is decree. On the other hand, section 104 provides for appeals against the orders. Section 2 subclause 4 defines an order as formal expression of any decision of a civil court, which is not a decree. Every order is not appealable. It is only such order which fit into the various clauses of section 104 and order 43 rule 1 that are appealable. Once it emerges that an order passed under rule 58 of order 41, order 21 is conferred, the status of a decree in the particular context of appeal, section 96 gets attracted. Section 96 does not enumerate the type of decree that can fall into its fold. Once the outcome of adjudication partakes the character of a decree, it gains an entry into the realm of section 96. The contention of the learned counsel for the petitioner that the appeals provided for under section 96 are against the original decrees and not other kind of decrees is unacceptable. The word original in the heading of the section 96 signifies the jurisdiction, that is original jurisdiction in contradiction to appellate jurisdiction. Section 104 on the other hand is neither general nor residuary in nature. It is only those orders which answer the description contained in its clauses that are appealable under it. Section 104 as it stands now provides for appeal against 5 categories of orders. There is no dispute that an order under rule 58 does not fall into clause FF, FFA, G and H, and effort can certainly be made to bring it within the purview of clause 1 of subsection 1. Since
there is the discussion regarding sub-rule 5.
Sub-rule 5
4 and 5 is what we are concerned with now. Yes.
How? That
And
is
there is a specific
that-
provision
yes, ma'am.
saying no appeal will lie. And for that you will have to file a suit.
That is what also
But
whether
where
suit
that
can
is concerned.
my lord 5 anta specific agi helilla, it is relating to 4 itself. My lord, the difference is 5 my lord may take my lord the provision of the act itself. There my lord the difference itself is made by under the provision itself.
Yes.
My lord 58 where proviso may I request.
Yes.
Proviso provided that no such claim or objection shall be entertained where before the claim is preferred or objection is made, the property attached has already been sold. Where court consider that the claim or objection was designedly or unnecessarily delayed. There are 2 proviso where my lord this provision, how now may take lordship
that does not come into the picture.
how now subclause 5 may request.
Yes.
Where a claim or objection is preferred and the court under the proviso to sub-rule 1 refuses to entertain it, the party against whom such order is made may institute a suit
Where
to
before
establish.
the claim is preferred or objection is made, the property attached has already been sold.
How?
So only in those circumstances.
Only in those circumstances, subclause 5 will apply. All other orders my lord, under my lord, subclause 3. Clause 3 provides my lord, upon the determination and question referred to in subsection sub-rule 2, the court shall in accordance with such determination allow the claim or objection of the release of the property from the attachment either wholly or extent to it thinks fit, disallow the claim or objection. Here my lord, it is disallowed. Continue the attachment.
Which provision do you get that the determination
Yes.
will amount to a decree?
Subclause 4.
Yes. Where do you?
Where any
Ah.
claim, where any
As if
claim,
it, as if it were a decree.
yes.
Yes.
The distinction between, my lord, sub-rule 4 and 5 is, my lord, 4 is a situation where, my lord, the objections are allowed. 5 is a provision.
5 pertains only to clause 1 of the proviso.
Yes, clause 1 provides two things. The proviso provides.
Clause 1 is only when the property has already been sold
No, there are two.
before attachment.
Yes, ma'am. That is what.
Second one does not come into the picture. It is only in respect of clause 1 of the proviso.
Allala, my lord, I'll
Please
read.
read it.
Yes, my lord.
Yes.
Where the claim or an objection is preferred, I'm reading, my lord, sub-rule 5, preferred and the court under proviso to sub-rule 1, not, my lord, proviso 1. It is proviso to sub-rule 1. Proviso has two parts. One is, my lord, attachment. The B is,
So
my lord.
both the.
Yes, my lord. So objection, if it is rejected, my lord, prima facie without adjudication,
where
saying
the
that, my
court
lord,
considers that the claim or objection was designed
or
or
unnecessarily
unnecessarily
delayed. Andre, it doesn't entertain the objections, my lord, saying that, my lord, without adjudication, my lord, it closes that objections or rejects that objections. Then, my lord, it will fall under proviso to sub-rule 1. Then, my lord, 5 will come into play.
Yes.
My lord, if there is adjudication and a positive order is made, allowing the objections, that amounts to a decree. The decree holder in the execution proceedings will have to, my lord, file an appeal.
Yes.
Your lordship,
See
the order.
Allowing anta alla, 3 subclause B may be called, 3 subclause B. Whether it allows or disallows.
Correct.
Disallow the claim or objection.
But
Here, my case is
not in terms of the proviso.
not in terms of the.
Correct. So we'll have to see what is the order. Which is the order?
Starts from page number 20. The point, my lord, is formulated at page number 26. There is a point, my lord, for consideration, page number 26.
ಆ 2 ಪಾಯಿಂಟ್ ಬರೋದಿಲ್ಲ
ಬರೋದಿಲ್ಲ. Therefore, it is appeal.
2 ಪಾಯಿಂಟ್ ಬರೋದಿಲ್ಲ. So therefore,
it is only appeal, my lord.
No, it goes against you.
No, my lord.
Clause 4, rule 4 will come into the picture.
That is the reason I am in appeal, my lord.
Huh?
That is the reason I am in appeal.
No, you cannot prefer an appeal.
Rule 4 says it is only by way of appeal, since it amounts to a decree.
Please read this.
Please. Rule 4. Where any claim or objection has been adjudicated upon under this rule, the order made thereon shall have the same force and be subject to the same condition as to appeal or otherwise.
Yes.
Here, my lord, the court below has formulated.
Now let us see the order.
Point, my lord, at page number 26. Point. This petition was filed for recovery of an amount of and so. So and so, based on the award passed by the Deputy Registrar of Chit at Raichur in its dispute numbers 47 of 2018-19. As per award dated 27/2021, during the dependency of the EP, the JDR number 1 remained absent. The rest appeared through counsel, JDR number 2, 3, and 6, who are guarantors. The chit defaulter is JDR number 1. The JDR number 5 is the daughter of JDR number 1. JDR number 4 is the son-in-law of JDR number 1. The Deputy Registrar of Cooperative Society, Raichur, passed the award directing JDR to pay the chit due amount along with the interest and also attach some immovable properties of JDR number 1. After that,
just to save the time, paragraph 16, Lord, page 11.
It is also found in the operative portion. Last but one paragraph. On going through the order,
Not bona fide.
the third party are not bona fide litigants, only to stall the auction proceedings at the behest of JDR number 1. IA number 7 was filed, and this application is also filed. Therefore, there is no merit in the application.
it is on due adjudication of my claim. The application is rejected
But
on merits.
It is very clear
That could not have been
that the
done.
application is considered as not a bona fide one. It is only designed
That,
to help the judgment debtor.
that is the view of the court, my lord, based on the material which they are
Correct.
relying upon.
So therefore, that is why we are saying we'll have to consider what is there in the order.
Yes, my lord,
Yes.
the
So
court has made an,
itself has made it very clear. No, it is being dismissed on this ground. Then rule 5 will get attracted.
no, my lord, definitely not, because my lord, the court, while coming to such conclusion,
Yes.
if the court has, my lord, looked into, my lord, the proviso sub A and B, my lord, on 2 points, if property is already sold or if it is delayed, then only
Designed.
designed or delayed,
Correct.
designed or delayed.
ಅದನ್ನ ಅವರೇ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳ್ಬಿಟ್ಟಿದಾರಲ್ಲ ಈಗ.
ಇಲ್ಲ, ಅದನ್ನ after appreciating the materials which are been on record,
It is
those
said
records are
it is
taken
not
into
a bona fide
consideration.
application. These are not bona fide litigants. They are doing it only to help the judgment debtor number 1.
That
And
finding
therefore,
itself,
on
I
that
am,
ground it is rejected.
my lord, that cannot be the basis, my lord, for rejection of an application
Second
under order 21 rule 58.
Second one,
Second
the
one, my lord,
court itself is saying so.
order 21 rule 58.
You
my lord,
cannot say something which is not specifically stated by the learned judge.
my lord, that finding is after, my lord, looking into the documents, not that, my lord, my application is been taken into consideration and on the basis of the application, it has been found by the authority, by the court below. The court below refers to all the records which are being produced by the respondents. If that is so, my lord, there should have been an adjudication. They cannot simply take out, my lord, the documents which are being filed along with the objection,
Yes.
and then, my lord, adjudicate on that point and then come to this conclusion. If that conclusion is purely based on, my lord, where the court and consider the claim or objection was designedly or unnecessarily delayed.
Correct.
Paragraph 16.
Designedly anta barbekadre,
Paragraph
my
number
application at
16 also, my lord, they clearly state that, my lord, it is only with an intention to stall the proceedings.
illa, that is based on
Page
what?
11.
That is based on the material which has been produced by the respondent.
Internal
When
page 11 of-
respondent is been given such opportunity to produce records and then rely upon those records without adjudication of on those, my lord, records, I should be given an opportunity whether there was a partition in the family or not. How the court come to a conclusion that there is already a partition, therefore these revenue records, my lord, merely looking into revenue records, how the court say there is already a partition. That is a clear finding on, my lord, based on the records.
I am reading paragraph number 9. The reasoning starts in paragraph number 8. Paragraph number 8 of the order. Yes. Yes. It's only regarding the directions issued by this court and why you were directed to give the check. Yes. All those are contained in paragraph number 9. Yes.
Paragraph 16 would be relevant.
Yeah, 16 is the finding, my lord, on records.
Blood, he is blood blowing
Sorry.
hot and cold. If it is his case that there is
The
adjudication,
first, my
my
lord,
lord,
prima facie, he
Cost-
should have a locus to file such application. And, my lord, even we will assure, my lord, by giving a check in favor of, my lord, the decree holder. We will also say, my lord, we will deposit the money after, my lord, 1 month. And we will proceed against the properties of, my lord, very same decree holder number 2 also. That cannot be, my lord, a ground.
The application was filed by you.
Yes.
As a third party.
Yes.
Correct. Yes, it clearly falls under.
Melod,
rule
make
15.
one more point, Melod. One more point I missed out, Melod, along with Melod, the memo for production of additional.
Therefore, Rule 5 will come to operation. The claim is not fully decided by the court. It has rejected the application filed by these people on the ground that you are only filing this application to help the judgment debtor. Judgment debtor number 1 is their relative.
Brother.
Brother. Without adjudication. Adhe, what can I? To provisorally, clause 2 gets attracted. The application has been dismissed only on that ground. There is no need for going for full inquiry. You please read clause 2 of the proviso.
Proviso.
It need not adjudicate. In rule 1 of order 58. Sorry, this rule 58, clause 1.
B, my lord, proviso B.
Yes. Where any claim is preferred to or any objection is made to the attachment of any property attached in execution of a decree on the ground that such property is not liable to such attachment, the court may proceed to adjudicate upon the claim or objection in accordance with the provisions herein contained, provided that no such claim or objection shall be entertained. It is not entertained at all. No question of going and
They have
conducting
not gone
or
to this stage.
adjudication.
They have not gone to the stage of adjudication.
Yes.
My specific contention, my lord, that my lord, para 13, analysis and findings. The court has gone into, my lord, the records,
Prima
even the
facie-
finding.
Prima facie, it has to see the documents, sir. You can't say, no, don't even look into the documents and we will dismiss the application.
But
only
this
on-
finding, if
ಹಂಗಲ್ಲ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
for a sake of convenience, this finding in para number 13, my lord, if taken in entirety, my lord, now, my lord, if keeping aside this order, if I file a suit for partition in my family, this finding made in para 13 will definitely affect my claim itself.
No.
Because, my lord, the
It
court
is
has
not
given a
an
finding.
adjudication.
My lord,
It is not an adjudication.
It is an
Not
adjudication.
an
The court-
adjudication, no evidence is recorded.
Manoj,
It
that
is dismissed. Your application is rejected. It is not entertained
Manoj, the
in
court has,
terms of the proviso.
the court has,
Clause-
for a
Clause
sake of,
2 of the proviso,
for a sake of
it
convenience,
is rejected.
for the sake of convenience, I
Yes.
may permit
But
it to
his
read 30,
apparent-
Manoj.
His
30
apparent,
Manoj, but the decree holder number 2 files a number of ROR present and old also mutations, which indicate that several of joint family in the year 1993-94, as the revenue records, panchayat records and corporation records indicate the same. The learned counsel for the third parties argue that the entries in the revenue records are illegal entries. Till today, no division is taken place among third parties and just JDR. The court holds the individual ROR in respect of each children deceased Veerappa way back in the year 2003 and earlier to it indicates the disruption of a joint family. This is a finding which has been given by the court. Not only attached property, some other properties are also got divided among the parties and separation of properties between the family
How
members.
does
But third
How
parties,
does adjudication happen?
Manoj, that is,
The recording of evidence.
yes, Manoj, that is what I am saying, Manoj.
No,
This,
no evidence is recorded. Your application has been rejected only on the ground that it cannot be entertained, that because you are not bona fide persons who have a legitimate claim over the property. You have filed the application only to help the judgment debtor. That is the opinion.
Manoj, that
adjudication
opinion
is made.
expresses, Manoj, though Manoj expressed in that fashion, Manoj, but ultimately there is one more point, Manoj, I have missed out, Manoj. Memo, Manoj, along with the additional document which I have produced, page number 19 maybe.
All this cannot be gone into now.
How, I'll
You
take
will
one,
have to file a suit to get a
I'll take
declaration.
only 1 minute, I'll take only 1 minute of the court. Along with the memo, I have produced the entire order sheet, may take lordship to Manoj, the page number 19 of the order sheet. The order is passed on, Manoj, this order,
You know,
the order, Manoj, passed on IR number 20.
additional document.
ಹೌದು ಮೆಮೊ along with additional document ಹಾಕಿ ಅದರಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿದ್ದೀನಿ. Manoj, this order on IA is on 9/8/2024. Manoj, may take lordship to Manoj the order sheet dated 12/7/24, which is at page number 19. Manoj, fifth paragraph, the third paragraph. On perusing the order of WP dated 24/6/2024, the High Court of Karnataka directed the decree holder not to encash the check handed over by JDR number 2 for a period of 1 month from today. 1 month expires on 23/7/2024. It means as on today, decree amount, EP amount is not satisfied. Court directed to either to pay EP amount or offer security to set at liberty. But the JDR number 3 kept mum. But counsel submits set him at liberty till tomorrow. He would offer security, but court does not have any hope. The property seeks time, so and so. Then, Manoj, this is done on, Manoj, the court is aware about this, Manoj, the conduct of, Manoj, the JDR number 2, who, Manoj, himself, Manoj, transposed as a JDR number 2, as on 12/7/24 itself. That, Manoj, such an application at the, Manoj, therefore, Manoj, the application for attachment of this property at the instance of this person itself is illegal.
No, I'm not.
When
judgment
court,
debtor
Manoj,
free.
wants to, Manoj, hold an attachment, first it should be satisfied whether the person who is filing an application before the court is a decree holder in entire. When he himself has failed to deposit that amount itself, which has been assured before this honorable court, not that, Manoj, some private transaction where, Manoj, he has given some assurance. Before this court, Manoj, he has given a check and then he got himself transposed. This is virtually amounts to, Manoj, misguiding the court. Even this court also, by securing an order, favorable order, now he wants to proceed against the property of, Manoj, the one of the parties. Therefore, Manoj, such application being entertained by, Manoj, the execution court was rightly objected. And this objection raised by, Manoj, these appellants could not have been rejected on these points, which those documents are never been a part of record. It is only the objection raised by this person. If an objection was raised by, Manoj, the real decree holder.
For you to file a suit, get an order of temporary injunction,
Now this
cannot do it,
finding will come in
sir,
my
in
way.
the execution petition, no, sir.
Now this finding of my lord, the court will come in my way, even to file a suit for partition or to claim this.
Provision itself says you can file a suit.
Yes, my lord, it will,
This
he will come up with this order saying that my lord, already court has given a,
this is not a decree, sir.
how do, other this finding my lord will come in my.
No, it is not a finding on adjudication.
My lord,
There
that
is no
could-
adjudication.
that may be
But
clarified, that may be clarified, my lord.
Alright.
This finding on,
No
my lord,
difficulty. no
finding at para 13,
Absolutely
that should not come in my way, my lord.
Yes,
May I, my lord?
yes.
Lord, his apprehensions are met, my lord, in sub-rule 5 itself. Sub-rule 5 says any rejection is, my lord, subject to the result of the suit. It is conclusive only subject to the result of the suit.
Yes.
So, my lord, all these findings are subject to the result of the suit. They
Yes.
can, my lord, very well maintain that. Pleasure. So far as the answer to the judgment which he has quoted, my lord, that was a case where, my lord, the objections were allowed. Or in judgment, that was a case where objections were allowed and, my lord, auction was set aside. So, my lord, there, that amounts to a decree. Here, my lord, rejection of objection, not that.
There allows or rejects, it's.
So the matters coming up for orders. What about this respond number 9?
But there was also direction to, my lord,
Who is this respond number 9?
my lord, they were not represented even before the execution.
Anyway,
court.
he's not a contesting respond.
No, man. 3 and 9.
On your application, this is the
He-
person
he-
who has contested the matter. ಏನ್ ಹೇಳಿದೆ? For orders, comma, with the consent of the learned counsels on both the sides, the matter is taken up for final disposal. Stop. Respond number 9. Is not served with the notice. Stop. However, the learned counsels on both the sides admit that respond number 9 is not the contesting party in the matter and no relief is claimed against respond number 9 in this appeal. Stop. Next para. The appellants herein filed an application in IA number 1 in execution petition number 546 of 2021 before the learned first additional senior civil judge at Kalaburagi, comma, under order 21, rule 58, 69 and 97 of CPC. Stop. The appellants are aggrieved of the impugned order passed by the executing court rejecting the application. Full stop. Next para. A brief background of the matter is that respond number 1, Messrs. Margadarshi Chits Private Limited
Leave of the court. More matter in that.
Huh? Yes,
Leave of the
yes,
court.
yes. File the execution petition. To execute where do you get that information?
The last third page, order, execute, my lord, the order dated 12/2/2021.
Where do you get that?
Lord, last second page, my lord, the pages are not paginated. Last second page, my lord, in the Kannada order, my lord, in Vyajya Sankhya 47 of 1819. May I pass it on, my lord?
To execute the award passed
Passed under section 71 of Chit Fund Acts, my lord, by the registrar of chits at Raichur.
the deputy registrar of chits at Raichur. Passed under section 71 of the Chit Funds Act, 1982. Full stop. Respondent number 2 is the original borrower. Yaru borrowers?
Principal borrower is, my lord, respondent number, my lord, respondent number.
Respondent number 2, Chandrasekhar.
No, I'm, my lord, respondent 3 is the principal borrower. Respondent 3 in the present appeal.
It's a trading company.
Yes, my lord, by the proprietor Sharanappa.
Respondent number 3, Tagdake, previous sentence. Respondent number 3, Messrs. Sri Guru Channavira Trading Company,
By its proprietor Sharanappa.
represented by its proprietor. And respondent number 4, Sri T. Chandrasekhar, was the borrower.
No, only 3 was the principal. He was the borrower. All others, my lord, are guarantors.
Proprietor ಆದ್ರಿಂದ respondent number 4 is also a borrower.
Yes, Swami. I'm not connected with either the proprietorship firm or, my lord, the
Who are you?
proprietor. I am the person, I am the guarantor.
Which respondent are you, sir?
Two, my lord, Chandrasekhar.
Huh?
2. Chandrasekhar is 2. He is also arrayed as 4.
Sharanappa is the proprietor.
Sharanappa is the proprietor.
ಏನ್ ಹೇಳಿದೆ? Proprietor Sri Sharanappa VS was the original borrower. And respondent number 2,
5 to 9 are guarantors.
and 5 to 9 are guarantors. Full stop. During the course of the execution petition, respondent number 2, Sri T. Chandrasekhar,
Tendered a check, my lord, for discharge.
ಅದೆಲ್ಲಿ ಅದು ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಆ ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್
ಆ writ petition additional documents ಅಲ್ಲಿ ಹಾಕಿ.
ಅಲ್ಲ ಈ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ,
ಈ order ಅಲ್ಲಿ
that was discussed, where was it? In which paragraph is that?
I'll point it out. Lordships will get it at paragraph 9, my lord, internal page 8 of the
9.
Paragraph 9, internal page 8. Running page will be, my lord, 27, my lord, if I'm not.
ಏನ್ ಹೇಳ್ದೆ? Approached this court in WP number 201449 of 2024. And this court directed that respondent number 2 herein who was till then judgment debtor number 2 to be transposed as decree holder number 2. Yes. Full stop. Respondent number 2 herein had handed over a check for a sum of rupees 27,03,137 towards satisfaction of the outstanding dues. Full stop. Thereafter, respondent number 2 herein sought for attachment of the property in question, namely
Survey
5 acres and 12 guntas in survey number 127/2 of Aramakkal, Kalgi, Hobli, Kalagi, Taluka. Full stop. The executing court appointed special bailiff to execute the court order. Full stop. In the said order, proclamation warrant was issued by attaching the said property which belonged to judgment debtor number 1 and fixed the auction to be conducted at the spot on 29/7/2024. ಏನಿದು ಎರಡು ಡೇಟ್ ಇದೆಯಲ್ಲ 29/7/2024
auction and court
and 9/8/2024 ಏನದು
9/8, my lord, court auction.
ಹಾ
Court auction.
ಸ್ಪಾಟ್
court premises.
In the court.
ಸ್ಪಾಟ್ ಆಕ್ಷನ್ ಬೇರೆ
ಹೌದು,
ಕೋರ್ಟ್
ಹೌದು.
ಆಕ್ಷನ್ ಬೇರೆ.
Spot auction ಆದ್ಮೇಲೆ court ಅಲ್ಲಿ again, my lord, the auction is called for, my lord, to see, my lord, whether there are better, my lord, bidders. Then it will be finalized.
And thereafter court auction to be held on 9/8/2024. Full stop. At that juncture, judgment debtors number 4 and 5 got advanced the case before the executing court on 30/7/2024 and arrest warrant issued against them was recalled in terms of the directions issued by the learned single judge in WP number 201862 of 2024. Full stop. On the same day, the appellants herein filed the instant application claiming that the property in question is a joint family property and they have 1/6 share each in the property in question and all other joint family properties. and therefore raised objections to the application for attachment filed by respondent number 2 herein. Full stop. On consideration of the submissions made on behalf of the applicants for appellants herein and respondent number 2 for judgment data number 2, the impugned order was passed rejecting the application in IA number 1. Full stop. Next para. Learned counsel for respondent number 2 raised a preliminary objection that in view of sub-rule 5 of rule 58 of order 21, this regular first appeal cannot be maintained and the appellants can only file a suit in terms of sub-rule 5. Full stop. Next para. Learned counsel for the appellants contended that having regard to the impugned order, it is clear that there is an adjudication and in terms of sub-rule 4, the impugned order is a decree and therefore a regular first appeal can be maintained. Full stop. In this regard, learned counsel sought to place reliance on a judgment of the full bench of the High Court of Andhra Pradesh in the case of Mr. Gurram Sitaram Reddy versus Ganti Yashoda and another, reported in
AIR 2005, AP 95, equivalent citations. Third line.
AIR
2005. Third line from the top, my lord.
Yeah. AIR 2005, AP 95. Full stop. For contra, learned counsel for respondent number 2 submitted that the application filed by the appellants herein in IA number 1
A number 7.
7. IA number 1.
The operative portion, page 13. Misprint ಆಗಿದೆ interim application order
ಇಲ್ಲಿ ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ IA ನಂಬರ್ 1 ಅಂತ ಹಾಕಿದ್ದಾರೆ.
ಹೌದು ಮಿಸ್ಪ್ರಿಂಟ್ ಆಗಿದೆ. ಕೆಳಗಡೆ ಲೈನ್ ಅಲ್ಲಿ interim application IA ನಂಬರ್ 7 ಅಂತ ಇದೆ. ಅದೇ ಏನು ಮಿಸ್ಪ್ರಿಂಟ್ ಆದಂಗೆ.
ಸೊ IA ನಂಬರ್ ಅಲ್ಲಿ ಎಲ್ಲಾ ಕಡೆ IA ನಂಬರ್ 7 ಅಂತ ಮಾಡ್ಕೊಳ್ಳಿ. IA ನಂಬರ್ 1 ಅಲ್ಲ ಅದು. IA ನಂಬರ್ 7.
ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಅಲ್ಲಿ 7 ಅಂತ ಬಂದಿದೆ.
IA ನಂಬರ್ 7. ಏನ್ ಹೇಳಿದೆ? Has been rejected on the ground that the appellants herein are not bona fide litigants and they have filed the application only to stall the auction proceedings. at the behest of judgment debtor number 1. Full stop. It was therefore pointed out that having regard to the express provision contained in sub-rule 5 of Rule 58 of Order 21, since the executing court has refused to entertain the application in IA number 7, the appellants can only file a suit and they cannot maintain this regular first appeal. Full stop. Next para. Having heard the learned counsels for the appellants, comma, respond number 2, and on perusing the appeal memo, comma, this court is required to consider whether the objections raised at the hands of learned counsel for respond number 2 regarding maintainability of the appeal can be sustained or require it or whether it requires to be rejected, and whether this court is to proceed to consider the appeal on its merits. Full stop. For easy reference, Rule 58 of Order 21 is extracted herein ಅಂತ ಹಾಕೊಂಡು ಪೂರ್ತಿ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ತೀನಿ. Rule 58 of Order 21. Sub-rule 5 clearly mandates that where a claim or an objection is preferred and the court, comma, in terms of sub-rule 1 of the proviso, ಅಲ್ಲ ಇದರಲ್ಲೇ ಇದೆ, ಇದರಲ್ಲೂ ಇದೆ ಫುಲ್ ಪೆಂಚ್ ಹೇಳಿದೆ. Refuses to entertain the application, such party against whom the order of rejection is passed is permitted to institute a suit to establish the right full stop. It is also made clear in the provision itself that subject to the result of such suit, if any, an order so refusing to entertain the claim or objection shall be conclusive. Full stop. On the other hand, sub-rule 4 mandates that where any claim or objection has been adjudicated upon under the said rule, the order made thereon shall have the same force and be subject to the same conditions as to appeal or otherwise, as if it were a decree. Full stop. Next para. In the case of Gurram Sitaram Reddy, bracket Supra, the full bench of the Andhra Pradesh High Court considered whether against an order passed under Order 21, Rule 58 of the court in respect of a claim or objection to the attachment of property, a regular appeal would lie as an appeal against the decree, or a miscellaneous appeal against the order is required to be filed. Full stop. As rightly pointed out by the learned counsel for respond number 2, that was a case where the application filed under Order 21, Rule 58 was adjudicated upon and allowed by the executing court. Full stop. The question therefore was whether on such an order where the application was allowed, whether a regular appeal could be filed or whether miscellaneous appeal was required to be filed in terms of section 96 and section 104 of the code. Full stop. However, a division bench of the High Court of Delhi, in the case of Pradeep Vaid, VAID versus Messrs. Universal Constructions and others, reported in AR 2006, Delhi 4. It was held that if an applicant under Order 21, Rule 58 is aggrieved of the rejection of such application, then the remedy would be to file a separate suit. Full stop. Next para. We are not impressed with the submission of the learned counsel for the appellants that the finding in the impugned order can be held against the appellants if a suit is filed. Full stop. Sub-rule 5 of Rule 58 clearly provides that such observations or findings are conclusive only subject to the result of a suit which can be filed by the appellants. Full stop. It is therefore clear that if a suit is filed by the appellants such suit is to be considered and adjudicated based on the evidence that could be produced or placed before this court, before the court by the parties to the said suit. Full stop. Any observations made in the impugned order which touches upon the merits of the matter shall not in any way influence such suit. Full stop. Next para. We therefore proceed to dismiss the appeal. Previous paragraph, repeat ಮಾಡ್ರಿ ಏನ್ ಹೇಳಿದ ನಾನು previous paragraph. Dismiss the appeal on the ground that this appeal is not maintainable, having regard to the express provisions contained in sub-rule 5 of Rule 58 of Order 21. Full stop. The appellants are free to file a suit challenging, free to file a suit seeking declaration of their rights in respect of the property in question. And if such suit is filed, the said suit shall be considered on its merits, and any finding or observations made in the impugned order shall not influence the court considering such suit. Full stop. Ordered accordingly.
Order 1819, my lord, comply the order of the Supreme Court. There is a direction, Lord, we entered the name of the complaint, Waqf board, my lord, in the RTC. We entered the name of the Waqf board in the RTC, my lord, without notice to him. He prepared the writ petition, my lord. This one single judge directed us to, my lord, restore the name of the complainant, then proceed with the providing the opportunity. Now, my lord, we restore the name of the complainant. Lord, I'll file the affidavit, my lord. You will also pass over this.
Pass over.
Please.
18, 19, my lord, 21, 22 and 23.
21, my lord, you will also private on 28th, my lord.
21 matra.
Yes, ma'am.
So in 18, 19, 20.
20 ಅಲ್ಲ,
20 ಬೇಡ,
20
ಬೇರೆ.
is different.
That is,
Huh?
that is different, my lord. That is different.
ಅಲ್ವಾ?
Correct.
18, 19 ಮತ್ತೆ
22,
22.
23,
21,
24, man.
21 ಇವತ್ತು ಬೇಡ ಅಂತ ಹೇಳ್ತಾರೆ.
Also, man. 28th ಗೆ ಹಾಕ್ತಾರೆ. RTC ಆಗಿಲ್ಲ.
23, 24.
Yes, ma'am. 24.
ಅಲ್ಲ, 24 is different.
23.
24 is different.
24.
Aval 18, 19, 22, 23 pass over.
Please.
Huh?
Please.
Serial number 20.
Yes.
At the request of the learned government advocate, release this matter
On 28th, my lord. Another matter is listed on 28th, my lord.
on 28th of October.
Please.
What about 21?
21 may be urgent, 28, my lord. 20, my lord, I am ready to argue this. 21, 28 ಗೆ ಹಾಕ್ಬೋದು ಸರ್.
21 ಇವಾಗ
ಹೌದು,
ನಾನು ಹೇಳಿದ್ದು.
ಹೌದು ಸರ್.
What about 20?
20, my lord, the affidavit, my lord, regarding
Order.
complaints.
ನಾನು ಹೇಳಿದ್ದು serial number 21 ಅಲ್ಲಿ.
Happy
What about 20?
20,
Well,
my lord, I
you-
filed the affidavit. my
Lord,
lord.
they are not complied. The order is very specific. From the date that the petitioner was entitled for
Now,
the.
serial number 20 ಕೊಡ್ರಿ.
Yes. Take lordships. Operative portion of the order at page 16, my lord. That in view of the matter. that-
Family pension.
Yes. Huh? Yes. The response shall pay interest to the petitioner at the rate of 12% per annum from the date the petitioner became entitled to the family pension. Till the date the same was released to the petitioner. Lord, the entitlement they sanctioned it is from Lord 7/7/98. Family pension is sanctioned from 7/7/98, but they have now given the interest only from 2016 to 19. That is my grievance. And they have calculated the amount also, the, my lord, it is at, the authority, themselves are sanctioned and, my lord, they have so calculated at page, my lord, 39.
So you filed this contempt petition after receiving the amount?
ಇಲ್ಲ 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 ಈಗ ನಿನ್ನೆ ಮೊನ್ನೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
We sent that, my lord, he refused that one, my lord. That is also
ಅಲ್ಲ, ಅಲ್ಲ,
stated in
ಈಗ
the affidavit also.
ಈಗ
Check is
ಕೊಟ್ಟಿದ್ದಾರೆ.
refused, my lord.
40,000 ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ. Now they have given 45,000. Page
Stated in the
40 is the
affidavit.
calculation model. It is by the authorities themselves were calculated. Page 39, Lord. Manager G. This is calculation by the Lord Executive Engineer, KBGNL, Lord, the total amount is 6,49,142. And it was a sanctioned, Lord. They had also returned to the government for the sanction of this amount. Lord, it is at page 50. The director has returned to the government. Page 50, my lord, last para. They for the relief, for sanction of this amount, what they have calculated is 6,49,142. But now they have calculated only from 2016 to 19, 3 years. This is from 98 is to be given. I became entitled for
Can
the.
you see my lord, affidavit, my lord? Annexure R8, my lord. In my affidavit filed on 22/10/2024, my lord. Annexure R8. This is, my lord, directed by the government to calculate the, my lord, interest at the rate of 12%. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಮಲ್ ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಶ್ರೀಮತಿ ಜಯಶ್ರೀ ಇವರಿಗೆ ದಿನಾಂಕ 1/6/2016 ಪಿಂಚಣಿ ಹಾಗೂ ಇತರ ಸೌಲಭ್ಯಗಳನ್ನು ಪಾವತಿ ಮಾಡಿದ ದಿನಾಂಕದವರೆಗೆ ಶೇಕಡ 12 ದರದಲ್ಲಿ ಬಡ್ಡಿಯನ್ನು ಪಾವತಿಸಿದಲ್ಲಿ ತಲುಗುವ ವೆಚ್ಚದ ಮಾಹಿತಿಯನ್ನು ಹಾಗೂ ಉಳಿದ 39 ನೌಕರರು ಅವರ ಕುಟುಂಬದವರಿಗೆ ದಿನಾಂಕ ಸೋ ಪ್ರಕಾರ ತಗಲು ವೆಚ್ಚ ಪ್ರತ್ಯೇಕ ಅನುಬಂಧ ಸಿದ್ಧಪಡಿಸಿ ಕೂಡಲೇ ಸರ್ಕಾರಕ್ಕೆ ಕಳಿಸುವಂತೆ ತಮ್ಮನ್ನು ಕೋರಲು ನೀಡಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ಮೇಲೆ Annexure R9, my lord. This is also directed to us to make the calculation and all. Annexure R11, my lord. Last portion, my lord, page number 27. There is a government order, my lord, when he is entitled. That is government order, I will take your lordship. Page number, that is page number 28, my lord. These all the, not only this.
The direction of the learned single judge.
Yes, when he is entitled.
Shall pay interest to the petitioner at the rate of 12% per annum from the date the petitioner became entitled to the family pension.
Yes, my lord. As per the government order.
They only granted pension from 7/7/98. 7/7/98, they have granted the pension from 7/7/98.
ಹೆಂಗೆ 98 ಇಂದ?
ಇಲ್ಲಿ ಇದೆ ನೋಡು para 4 ನಲ್ಲಿ. Para 4 of the Lord, the order of single judge, page 15. From the date of entitlement. It was granted, pension was granted from 7/7/98. Therefore, this is, he became entitled from 7/7/98.
Family pension of rupees 1,055 per month. This what was granted with effect from 7/7/1998.
So that is the date of
the
Lord,
petitioner died.
yes, entitlement of the family
Up to
pension.
2005 and 1,055 from 7/7/2005 onwards. Till her death, or remarriage, whichever was earlier.
And this order has been, my lord, they filed a writ appeal, it has been confirmed.
ಎರಡು ಸೇಮ್ ಅಮೌಂಟ್ ಇದೆಯಲ್ರಿ 1055 per month was granted with effect from 7/7/98 till 6/7/2005
ಹೌದು, ಎರಡು ಒಂದೇ ಇದೆ.
and 1055 again. What is the difference?
ಅಲ್ಲ, ಎರಡು ಒಂದೇ ಇದೆ, but the my lord, C became, my lord, the husband of the my lord complainant became entitled for the pension from 7/7/98. My request is only, my lord, the interest has to be calculated from this date, and they have calculated and sent for the approval of the government. Now they take different stand. That documents are produced.
Yes, why from 2016?
But kindly see, my lord, Annexure R12, my lord,
Hmm.
government passed the order.
Yes.
This is the Annexure R12, my lord, you lordship get it, my lord, that is page number 29. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ. ಕಾರ್ಯದರ್ಶಿ ಜನಸಂಪನ್ಮೂಲ ಇಲಾಖೆ ಇವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ನಡೆದ ವಿವಾದ ಪರಿಹಾರ ಮಂಡಳಿ ಸಭೆಯಲ್ಲಿ ರಿಟ್ ಅಪೀಲ್ ಸೋ ವಜಾಗೊಳಿಸಿ ತೀರ್ಪನ್ನು ವಿರುದ್ಧ ಮಾನ್ಯ ಮೇಲೆ ಸೂಕ್ತವಲ್ಲವೆಂದು ತೀರ್ಮಾನ ಕೈಗೊಳ್ಳಲಾಯಿತು. ಅದರಂತೆ ಸದರಿ ಸಭಾ ನಡುವಳಿ ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ನಿರ್ದೇಶಕರ ಕಾಡಾ ನಿರ್ದೇಶಕರಿಗೆ ನಿರ್ದೇಶನ ನೀಡಲಾಗಿದೆ. ಈ ಹಂತದಲ್ಲಿ ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 7ರಲ್ಲಿ ಶ್ರೀಮತಿ ಜಯಶ್ರೀ ಇವರಿಗೆ ತಡವಾಗಿ ಪಾವತಿಸಿದ ಪಿಂಚಣಿ ಮತ್ತು ಇತರ ಸೌಲಭ್ಯಗಳ ಮೇಲೆ ಬಡ್ಡಿ ನೀಡುವಂತೆ ಕೋರಿ ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಪೀಠ ಇಲ್ಲಿ ದಾಖಲಿಸಿದ ಸೋನ್ಸೋ ನಂಬರ್ ದಿನಾಂಕ 1/10/2021 ಆದೇಶವನ್ನು ಈವರೆಗೂ ಪಾಲನೆ ಮಾಡಿಲ್ಲವೆಂದು ಸದರಿಯವರು ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಪೀಠದಲ್ಲಿ ನ್ಯಾಯಾಂಗ ನಿಂದನೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ದಾಖಲಿಸಲಾಗಿದ್ದಾರೆ. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 8ರಲ್ಲಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಆಡಳಿತಾಧಿಕಾರಿ ಕಾಡಾ ಭೀಮರಾಯಗುಡಿಯವರು ಶ್ರೀಮತಿ ಜಯಶ್ರೀ ಇವರು ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಸೋನ್ಸೋ ತೀರ್ಪಿನಂತೆ ಹಾಗೂ ಮಹಾಲೇಪ ದಿನಾಂಕ 17/10/19 ಕುಟುಂಬ ಪಿಂಚಣಿ ಮಂಜೂರಾತಿ ಪ್ರಕಾರ ಬಾಕಿ ಪಾವತಿಸಲಾದ ಮೊತ್ತ ಕ್ರಮಗನುವಾಗಿ ಶ್ರೀಮತಿ ಜಯಶ್ರೀ ಅವರಿಗೆ ನೀಡಬಹುದಾದ 1/6/2016ರಿಂದ ಅಕ್ಟೋಬರ್ 2019ರವರೆಗೆ ಬಡ್ಡಿ ಲೆಕ್ಕಾಚಾರ ಮಾಡಿ ಒಟ್ಟು ಮೊತ್ತ ಸೋನ್ಸೋಗಳನ್ನು ಪಾವತಿ ಮಾಡಲು ಸರ್ಕಾರ ನಿರ್ದೇಶನ ಕೋರಿರ್ತಾರೆ. ಪ್ರಸ್ತಾವನೆ ಕೂಲಂಕಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ಸರ್ಕಾರವು ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಪೀಠ ಇಲ್ಲಿ ದಾಖಲಿಸಿದ ಸೋನ್ಸೋ ದಿನಾಂಕ
unnumbered paragraph in page number 29. ತದನಂತರ ಅಂತ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ ನೋಡಿ.
ತದನಂತರ ವಿಳಂಬವಾಗಿ
ಅದನ್ನ ಸ್ವಲ್ಪ ಸ್ಲೋ ಆಗಿ ಕ್ಲಿಯರ್ ಆಗಿ ಓದಿ.
ಪಿಂಚಣಿ ಪಾವತಿಸಲಾದ
The reason why they are saying it can be given only from 2016. ಓದಿ.
ತದನಂತರ ವಿಳಂಬವಾಗಿ ಪಾವತಿಸಲಾದ ಪಿಂಚಣಿ ಮತ್ತು ಮತ್ತಿತರ ಸೌಲಭ್ಯಗಳ ಮೇಲೆ ಬಡ್ಡಿ ಪಾವತಿಸುವ ಸಂಬಂಧ ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 5ರ ಟಿಪ್ಪಣಿಯಲ್ಲಿ ಆರ್ಥಿಕ ಇಲಾಖೆಯು ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ 13/9/94 ಅನ್ವಯ ರಾಜ್ಯ ಸರ್ಕಾರಿ ನೌಕರರಿಗೆ ಮಾತ್ರ ವಿಳಂಬವಾಗಿ ಪಾವತಿಸಲಾದ ನಿವೃತ್ತಿ ಸೌಲಭ್ಯಗಳಿಗೆ ಬಡ್ಡಿಯನ್ನು ಪಾವತಿಸಲು ಅವಕಾಶ ಕಲ್ಪಿಸಲಾಗಿರುತ್ತದೆ. ಸದರಿ ನೌಕರರು ಕಾಡಾ ಅಚ್ಚುಕಟ್ಟು ಪ್ರದೇಶ ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದ ನೌಕರಿಯರಾಗಿದ್ದು ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ 1/6/2016ರಲ್ಲಿನ ನೌಕರರ ಪಿಂಚಣಿ ಕುಟುಂಬ ಪಿಂಚಣಿಯನ್ನು ಪಾವತಿಸಲು ಆದೇಶಿರುವ ಹಿನ್ನೆಲೆಯಿಂದಾಗಿ ನಿವೃತ್ತಿ ಸೌಲಭ್ಯಗಳನ್ನು ಅರ್ಹರಾಗಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ
prior to that there was no provision for pension. You are not a government servant.
ಅಲ್ಲ, ಗೌರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್ ಅಂತ they have adopted KCS. I understand.
It was adopted from 2016 and therefore you are entitled only from 2016.
ಇಲ್ಲ,
That is the
ಅವಾಗ this was, my lord, earlier to that also, my lord, they in the rule itself, not in the CADA rules itself, my lord, they have adopted the KCSR. They have adopted the KCSR. It is only from that date that they have granted. It was gone to the court and many went to Supreme Court and confirmed that they are entitled.
There is any judgment in that regard, you please show.
Now
they are of this opinion that since you are an employee of the CADA,
yes,
and your entitlement happened only from the year from 1/6/2016.
Yes.
Therefore, you are entitled for
what my lord is saying
only
that
from that date is the opinion.
That my lord, what my lord is saying that they were not the government servant prior to that. No, my lord. In the CADA rules itself.
That is the opinion, sir.
ಇಲ್ಲ
That is the reasoning why they are saying you are entitled for interest only from 1/6/2006.
No,
This is
no.
the reasoning.
ಇಲ್ಲ ಅವ್ರು ಕೊಟ್ಟಿದಾರ, ದಿಸ್ ಇಸ್ ಇನ್ಕರೆಕ್ಟ್ because the CADA itself in its rules have adopted the KCS in the beginning. ಅಲ್ಲಿ make it available, sir. The rules itself is there. They have adopted the KCS, sir.
Yes.
They are the government servants. That has been confirmed by the Supreme Court. There were also the other litigations with respect to other employees.
Perfect.
Next week, Lord, I will produce.
Although the respondents contend that they have complied with the directions issued by the learned single judge, and this matter was only regarding payment of interest.
Yes, interest. ಅಷ್ಟೇ ಬೇರೆ ಏನು.
ಏನ್ ಹೇಳಿದೆ? And have accordingly paid the interest on the family pension at the rate of 12% per annum. Nevertheless, the complainant contends that such interest is paid only from 1/6/2016 and not from 7/7/1998, as in paragraph number 4 of the order passed by the learned single judge. Full stop. Next para. Learned government advocate has taken this court through the government order dated 15/10/2024 at annexure R12 filed along with the complaints affidavit and submits that the finance department is of the opinion that since the husband of the petitioner herein was not a government employee and the employee of the CADA became entitled for pension and interest thereon only in terms of the government order dated 1/6/2016, accordingly, the interest has been paid to the petitioner. Full stop. Next para. Learned counsel for the complainant seeks for a short accommodation to secure instructions and make submissions. Full stop. Release this matter. Yavaga?
After 2 weeks.
On 6th of November.
Lord, apart from that, my lord, the same contention was taken in the writ appeal. They had filed a writ appeal challenging that out of single judge.
ತೋರ್ಸಿ ಅದನ್ನೇ ತೋರ್ಸಿ.
ಅದು ಇದೆ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ they have dismissed it at page 53 have produced. But ಇದರಲ್ಲಿ ಅದು ಬಂದಿಲ್ಲ, but they had challenged that order only on that ground.
ಅಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ಡಿಸ್ಕಷನ್ ಆಗಿದೆ ತೋರ್ಸಿ.
ಇಲ್ಲ, ಡಿಸ್ಕಷನ್ ಆಗಿಲ್ಲ ಅದು.
ಮತ್ತೆ
retired benefit, this is the various, my lord, the referring to the Supreme Court judgment, it has been held that. And my lord,
paragraph number 5 nodi. Learned government advocate submits that the petitioner is not entitled for interest for the delayed period as per the government order dated 13/9/1994. He submits that the learned single judge committed an error in granting interest. ಇಲ್ಲ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಯಾವುದು ಕ್ಯಾನ್ವಾಸ್ ಆಗಿ ಅದು ಡಿಸ್ಕಷನ್ ಅಲ್ಲಿ ಬಂದಿದ್ದಿದ್ರೆ
ಇಲ್ಲ ಬಂದಿಲ್ಲ ಇದರಲ್ಲಿ
have accepted.
ಡೀಟೇಲ್ ಅದು.
ಅಲ್ಲ ಇದು ಜನರಲ್ ಆಯ್ತು. ಬಟ್ ಇಲ್ಲಿ ಸಿನ್ಸ್ ಇದನ್ನ contention is that these were not government employees, they were employees of the CADA, and they became entitled only in terms of the government order dated 1/6/2016. That is the contention.
No, that is
ಆಯ್ತು.
because in the in the CADA rules itself in the beginning, my lord, it has been adopted KCSR. Therefore, they are government employees. They have adopted it in the beginning.
Serial number 20, my lord, I received the affidavit, my lord. I maybe, this is complied the order of the learned single judge.
Huh?
Which is passed over, my lord, that is previous matter, my lord. We received the affidavit, my lord, now.
18,
18, sorry.
18, 19.
Yes, my lord, all cases complied. Copy is also given to him. His name is restored, my lord.
Is making submissions court and I cannot comply.
Restored, this is the, I given the copy also.
ಕೊಟ್ಟಿದ್ದಾರಾ?
Name is this,
ಕೊಟ್ಟಿದ್ದಾರೆ sir. Now they have.
his name is restored in the records of.
RTC.
ಆಯ್ತು.
RTC. Yes.
How?
Copy of the RTC also is
Yes, Annexure R6.
furnished. Yes. Huh? Yes. So serial number 18.
In that, my lord, I will take notice for R2 also, my lord.
Learned government advocate takes notice for respond number 2 also. Next para. Learned government advocate has filed an affidavit along with enclosures. It's that the respondents have complied with the directions issued by the learned single judge in WP number 207385 of 2017. Full stop. Attention of this court is drawn to annexure R6 filed along with the affidavit, which is the record of rights, where name of the petitioner or complainant has been incorporated in column number 9 as the owner and khatedar. Stop. Next para. Learned counsel for the petitioner complainant submits that the respondents have complied with the directions issued by the learned single judge. Stop. Next para. Accordingly, the contempt petition is closed. Same order,
Next is, my lord, annexure R2 is the RTC. my lord. Only annexure is changed.
19 ali annexure
Order 90, annexure R2.
R2.
Yes. Next idರಲ್ಲಿ
22
22 idರಲ್ಲಿ annexure R5, my lord.
annexure R5.
Yes.
23
23, my lord, annexure R2, my lord.
R2.
Yes.
Yes.
23 could
No, 24, my lord, this is the
Annexure R2.
arrears of salary, my lord, during the period that they are working as a temporary, there are direction to.
In serial number 24, my lords, I will undertake to file wakalat on behalf of the accused. 2 weeks time, my lords.
ಯಾವ respondent?
TMC, my lords. Chief officer of
Number
TMC.
2,
Chief officer. Respond number 2.
2.
Yes.
Learned counsel Sri,
BV Jalde.
you know,
BV Jalde.
undertakes to
File wakalat.
file wakalat for respond number 2. A week's time is granted.
2
to
weeks,
do the,
2 weeks.
2 weeks is granted to do the needful. ಯಾರು ಮಾಡ್ಬೇಕಾಗಿರೋದು ಕಂಪ್ಲೇಂಟ್ಸ್?
ಅವರೇ respond number 2.
ಅವರೇ ಚೀಫ್ ಆಫೀಸರ್. At the same time, full stop, at the same time, learned counsel is also directed to secure instructions as to whether there is compliance of the orders passed by the learned single judge.
Yes.
Yes. Release this matter. On 7th of November.
CL number 25, Mahesh Patil.
Lord, appearing for the petition. Lord,
I appear for the R4 months.
my lord, I have challenged my lord the order of the Karnataka State Administrative Tribunal. Wherein my lord, it was a case of my lord premature transfer. Initially, my lord, there was an interim order before the tribunal, my lord, and thereafter, my lord, my application, my lord, was dismissed. And my lord, the present my lord, petition, my lord, initially there was my lord, interim order. Thereafter, my lord, it came to be vacated. My lord, here, my lord, I was my lord, initially transferred, my lord, page my lord, 20, page 20 of the petition, my lord, annexure A1. Initially transferred, my lord, from awaiting posting, my lord, to Bhimrayan Gudi in a vacant post. KBGNL Bhimrayan Gudi. My lord, serial number 3, page 20, my lord, in page 20. I, my lord, took charge, my lord, CTC, my lord, on 17/6/2022, annexure A2, my lord, 17/6/2022. My lord, it is 2 years, my lord, for an, my lord, the group A. My lord, since it was a case of premature transfer, and my lord, even my lord, the fourth respondent, my lord, he is also, my lord, both my lord, the fourth respondent and my lord, myself, my lord, both are working under Rule 32 of KCSR.
What is
And
the
more,
minimum period of stay?
my lord, 2 years, my lord. 2 years.
Huh?
2 years, my lord. 2 years. 2 years, my lord.
2 years.
Yes, my lord. 2 years.
ಆಯ್ತಲ್ಲ ಇವಾಗ
Yes, my lord. And now 2 years, my
ಮುಗೀತಲ್ಲ
lord.
2 years ಈಗ.
ಆಗಿದೆ. My lord, 2 years ಆಗಿದೆ. My lord, what had happened, my lord, thereafter, my lord, when I filed this petition, initially there was an interim order, my lord, thereafter it came to be vacated, my lord. My lord, here, my lord, this honorable court, my lord.
ಆಯ್ತಲ್ರಿ ಈಗ 17/6/2022 ಇಂದ 2 years ಮುಗೀತಲ್ಲ ಈಗ.
ಆಗಿದೆ, my lord. Now, my lord, thereafter, my lord, I, my lord, requested, my lord, this matter, my lord, was listed nearly for a dozen times, my lord. The government, my lord, were not able to provide me postings, my lord. Every time, my lord, they took time, and my lord, I now am without posting, my lord. They are not able to provide me posting.
Get the instruction in this one.
Huh?
I'll get the instruction, my lord.
My lord, it's been months, my lord. The lordship may kindly see the, my lord, the order sheet, my lord, kindly. On the last occasion, my lord, there was an, my lord, directions, clear directions.
ಏನ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಮತ್ತೆ ಹೇಳಿದ್ದಾರೆ. In the light of the same, respondent state to forthwith pass necessary order of posting of the petitioner, and such posting would be subject to the outcome of the present proceeding.
I will get the information, my lord. WhatsApp
Lord,
tomorrow or Monday, my lord, I will get
My
it.
lord, it's been months, my lord, the taking time, my lord, kindly, and my lord, I am without posting, my lord, and this period has to be.
Government advocate release this matter tomorrow. Please secure instruction.
Please.
Grateful.
Number 26, Arun Kumar Margundappa.
Day before yesterday's matter, my lords.
Yesterday's
Lordship has heard for some time and directed me to supply the copies of judgments to AGA. The issue is, my lord, petitioner who was a police officer, who is police officer conducted an inquiry, conducted an investigation. Yes.
That judgment.
Yes.
Observations in the.
Yes.
Judgment.
Adverse
yes.
remarks by
Yes.
session judge.
Yes. Yes.
Other day, I have also, my lord, submitted 2 sets of judgment.
Kodri.
Idu hing ಮಾಡಿ ಕೊಟ್ಟಿ compile. I have filed it in the counter. Yesterday one.
ಎಲ್ಲ
My lord,
ಒಂದೇ ಸೆಟ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ.
ಇಲ್ಲ ಇದೆಲ್ಲ ನಿನ್ನೆ ಹಾಕಿದೀನಿ, ಅದು ಪುಟ್ ಅಪ್ ಆಗಿಲ್ಲ. Yesterday only I filed.
Uh-huh.
Pass over, matter may be passed over. and-
ಆಯ್ತು ಮಧ್ಯಾಹ್ನ ತರಿಸ್ಬೇಕು ಪಾಸ್ ಓವರ್.
Please.
Please.
Seal number 27, Gita, owner of Sajjan Shetty.
My lords, due to our side, we could not issue the IA, my lords. We may be allowed to issue the IA. And we may be allowed to issue the IA to the trial court advocate, my lords.
Learned counsel for the appellant is hereby directed to furnish copy of IA number 1 of 2024. Along with the appeal memo, so that the same can be served on the respondent along with the court notice.
We may be allowed to issue to the,
Weeks time ಅಂತ ಬಂದಿದ್ಯಾ? Huh?
my lord, we may be allowed to the issue
Within a week from today.
to the trial court advocate, my lord. We may be allowed to issue that to the trial court advocate, my lord.
Full stop. At the same time, the appellant is also permitted to serve copy of the appeal memo along with the IA
Yes.
on the learned counsel representing the respondent before the trial
Trial
court.
court, my lord.
Yes.
Seal number 20, Ratna Shivayogi.
This objection is R9, my lord, is visible and incomplete and whichever the copies furnished before the case AT, I have furnished the same before this court, my lord, therefore kindly accept.
22 and 27.
That is the R9 regarding R9, my lord, which was,
Complete
Produced by
copy
the-
of annexure R9.
yes, ma'am, which was produced by the,
Actual copy of annexure R9.
yes, ma'am,
Same
which was same, my lord, which was produced by the respondent therein, my lord, there are 3 herein also and there also. Therefore, it is unable to kindly accept the same. That is only
Office objection at, office objections are overruled.
I am challenging the order passed by the, I am challenging the order passed by the KCT, my lord, on 2 grounds. One is premature and another one is who has transferred to my place is the lower cadres, he is not entitled for that post, my lord, that is not considered by the KCT. Therefore, filed this writ petition, my lord.
Hmm.
Let me kindly see the A1, my lord, ink page 23. This is
For
the,
the applicant,
yes, my lord, I was,
so before
before the KCT, I am
Ah.
the applicant, my lord.
no interim order is passed.
No, no interim order, the status quo was passed. Since she has not, she has taken charge, therefore, then, my lord, what is the, my lord, kindly see the annexure A1, my lord. That is first transfer order 3723.
Huh?
37/2023. That is it, my name is found in serial number 1. Anil Kumar,
ಮತ್ತು ಸಿ ವೃಂದದ ಅಧಿಕಾರಿ ಸಿಬ್ಬಂದಿಗಳ ವರ್ಗಾವಣೆ
yes, ma'am.
ರದ್ದತಿ
Really, first one, this is the first transfer order, my lord, 37. That Anil Kumar transferred to Karatgi.
ಆ?
The Anil Kumar appellant, prisoner here in my lord, transferred to Karatgi. Then respond 3 herein, transferred to Assistant Director Krishi Maratha Ilake Kalaburagi in her own pay scale. Swanta ವೇತನ ಶ್ರೇಣಿ ಮೇರೆಗೆ.
7/2023.
Yes, my lord, that's A1, ink page 23.
Ah.
Then, my lord, thereafter, my lord, A2,
Your name is at serial number 1.
1, my lord. This one 3 name is found at serial number 3. 2, sorry, 2.
Ah.
Then, my lord, second transfer order A2, my lord, 15/7/24. My name is found at serial number 4 and respond number third name is found at serial number 5.
Same again mutual transfer.
Mutual illa, again, there is no mutual
The
transfer.
same post.
Same, ಬೇರೆ ಪೋಸ್ಟ್ಗೆ ಹೋಗಿದ್ದಾರೆ. ಇದರಲ್ಲಿ ಶ್ರೀಮತಿ ಸೋಯನ್ಸಿ ಅವರು ಸ್ಥಳಕ್ಕೆ ಸಹಾಯಕ ಕೃಷಿ ಮಾರಾಟದಲ್ಲಿ ಕಲಬುರ್ಗಿ ಸೋ ಅಂಡ್ ಸೋ ಇವರ ಸ್ಥಳಕ್ಕೆ ನನ್ನನ್ನು
A2 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ
A2 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಐಟಮ್ ನಂಬರ್ 4 and 5 ಥರ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ 5 ಅವ್ರನ್ನೇ ಶ್ರೀಮತಿ ಸವಿತಾ ಥರ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಟು ಕೃಷಿ ಉತ್ಪನ್ನ ಮಾರುಕಟ್ಟೆ ಸಮಿತಿ ಔರಾದ್.
ಅದೇ ಇವರು
ಇಲ್ಲ ವಯಸ್ಸ ವರ್ಷ ಅಲ್ಲ, ನನ್ ಬೇರೆ ಪ್ಲೇಸ್ ಅವ್ರು ಬೇರೆ ಪ್ಲೇಸಿಗೆ ಕೊಟ್ರು.
No, but you were sent back to Kalaburagi.
Yes, Mala, Kalaburagi.
Ah.
Then my lord, one more order on 30th 7. I have taken charge, my lord, on that same day. And my lord, you ask me kindly see annexure A6. That is my name is found at serial number 7 and respond with third name is at serial number 6.
37.
37, 37. Again, 15/7 is ಮತ್ತೆ again 37. Within 15 days only.
Yenri, what is this? Huh?
Private tomorrow, my lord, I'll get the instruction, my lord.
How is it that you did not succeed before the tribunal?
I have furnished the identical if the lower cadre adunu furnish
The
my
order?
the order, my
What is
lord.
the reasoning?
Reasoning, my lord, they can be posted in lower cadre also, they can posted. Last time kindly see the observations. In the ink page 102, my lord, last inner page 102, ink page 102. Last, in view of the fact that observation. In view of, may I read it? Middle of the then. In view of the fact that this. In view of the fact that this post requires to be kept vacant and somebody required to work on the contest, the third respondent was transferred to the Aurada earlier. She also made a request to the government to consider her case to transfer the nearer place where her husband is working and they also government servant. On considering the same, third respondent is posted to Assistant Director APMC Kalaburagi. From these facts, it's clear that she is no hardship. There is no hardship to cause to anybody. On the other hand, the applicant is interested the highest responsibility regular holder post of special auditor. So and so, third respondent is posted Assistant Director APMC Kalaburagi. Then, my lord, para 12, it being a position, the learned day specifically urged that there is no hardship so and so. The learned council also referred to the various decisions relating to posting of lower cadre persons to higher cadre and so referred cadre rules. There is no quarrel with said proposition to lower cadre person cannot be posted to the higher cadre post. It is also permissible that on certain circumstances, lower cadre person can be posted on own pay scale. The law is very clear on that aspect that posting a person on own pay scale is temporary and that being the person in view of the transfer or posting of applicant as special auditor officer which is cover the Kalaburagi division which is includes 7 districts in the contest to the place of applicant, third respondent posted temporarily. Even you are saying it will indicating that it will be a temporary arrangement. If there is not mentioning it's a temporary, but it indicates that it is temporary. At her request, when the husband is working in, she is not entitled, she is a grade 4 employee. She is not entitled for that post. I have produced that order passed by this honorable court, my lord, annexure. Before the tribunal, my lord, I have produced the.
No, but what is the consideration regarding the transfer policy?
Transfer policy, 2 years is compulsory for A and B. I have produced that transfer guidelines also.
What is the, where is the discussion regarding that?
It's 2 years.
Did not.
I brought to the notice, my lord, that is specific ground only to premature as well as the lower cadre.
ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಿದ್ದಾರೆ? ಏನು ಹೇಳಿಲ್ವಾ?
ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಿ? ಅದ್ರ ಬಗ್ಗೆ ಪ್ರಿಮ್ಯಾಚರ್ ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ಲ.
ಏನ್ರಿ ನೋಡಿದೀರಾ ನೀವು?
Tomorrow will also private. Will also private tomorrow, my lord, I will get it.
In 15 days, if a person can be transferred like this.
That is, my lord.
And nothing is said regarding the premature transfer.
Even though I produce annexure A9, my lord, which is the judgment passed by this honorable court that lower cadre person cannot be posted to the higher.
Madam, why are you insisting on that one now?
Yes.
In 15 days time you are transferred. ಅದನ್ನ ಹೇಳಕ್ ಸಾಲದ?
ಹೇಳಿದ್ರಿ, ಎರಡು ಹೇಳಿದ್ರಿ.
Then is it not a better ground for you?
Yes, my lord.
Then why are you insisting on this lower cadre and all that? And you are doing the same mistake here. Instead of pointing out, in 15 days I have been shunted out like this.
ಅಲ್ಲ ಪ್ರೀಮ್ಯಾಚರ್ ಅಂತ ತಗೊಂಡಿದ್ದೀನಿ ಪ್ರೀಮ್ಯಾಚರ್ ಪೋಸ್ಟ್.
ಮತ್ತೆ you are not saying anything about that. ನೀವು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀರಾ lower cadre.
Therefore, I brought to the notice of this court that 30th 7 within 15 days they have again transfer.
Only thing is, there may be orders passed by the chief minister.
They are
So even if this premature transfer, if the order is passed by the with the consent of the chief minister, then it is permissible in law. That is why probably you are not insisting on that ground.
ಇಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ ಚೀಫ್
So
ಮಿನಿಸ್ಟರ್
why is it that you are not pressed on that ground at all? ನೋಡಿ ಇಲ್ಲಿ page number 96 ಅಲ್ಲಿ, in page number 96 ಕೆಳಗಡೆ last 4 lines. Now within 15 days, though the third respondent is not eligible to hold the post, has managed to get back to the same post by disturbing the applicant. Third respondent being in the lower cadre cannot disturb the applicant. So ಎರಡು ground ಅನ್ನು urge ಮಾಡಿದೀರಾ?
Yes, madam.
ಹಾ.
Both the grounds are urged.
Para 6 ಅಲ್ಲಿ
ಹಾ.
para 6 ಮಲ್ಲ.
ಹಾ.
What is the reason, my lord? It is
ಏನು?
third respondent filed the statement of objection. Learned counsel urged that applicant was transferred to APMC as assistant secretary grade 1 by order dated 3/7/2023. In the same order, the third respondent was transferred in the place of the applicant. Since that the third respondent has been working at APMC Kalaburagi on her own pay scale as per annexure A1, it is further urged that on receipt of the order dated 3/7/2023, without any objection for posting of the third respondent applicant, got relieved by handing over the charge to the third respondent as per annexure R1. Thereafter, the applicant has given additional charge of the post of additional director, special editor, Kalaburagi by order dated 29/8/2023 as per annexure R2. In this pursuant that the applicant took charge on post 19/2023 as per the CTS annexure R3. That after reporting the applicant as reported as special audit officer applicant worked in the said office and stayed in the Kalaburagi only. It is further urged that on 15/7/2023, the applicant was transferred to the post of third respondent and the third respondent transferred to the Authorized as per annexure A2. After reporting at Kalaburagi, the applicant was issued with the order additional charge as special audit officer division office Kalaburagi by order dated 16/7/2024 and he took the charge on 18/8/2024 by order dated 16/7/2024 as per annexure R4 R5 CTC dated 18/8/2024. After receipt of the said order, the respondent joined the duty at Authorized and later made representation to the respondent 2 requesting the reconsider the order of the couple's case and give any post nearer to the working place of her husband, who was the working at lecturer government political Abjalpur and is now working at Kalaburagi at annexure R6. On considering the said representation of the third respondent, the respondent number 2 has issued the order dated 30/7/2024 by posting the applicant to the post which was held by the applicant and he was an additional charge of the post of special audit officer by giving him full charge. Accordingly, the applicant took charge on.
Nothing is found regarding the premature transfer.
Yes, that is, my lord, a request is made by the my lord, third respondent.
What? If
On
request is
couple,
made, you can disturb anyone, is it?
Because we given the full
ಏನಾದ್ರೂ
charge.
vacant post available ಇದ್ರೆ considering is okay.
Because my lord,
How
additional
can
charge.
you, just because there is a request made by that person,
But-
shunt out this person within 15 days?
2 charges was given to this my lord petitioner hearing. But one account auditor and also this post.
Right.
For that is the reason, my lord, we given full charge to the my lord, account auditor. Posting this third respondent to that post. Because of this, he is also, her husband also working at the Kalaburagi as a lecturer.
ಹೌದ್ರಿ, if see there are 2 posts and this person is also holding post charge of the other post,
Yes,
and if there are 2 posts, relieving this person from one post and handing over charge to that other person is all right.
Please.
Because she will also not be disturbed. But ಅದ್ ಮಾಡಿಲ್ಲ ನೀವು. Now you have been sent out, is it?
Yes, ma'am.
You have been sent to which place?
Sent to that some space auditor ಅಂತ ಬೇರೆ place ಗೆ ಕೊಟ್ಟಿದ್ರು.
ಯಾವ ಜಾಗಕ್ಕಮ್ಮ?
Yes, ma'am.
From which place to which place are you now transferred?
ಅಲ್ಲಿಗೆ auditor ಗೆ ಅಂತಾನೆ post.
ಇಲ್ಲ, ಒಂದ್ auditor
No,
ಅಂತ
no, no.
manager.
If it is in the same place, it is understandable.
Yes, annexure A6, my lord.
A6.
Challenge.
Annexure A6.
Yes. ಇವ್ರನ್ನ ಸಹಾಯಕ ಸವಿತಾ ಅನ್ನೋರಿಗೆ ಸಹಾಯಕ ನಿರ್ದೇಶಕ ರಸಿ ಮಾರ್ಕ್ ನನ್ನ ಪ್ಲೇಸಿಗೆ ಹಾಕಿ ಅನಿಲ್ ಕುಮಾರ್ಗೆ ಲೆಕ್ಕ ಪರಿಶೋಧಕ ರಸಿ
That is
ಮಾರ್ಕ್
full charge ಕೊಟ್ಟಿದ್ದೀವಿ.
So you are in Kalaburagi only.
Yes,
Kalaburagi,
same,
but
here
different
only.
place is different.
ಏನ್ place?
The division, entirely that APMC, the auditors.
Ah.
That is my place, my lord, that is assistant director of the APMC.
ವಿಶೇಷ ಲೆಕ್ಕ ಪರಿಶೋಧಕರು
Yes.
ಕೃಷಿ ಮಾರಾಟ ಇಲಾಖೆ ಕಲಬುರಗಿ. You are in Kalaburagi only.
ಕಲಬುರಗಿ ಇದ್ರೆ ನನ್ನ ಪೋಸ್ಟಿಗೆ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಇದ್ರೆ then within
ಅದೇನು
15
ನಿಮ್
days
ಪೋಸ್ಟ್ ಅಂತಂದ್ರೆ?
assistant director ಅಂತ APMC ಇದೆ
ಹಾ.
post that has been disturbed by
So,
this third
you are
respondent.
holding two charges.
Additional and ಕೊಟ್ಟಿದ್ದಾರೆ. I don't want any other. That is only done. Now they transport this ವಿಶೇಷ ಲೆಕ್ಕ ಪರಿಶೋಧಕರು ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. It can't be.
We'll consider.
ಅಲ್ಲ ಅದರಲ್ಲಿ.
Learned government advocate takes notice for
Respondent number.
all the respondents, huh?
Please.
May I make my submission? Even that
Only two, ma'am.
in the same office also, if the transfer to some other
For response number 1 and 2.
Yes.
Issue
Notice
notice
has to
to
go.
respond number 3. Learned Counsel Shri B.R. Patil. ಇಲ್ಲಿ ಅಪೇರ್ ಆಗ್ತಾರಲ್ಲ?
ಅವರು ಅಲ್ಲೇ ಅಪೇರ್ ಆಗಿದ್ರು ಸ್ವಾಮಿ.
ಹಾ?
ಕೇಟಲ್ಲೇ ಅಪೇರ್ ಆಗಿದ್ರು. ಬಟ್ ಇಲ್ಲಿ ಅಪೇರ್ ಆಗ್ತಾರೆ.
ಕಲಬುರಗಿ ಇದ್ದಾನೆ.
ಹೌದು ಕಲಬುರಗಿ.
He doesn't appear here.
But he is not coming here, my lord.
B.R. Patil.
ಇಲ್ಲಿ ಬರಲ್ಲ ಸರ್, ಅಲ್ಲಿ ಕೇಟಲ್ಲಿ.
I issue notice to respond number 3.
interim sought for interim.
Learned counsel for the petitioner is directed to serve copies of the writ petition along with annexures from the learned government advocate.
One second, may make. Lord, may kindly see the annexure, my lord, CAD rules. Lord, may kindly see.
ನಾನೆಲ್ಲೋ
I brought-
ಬೇರೆ ಕಡೆ ಕಳ್ಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ
ಅಲ್ಲ CAD, one second, one
ಕಲಬುರಗಿ ಒಂದು.
ಅಲ್ಲ one second ತಾವು CAD rules ನೋಡಿದ್ರೆ. ಅಲ್ಲ CAD rules ತಾವು ಒಂದ್ಸಲ ನೋಡಿದ್ರೆ ಸರ್, ಇವ್ರ CAD rules.
Let us consider, not now.
For a moment, my lord, I brought to the notice of this court, my lord. Lord, may kindly see the CAD rules produced at annexure.
Yes.
Yes, annexure C, my lord.
Statement objections file ಮಾಡಿದ್ರಲ್ಲ.
ಅಲ್ಲ annexure C.
ಅಲ್ಲಿ ಅವ್ರು ಫೈಲ್ ಮಾಡಿದಾರೆ, ನಾವು ಫೈಲ್
There.
ಮಾಡಿಲ್ಲ. I'll
ಅಲ್ಲ,
file here also.
ಇವೆಲ್ಲ
Respondent number 3, contesting respondent filed their statement of objection.
You didn't file.
We not.
they have not filed any. Lord, ಅಲ್ಲ
Week's time is granted to
for a
the
moment, my lord.
respondent state to file statement of objection.
ಅಲ್ಲ one moment, one second ತಾನೆ. One last may kindly see annexure C. One second I will convince my. Last may kindly see annexure C. ಅಲ್ಲ ಒಂದ್ಸಲ ನೋಡಿದ್ರೆ ಸರ್.
ಹೇಳಿ.
ಅಲ್ಲ ತಾವು ಫೈಲ್
ಹೇಳಿಮ್ಮ,
ಅಲ್ಲ annexure C ಅವ್ರ ಕ್ಯಾಡರ್ what is how he is eligible for that post ಅಂತ. He is not eligible. ಅದಕ್ಕೆ one second ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ಬಿಡ್ತೇನೆ. ತಾವು annexure C ನೋಡಿ.
Tribunal has passed
ಅಲ್ಲ.
at least 15 pages order.
ಅಲ್ಲ 15 pages is that is not correct ಅಂತ. Therefore I file. One second ತಾವು one moment.
Not
ಅಲ್ಲ one second assistant director.
no interim relief granted to you there.
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ಟೇಟಸ್ ಕೋ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಲ್ಲ ಅಲ್ಲ ಐಡೆಂಟಿಕಲ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ when this tribunal has allowed the dismiss the application. ಅದಕ್ಕೆ one second ತಮಗೆ ಹೇಳ್ಬಿಡ್ತೇನೆ discrimination ಆಗುತ್ತೆ among these persons ಅಂತ. one second ತಾವು ನೋಡಿದ್ರೆ ಸರ್.
The third respondent has already taken charge.
ಅಲ್ಲ one second ತಾವು ನೋಡಿದ್ರೆ ಹೇಳ್ಬಿಡ್ತೇನೆ.
ಚಾರ್ಜ್ ತಗೊಂಡಿದಾರೋ ಇಲ್ಲ ಅಷ್ಟೇ ಹೇಳಿಮ್ಮ.
ಅಲ್ಲ ನಾನು ಕ್ಯಾಡರ್
therefore ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಸ್ಟೇಟಸ್ ಕೋ ಅಂದ್ರೆ ಅರ್ಥ ಏನು?
ಅಲ್ಲ ಅದರಲ್ಲಿ ಈಗ ಐಡೆಂಟಿಕಲ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ಅಲ್ಲಿ ಇದರಲ್ಲಿ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ ಆನ್ ದ ಬೇಸ್ ಆಫ್ ದಟ್ ಸರ್ಕ್ಯುಲರ್ he can't occupy that post ಅಂತ ಹೇಳಿದ್ರೆ ಅದೇ ಸೇಮ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ಅಲ್ಲಿ ಸೇಮ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
ಆಯ್ತು, you are continuing in Kalaburagi only.
ಅಲ್ಲ
we will consider after
ಅಲ್ಲ,
a week's time. Let us
ಅಲ್ಲ
see.
one second ತಾವು
Yes.
ಒಂದು ನಿಮಿಷ I will not take more than 2 minutes. ಅಲ್ಲ one second ತಾವು ನೋಡಿ. In identical circumstances, you are asking me kindly see, I produce that annexure, my lord.
Yes,
You are
next
asking me
matter,
kindly
please.
see the, ಅಲ್ಲ one second ತಾವು ನೋಡಿದ್ರೆ ನಾನು.
Next matter, please.
For kind perusal.
Yes,
Annexure ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ ಸೇಮ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
yes.
My lord, I am for the appellant. The respondent number 1 is right. The LR's application is filed unserved, my lord. Hence I have filed one more application to paper publication.
Paper publication.
Yes, my lord.
ಹೆಸರು ತಗೊಂಡಿದ್ದೀರಾ ನೋಟಿಸ್? ಒಂದೇ ಸರಿ.
Yes, ma'am.
You will have to take out at least 3 times.
Please, ma'am.
Each
Reissue.
time is granted at the request of learned counsel for the appellant to take fresh steps for service of notice on
Respond number 1.
deceased ಅಂತ ಇದೆಯಲ್ರಿ?
Yes, my lord. Respond number 1 is died.
ಹಾ.
LR application is filed. ಅದ್ರ ಮೇಲೆ ನೋಟಿಸ್ ಹೋಗಿದೆ, ಆದ್ರೆ ಅನ್ಸರ್ವ್ಡ್ ಅಂತ ಬಂದಿದೆ RP.
on
Yes, ma'am.
IA number
1,
ಯಾವ್ದು ಅದು?
1,
IA
2,
number
3.
1 of 2024 ಅಲ್ಲ?
Yes, ma'am. 1, 2, 3.
3 na?
IA number 1, 2 and 3.
Application to bring the LRs on record, which application? IA number? 1 to 3.
Yes,
1
ma'am.
to 3 of 2024.
Yes.
Yes.
Pro RPD.
Number 30, government advocate.
Yes.
Number 30, government advocate.
In this matter, the notice may be ordered only there is a delay in filing the application. Appeal, my lord.
Issue notice on IA number 1 of 2021 and the appeal.
Please.
Number 31, Ratnayam Shivayogi.
In this matter, my lord,
Adರಲ್ಲಿ once.
is
Last minute
yesterday's matter, my
NTC, I
lord.
have produced the order passed by this honorable court, my lord, earlier. Along with me by mistake it was.
Revival.
Yes,
Ala,
my lord.
revival, my lord. Varsami kindly
Yesterday,
say.
lordship is decided that, my lord, regarding a review petition is filed in the writ appeal passed by your lordship, my lord.
Ah.
That review petition is there, my lord. 2,62,000 of 2024. Lordship will direct the registry to post this RP, my lord, before the appropriate branch, my lord. Thereafter, my lord, lordship may be considered this content proceedings.
Varsami
Review petition has been.
Yes,
Yes,
ma'am.
yes. Please. That is 2,62,000 of.
See that
2000.
order?
I have produced that, my lord, along with memo, my lord, I have produced the final order by mistake, order CP. Memo haki ಕೊಟ್ಟಿದ್ದೀನಿ. Varsami kindly see the memo 12/9/2024, my lords, produced along with memo.
ಯಾವ್ದ ಇದ್ರದ್ದು? ಈ ಸೂಪರ್
Supermarket.
Ah.
Lordship has made an observation that within a,
ಇದರಲ್ಲಿ ರಿವ್ಯೂ ಪಿಟಿಷನ್
Yes,
ಫೈಲ್
ma'am,
ಮಾಡಿ.
yes.
ಅದರಲ್ಲಿ
ಇದ್ರಲ್ಲಿ
review
ಹಾಕಿದ್ದೀವಿ
ಮಾಡಿದ್ರು.
sir.
ಹಾ.
Extra
With the
ದಲ್ಲಿ
with the consent of the both the parties, my lord, it was passed. Again, they have filed writ appeal. In writ appeal, my lord, by considering all these facts, my lord, the lordship has passed the order. And allot the site 20/40. Within a period of 4 weeks ಅಂತ ಹೇಳಿದ್ರು.
ಇದ್ರಲ್ಲೂ ಒಂದು ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ರು.
ಮಾಡಿದ within a period of 4 weeks ಅಂತ ತಾವು observation ಮಾಡಿದ್ರೆ after considering all those aspects, my lord. They have filed the affidavit. Writ petition, actually writ petition was in the consent, with the consent of both the parties. Again, they have filed writ appeal when they have filed the contempt. Lordship club both appeal and
ಅಮ್ಮ,
contempt.
ಇದ್ರಲ್ಲೂ ಒಂದು ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ರಲ್ವಾ?
ಅವ್ರು ಹಾಕಿ
ಇದೆ ಇದೆ.
ಈಗ just now they are
pending ಇರುತ್ತೆ.
mentioning that
ಅದೇ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಇವಾಗ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ರಿವ್ಯೂ ಮಾಡಿದ್ದೇವೆ ಅಂತ.
ಹೌದು.
The order is passed in the year 2023, my lords.
What
ಹೌದೌದು
ups?
ಅಂತ.
What ups?
ಇಲ್ಲಿ ನೋಡಿ, Lordship 18th December 23, my lords.
No, we will proceed to consider this contempt petition.
Not because, my lord, this-
ಈ ತರ we are really failed to understand what exactly is your problem.
it's true, my lord. Here, what happened, my lord? We auctioned these properties, my lord, long back. We accepted, it is not disputed.
ಕನ್ಸಿಡರ್ ಮಾಡಿ
Consider.
ಆಯ್ತು, ಓನ್ಲಿ 20/40
Yes, my lords.
ಸೈಟ್ ದೇ ಆರ್ ಎಂಟೈಟಲ್ಡ್ ಫಾರ್, ಅದನ್ನ ಕೊಡಿ ಅಂತ ನಾವ್ ಹೇಳಿದ್ವಿ.
Yes, my lord, because, my lord, even that one also, my lord, one of the, my lord, public interest litigation is filed before the Supreme Court. How use supermarket and other the government is misutilizing the sites, my lord, by giving the alternative site. So that is questioned before the honorable court. So Affairs Court clearly directed us not to proceed with the alternative site. That is why, my lord, I felt the.
ಇವಾಗ
ಅದು-
ನೀವು ಏನ್ ಬೇಕಾದ್ರೂ ಮಾಡಬಹುದು.
That is different, my lord.
ಡೈರೆಕ್ಷನ್ ಬೈ ದಿ ಕೋರ್ಟ್.
Yes, ma'am.
You cannot apply the
That's
same
true, my lord. That
principles.
was not brought to lordship notice, my lord, on that day.
No,
But that is the reason, my lord, we filed the review petition, my lord.
no, we'll proceed to consider contempt.
Idರಲ್ಲಿ lordship have it, my lord, direct the, my lord, registry to put up this RP, my lord. Any date, my lord,
No,
lordship fix this date,
ಅದಾಗೋದಿಲ್ಲ.
my lord.
Not possible because I am here
That's
and that other learned judge is in Bangalore.
not any.
ಅದಾಗೋದಿಲ್ಲ ಅದು.
ಅಲ್ಲ, VC ದಲ್ಲಿ
Not
ಮಾಡ್ಬೋದು.
possible.
VC ದಲ್ಲಿ that can be
No,
done.
no.
My lord, I will file the objection to this IA, my lord, which is filed by the my lawyer
Then
friend.
ENIA.
IA for reviewing the order.
There is a liberty, my lord, the last
That's
claim
why, my lord,
last
I'll file the
liberty
objection,
reserved
my
to the
lord. Why?
complaint to revive the
Approval.
complaint.
How the application
the
file,
order-
Approval.
that was disposed of, my lord.
ಅಲ್ಲ, ಪ್ಯಾರಾ 9 ದಲ್ಲಿ ಕೊಟ್ಟಿದೆ liberty is reserved to the complaint to revive the contempt petition if the order passed by this court is not complied with.
That's why, my lord, I filed the, my lord, formal objection to this IA, my lord. And my lord,
Objection, sir,
bringing,
when a specific liberty is given
yes, but that's
to
what,
revive the contempt.
that is the reason, my lord, we not brought to the notice of your lordship, my lord, on that day regarding the, my lord, finding up the affairs court. That was not brought.
That
my
is
lord.
not
Regarding the
applicable,
ultimate-
my lord. That is
alternative
different.
site,
It is
my lord.
88
Not going to
auction.
accept all that.
What a short date, my lord, in date 28th or 29th, my lord, I may be permitted to file the objection.
What is
And-
the next procedure for contempt?
Allah, procedure, first, my lord, here before charge. And,
Thing before framing charge.
Allah, but, short date, my lord, for making the 28th, you also have it, my lord.
Matter for hearing before charges
Allah, charge and bad as well. You lordship, my lord, why submission, my lord?
on
Allah, hearing bad as well. That you also have it, my lord, on 28th, my lord. I'll try to get this, my lord. Allah, I'll try to get, my lord, that review petition before lordship, my lord. Requesting-
That is why I'm saying I'm not going to allow that.
But that is
You
your
please
lordship.
take it,
Allah, lordship dismiss it, my lord, because, my lord,
5th of November.
Please.
Allah,
Yes.
Allah,
We'll
framing
continue
up charge and bad as well.
I brought to so many times I brought to authority. Care ಮಾಡೋದಿಲ್ಲ. ಹೋಗ್ರಿ ಏನ್ ಮಾಡ್ಕೊಂತಾರೆ ಮಾಡ್ಕೊರಿ ಅಂತಾರೆ. DC ಹೋದ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ ಮಾಡ್ಕೊರಿ ಅಂತಾರೆ.
ಒಬ್ಬರನ್ನ ಬಂದಾರ ಅವರು
ಏನ್ ಮಾಡ್ಕೊಂತೀರಿ ಮಾಡ್ಕೊರಿ ಅಂತಾರೆ DC ಗೆ.
CL number 26, Arun Kumar Mrugundappa.
Petitioner is challenging order of ASAT in partly allowing the application. Yes. Just to refresh Lordship's memory, my submission is, my Lord, continuation of departmental inquiry is unsustainable. As my Lord, adverse remarks are already expanded by this honorable court, including a direction to hold my Lord departmental inquiry. My Lord, in this regard, day before yesterday, I have taken Lordships through certain decisions of Honorable Supreme Court, including various other high courts. My Lord, insofar as first decision is concerned, that is Pawan N. Chandra versus Rajasthan High Court and another, where my Lord, though my Lord, there the determination was not
ACR.
please, yes, though my Lord, it was not departmental inquiry. However, my Lord, adverse remarks were directed to be vanished from the records. And second, my Lord, decision, that is KP Singh Kushwa, page 4, my Lord. There, my Lord, I am relying this decision in order to show that courts have, my Lord, jurisdiction to make certain adverse remarks.
This is from
At the same,
Madhya Pradesh High Court.
yes, ma'am. Madhya Pradesh High Court. Para 13 already Lordship has read this, page 7, ma'am. There, my Lord, my endeavor is to show that though court has vested with jurisdiction to make certain adverse remarks while conducting inquiry or trial, at the same time, my Lord, they cannot direct the to initiate departmental inquiry, my Lord. That was the sum and substance of this decision. My Lord, page 9 is another judgment of Madhya Pradesh High Court, KL Pandey versus State of Madhya Pradesh. There, my Lord,
It is
again,
this Kushwaha.
yes,
Yes.
Kushwa, my Lord, page 7, para 13. And following this Kushwa judgment, only, my Lord, this KL Pandey case, my Lord,
Yes.
there again, my Lord, it is reiterated that while making adverse remarks, a court has no jurisdiction to direct the authorities to hold a departmental inquiry. My Lord. That is again reiterated, my Lord. Sir.
Yes.
And now coming to, my Lord, page 12, another decision of Chhattisgarh High Court, Pramod Srivatsa versus State of Chhattisgarh. There, my Lord, Honorable High Court, following ratio of Honorable Supreme Court in case of Muhammad Naeem, wherein in the absence of, my Lord, during the course of holding inquiry against a person who was not before the court, my Lord, who was not before the court, how, my Lord, adverse remarks are not sustainable. That is, my Lord, sum and substance of this decision. And again, there certain guidelines are laid down. My Lord, may take Lordship through page 18 of judgment, para 19, my Lord. In page 18, para 19. A concepts of merit, the concepts of judgment mentioned herein above would show that though judge has unrestricted right to express his view in any matter before him, but there is corresponding duty in a judge not to make unmerited and undeserving remarks, especially in case of witness or private parties who are not before him, affecting their character and reputation, unless it is absolutely necessary for just and proper decision of the case, and that too after affording an opportunity of explaining or defending the witness or the party as the case may be. Judicial decisions must be judicial in nature, and it must show judicial respect to the litigant per party, witness who come before the court for their cause. It is also well settled that this court in the exercise of inherent or extraordinary jurisdiction can expunge those remarks made by subordinate court following three tests laid down in Muhammad so and so. If it is really necessary to do so, or prevent abuse of process of the court, or to secure ends of justice in exceptional cases. Where
Supreme Court judgment idre Muhammad Naeem anbitru, why are you not citing it?
My lord,
Why are you taking us through
Yes.
learned single judges judgments of the other high court?
my lord,
If this is based on a Supreme Court judgment known as Muhammad Naeem,
yes,
why are you not citing that one?
my lord, portion of said decision is called out, my lord, in the very same judgment itself. And my lord, here in this case, the issue is, my lord, already remarks are expunged. My only endeavor is to show that, my lord, after expunging remarks in the present case also, there, my lord, departmental inquiry itself is quashed. That is what, my lord, in the next paragraph it is dealt with, my lord. Yes, para 22, my lord. Following aforesaid principles laid down by Supreme Court, we are inclined to allow this writ petition. Consequently, the adverse remarks made by trial court so and so is hereby expunged. The initiation of departmental inquiry by way of show cause notice so and so consequent proceedings are quashed. So my limited attempt is to show that, my lord, even after expunging adverse remarks, my lord, the consequential order or action, my lord, must also go. And, my lord, in the next judgment,
What are the tests laid down in Muhammad Naeem?
Muhammad Naeem, my lord, that is, my lord, principles of natural justice is, my lord, that is, I'll take lordship through. My lord, that stage is now over in the present case, because, my lord, adverse remarks are already expunged. My lord, next page, my lord, page 19, a judgment of Madras High Court, wherein it has elaborately dealt with, my lord, the delay and laches, my lord, in initiating or concluding, my lord, departmental inquiry, my lord, referring to various decisions of Honorable Supreme Court.
ನೀವೇ ಸ್ಟೇ ಮಾಡ್ಸಿದಿರಲ್ರಿ?
ಇಲ್ಲ, my lord.
Proceedings ನೀವೇ ಸ್ಟೇ ಮಾಡ್ಬಿಟ್ಟು ಡಿಲೇ ಅಂತಂದ್ರೆ ನಾವೇ
Proceedings, my lord, writ petition is disposed of in the year 2019 itself. 2019 itself.
So therefore, we said, you want early conclusion of the department, we will direct.
Again, my lord.
How can you say, no, don't hold an inquiry against me at all?
My lord, delay is, my lord, next aspect. My first, my lord, contention is, because, my lord, my writ petition is, previous writ petition is already allowed. Where, my lord, I sought, my lord, two prayers. One is to, my lord, expunge remarks and consequent direction to, my lord, hold departmental inquiry. Departmental inquiry also. Direction to hold departmental inquiry is also, my lord, set aside by this court.
Then?
Therefore, authorities cannot, my lord, proceed with the disciplinary.
Where is the direction?
Yes, ma'am. prayer was
In prayer already, if there is such a
repetition allowed.
direction,
Yes.
then they would have immediately stopped the further proceeding.
My lord, it is implied that, my lord, may, I'll take lords. It is implied. Once, my lord, repetition is allowed.
Hmm.
If it is partly allowed, my lord, then things would be different. However, in the present case, page 132, my lord,
Yes.
annexure A4, prayer as all, prayer is called out at para,
Yes.
yes, beginning para, my lord, to
Yes.
quash and expunge the adverse remarks made against petitioner herein in paragraph number 41 to 52, and also direction to respondent number 3 to 5 herein to take necessary recourse as observed in paragraph so and so of the judgment dated so and so and so.
Hmm.
The direction was, my lord, to respondent number 3 to 5 is to initiate departmental inquiry. Said, my lord, direction is also, my lord, set aside by this honorable court. Therefore, if they want, my lord, to initiate any departmental inquiry, let them start, my lord, fresh.
Your prayer was not clear. There is no such direction.
No.
So you can't go back on this. Not possible. If you had asked for a specific prayer seeking to quash the departmental inquiry proceedings, then appropriate orders would have been passed. No orders are passed.
My lord, para 41 to 52, my
That is
lord,
why
remarks
you
are there.
also were not able to stop them from proceeding.
Lord.
Next.
My lord, now coming to, my lord, next decision.
Hmm.
This, my lord, delay in concluding, my lord, disciplinary inquiry is, my lord, prejudicial. Is causes, my lord, prejudicial, and it adversely affects the right of, my lord, delinquent official.
Hmm.
My lord, in the present case, though, keeping, my lord, interim order, my lord, obtained by petitioner, keep aside. My lord, 2012, my lord, the departmental inquiry.
See,
Alla,
you
I
got it
suffered.
stayed. You got it stayed.
Yes.
How can you put the blame on them now?
Till 2019, 2019 onwards, my lord, there is no progress.
Hmm.
And till, my lord, 2023, 2024, my lord, they have not issued even not even a single notice.
Yes.
Calling me to face inquiry, my lord.
Hmm.
All these days, my lord, I being a police inspector, right from 2012 to till today, my lord, no promotion, nothing. It is nothing but, my lord,
them to conclude in 3 months' time.
It is nothing but, my lord, it causes great mental agony, my lord, trauma. And besides that, my lord, I lost opportunity of getting promotion.
Hmm.
Because merely because, my lord, departmental inquiry pending, I cannot be denied right of promotion.
Hmm.
At least sealed cover procedure is also not followed.
You should have insisted. You should have filed a petition seeking such direction.
I am an employee, my lord. I am a servant under the respondent higher authorities.
You cannot do that.
I cannot tell.
And now it's an exception. Now that you are standing before the court is an exception.
All these days, my lord, it is nothing but jeopardized. My rights are jeopardized.
Yes, any
I
judgment
understand.
you want to cite?
My lord, last
Yes.
last two decisions. My lord, Honorable Supreme Court, that again, my lord, on the aspect of delay in PV Mahadevan case, where, my lord, I'll take lordship to para 16, my lord, page 36. Under the above circumstances, we are of the opinion that allowing respondent to proceed further with the departmental proceeding at this distance of time will be very prejudicial to the appellant. Keeping a higher government official under charges of corruption or and disputed integrity would cause unbearable mental agony and distress to the officer concerned. The protracted disciplinary inquiry against a government employee should therefore be avoided not only in the interest of government employee, but also in public interest, and also in the interest of inspiring confidence in the minds of government employees. At this stage, it is necessary to draw the curtain and to put an end to the inquiry. The appellant had already suffered enough and more on account of disciplinary proceedings. As a matter of fact, mental agony and suffering of the appellant due to protracted disciplinary proceedings would be much more than punishment. For the mistake committed by the department in the procedure of initiating disciplinary proceedings, the appellant should not be made to suffer. My Lord, next, my Lord, division bench judgment at page 37 of our High Court, where, my Lord, promotion cannot be denied on account of departmental inquiry, pending departmental inquiry, that is sum and substance of next decision. Now, my Lord, coming back to the issue on which, my Lord, departmental inquiry is initiated. Page 121 is a proceedings of respondent department. Page 121. Disciplinary proceedings is on account of, my Lord, adverse remarks made by session judge itself. That is, my Lord, reference 192 refers. Manya Jilla Nyayalaya, so and so. Page 121, my Lord. Annexure A2. My submission is, there is no independent inquiry. It is consequent upon, my Lord, adverse remarks made by the learned session judge. Page 121, there under reference 1, Manya Jilla Mattu Satra Nyayalaya Yadgiri Ravara Katu TK so and so, Dinanka so and so. It is, my Lord, consequent upon adverse remarks made by session judge, departmental inquiry is started. And, my Lord, because said adverse remarks are already expunged, now departmental inquiry cannot be, my Lord, permitted to go on. That is my submission.
Please see the last two lines in page number 120.
Yes. ಹಾಗೂ ಘಟನಾ ಸ್ಥಳದಲ್ಲಿ ಭೌತಿಕ ಇವರು ಪ್ರಕರಣದ ತನಿಖೆಯನ್ನು
ಸಾಕ್ಷಿಗಳನ್ನು ಸುರಕ್ಷಿತವಾಗಿ ಕಾಯಲು ಸಿಬ್ಬಂದಿಯವರನ್ನು ನೇಮಕ ಮಾಡಿದ ಬಗ್ಗೆ ತನಿಖೆಯಲ್ಲಿ ನಮೂದಿಸಿರುವುದಿಲ್ಲ.
121.
121.
ಸಮರ್ಪಕವಾಗಿ
ಇವರು ಪ್ರಕರಣದ ತನಿಖೆಯನ್ನು ಸಮರ್ಪಕವಾಗಿ ನಡೆಸಿರುವುದಿಲ್ಲ.
Yes.
These are the allegations against you.
They are, my Lord.
It arises out of the observations made in the judgment.
Yes.
But is the department not entitled to take action against you?
If it is, my Lord, independent inquiry, then
independent artha enu?
Independent, my Lord, without depending upon the adverse remarks made by session judge, my Lord. If it is, my Lord, prior to passing of judgment or even after passing of judgment, if, my Lord, department intends to hold inquiry, my Lord, then things would be different.
Sir,
it is
sessions court has come to a conclusion.
Yes.
That because of your lapse.
Yes.
It is constrained to pass an order of acquittal.
My Lord, a reference to, my Lord, learned session judge order. My Lord, it is not only an account of lacuna, it is not only an account of lacuna of, my Lord, investigation they are acquitted, but there are some other aspects, my Lord, which were.
On that aspect in matter, you will be given the opportunity to say, no, it is not because of my lapse. It is because of something else. But without holding an inquiry, how to come to conclusion?
At the cost of reputation, my lord, it is because of, my lord, adverse remarks are expunged, my lord, they cannot fall back on, my lord, the order of learned session judge and
Evidence court
proceed.
has considered all the material available on record and has found fault with your investigation. And has expressed its anguish that because of your lapse, the court is required to pass an order of acquittal. Should the department not take action against you?
My lord, till then, my lord, the court may be right in, my lord, making observations,
Ah.
but the second part, my lord, in directing to initiate, my lord, departmental inquiry is, my lord.
Even dehorse such direction. In the operative portion, there is no such direction. In the operative portion, there is no such direction.
Yes,
Of course, it is found in one of the
Yes,
paragraphs that you have
yes.
read out.
yes,
We have also seen that.
yes, yes.
Taking cue from that one, if
Yes.
departmental inquiry is initiated against you,
Yes,
what is wrong?
at this length of time,
Information regarding your lapse can come from any side, including the judgment of the competent court.
yes. My lord, even if we go by with, my lord, the investigation should go on, departmental inquiry should go on. My lord, till 2019, my lord, 2019 writ petition came to be allowed. Thereafter, my lord, there is no progress. 2019 to, my lord, 24, I am made to suffer without any promotion.
Hmm.
There are two parts, my lord. Of course, there was interim order till 2019, and thereafter, nothing prevented, my lord, respondent authorities to go ahead with the investigation. They never did any attempts, even to issuing the notice, my lord, notice calling me to face inquiry. That itself, my lord, vitiates. I having, my lord, suffered a lot. It is nothing but, my lord, double jeopardy, punishing a person twice for same mistake.
How?
Yes, my lord. 2000, after 2019, my lord, they could have proceeded with the matter. 2019, all these days, all
Could have pressed for the very same prayer.
I went up, I approached the authorities by way of representation. I have also produced those representations.
Okay. Any judgment you want to cite?
Lord, this is, my lord, regarding inquiry, my lord, you are also aware of that, my lord. If any, my lord, criminal case is acquitted by the session court, even, my lord, authority, disciplinary authority has to proceed against the, my lord, delinquished, my lord, that is not permissible. Dishonorable court also, my lord, several judgments, and also apex court you also have.
Please cite judgments.
That judgment, my lord, I will give, my lord. That is apart from that, my lord, here, my learned friend is cited the judgments, my lord. First judgment is not applicable to this, my lord, because it is not a departmental inquiry. Other judgments is referred, my lord. There is no opportunity to him to say before passing the any adverse order. But that is expanded by the learned single judge. But here also, my lord, learned single judge expanded that observation made against him. But 2013, my lord, we initiated the, my lord, inquiry proceeding. Then, my lord, he filed the writ petition before this court and obtained the stay. Till 2019, my lord, we are not unable to proceed against him. Thereafter, my lord, when we issued the notice, I filed the, my lord, notice also, my lord, along with memo. When we filed the issued notice to appear before the inquiry officer, he giving the one and the other reason not possible to appear before him. Several reply is given. That is also attached along with the. But now, my lord, there is a absolutely, my lord, Kate is directed us to complete the proceedings within the stipulated period of time. But even now also, my lord, if he cooperated, my lord, without taking any adjournment, my lord, you also directed us to fix the date also, my lord.
ಆಯ್ತು ಇವಾಗ ಟ್ರೈಬ್ಯುನಲ್ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ರಲ್ಲ.
Yes, my lord.
Why have you not proceeded?
But that is why, my lord, when that is also I produced the, my lord, entire order sheet, my lord. That is, my lord, there also, my lord, one and the other reason, my lord, is seeking the time. We filed the writ petition before the honorable court. That is, my lord,
What is-
entire proceedings, my lord, we filed. Thereafter, what happened, my lord, we approached the, my lord, DIG, my lord, regarding the pendants of the writ petition filed before this court, my lord, this present writ petition. That memo is there.
When was that order passed by the tribunal?
But tribunal is passed.
It is in the month of March 2024.
Yes.
and notice is issued in the month of October, September 2024.
Yes.
It is after 4 months was a period that was fixed, my lord, by the tribunal. They never issued any notice, nor they proceeded with the departmental inquiry. And now, my lord, after this the present writ petition dealt with the previous bench, my lord, for several occasions, they come up when I argued on the aspect of delay, they come up, they issued notice on the petition. It is only after my argument with regard to delay aspect and no progress in the departmental inquiry. My lord, kindly see references made in para 4 notice, page 4 notice. All the references, my lord, are referred 2013, 2014. Thereafter, nothing. Directly, my lord, 24/9/2024 is referred.
See page number 7 of their memo.
Yes,
This is your reply to the notice.
yes, ma'am. It is, my lord, thereafter. It is only after September, my lord, I have given reply. But
ಆಗ್ಲೂ ನೀವು ರೆಡಿ ಇಲ್ವಲ್ಲ ಹೋಗೋದಕ್ಕೆ?
ಅಲ್ಲ ನಾನು ಹೋಗ್ತೀನಿ. ಅಲ್ಲ ನಾನು ಇದಕ್ಕೆ
ಮಾಡೋದು.
ನಾನು ಇಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ಇಟ್ಕೊಂಡು ನಾನು
ಅಲ್ಲಿ ಹೋಗಿ you ask for time.
My lord,
Here you come and say no, they are not doing anything.
no, I completely cooperate, my lord.
There are
There is
3 notices issued. to
yes,
you.
my lord. It is only, my lord, September 2024 when they have not obeyed, my lord, KIT's order, when they have not completed within a period of 4 months. How, my lord, one can expect that I should cooperate. If they have soon after disposal of KIT matter before KIT, they could have issued notice, and if I fail to attend, then matter would be otherwise.
So
That is not so.
If they don't conclude it in 4 months, you should be.
Allala.
The inquiry itself.
It is not only, my lord. It is not only 4 months matter, my lord. 2019 till, my lord, approaching of KIT. There are 2 stages, my lord.
Yes.
Absolutely, there are no, my lord, demerits on my part or malafide could be attributed to.
2 replies you have given.
Yes, ma'am.
And in both you are giving excuses to say, no, I am not able to.
ಅಲ್ಲ ಅವರು ಈಗ CR ಇದ್ರ ಬಗ್ಗೆ ನಾನು, my lord, I am nothing to say anything about this. It is because subsequent
Operate, you participate in the proceedings within 3 months, it will be concluded.
my lord, already KIT has already, my lord, fixed a.
ಹೌದು.
But
And all their attempts are going in vain because you don't want to.
no, my lord, kindly appreciate this fact, my lord. It is September 2024 they have issued.
Aye.
And KIT, my lord, has decided the matter, my application on 22/3/2024.
So will it give a right to tell?
Hello,
No, it had to be concluded within 4 months, and otherwise the department inquiry should.
I am not saying so, my lord. Even a single effort is not made within the given period.
Efforts are seen here, and your efforts also are seen here.
Allah, it is.
You have given 2 replies.
Yes, my lord.
And you are saying why you are not able to participate.
I am ready, my lord. My bona fides always, my lord, always there.
We will fix the next date of the inquiry.
Yes.
From then it will go on continuously. Within 3 months, it should be concluded.
Enquiry officer also
If
before
that
last
is,
week
my
only,
lord,
no?
it is nothing but expansion of, my lord, time.
ಹೌದು.
At my instance, in my writ petition, if they are so genuine, my lord, they are so bona fide, they could have approached honorable KIT seeking enlargement of time. Instead of doing so, how can, my lord, they come and now say and seek expansion of time?
You are talking as if this order passed by the tribunal is the law, that it had to be concluded within 4 months, otherwise it will be stopped. What was your prayer in the application before the tribunal?
To quash, my lord, articles of
Direction
charges.
for conclusion of the inquiry?
Yes, 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 my lord, yes.
Was that the prayer?
To consider my representation.
What is your representation?
Representation, my lord, to drop
then-
departmental proceedings on account of
Or
adverse remarks.
That prayer was not granted.
That phrase, yes.
On the other hand, it found that the interest of justice would be met if the inquiry is concluded within 4 months.
Yes, ma'am.
True that they have not taken steps. But afterwards also, even after they have taken steps, you have refused to go and participate in the inquiry. You have given some reason or the other.
Reasons are there, my lord, but
Yes.
my lord, my submission is all along, right from 2012 till today, my lord, there is no promotion. I am in
We'll fix the next ಇವತ್ತಿದೆಯಾ ಇವತ್ತು ಡೇಟ್ ಇದೆಯಾ
But-
ಎನ್ಕ್ವೈರಿ ಇವತ್ತು ಡೇಟ್ ಇದೆಯೇನ್ರಿ?
Yes, my lord. Date is, my lord, so I produced that, my lord, copy of the notice also, my lord.
ಹಾ.
In the memo, we requested him to appear before me, before 2022. That is last notice, my lord. Page number 6, my lord, in the memo, my lord. 22/10/2024 ಒಳಗಾಗಿ ದೋಷಾರೋಪಣೆ ಆಕ್ಷೇಪಣೆ ಲಿಖಿತ ವಿವರಣೆ ಸಲ್ಲಿಸಲು ಕೊನೆಯ ಅವಕಾಶ ನೀಡಲಾಗಿತ್ತು. Yesterday from even also he not appeared. He given the reply stating that it is not possible for me to appear before you.
You have not even given a written reply to the charge sheet,
yes, my lord,
to
it
the
is,
notice.
it is now, my lord, that is in the month of September 2024, they have sought my reply.
Yes.
Though, my lord, articles of charges issued way back in the year 2013.
Sir, how many times to repeat?
Illa, 13 ali put.
Because of your instance and stay was granted, they could not proceed. Purple. The petitioner is before this court aggrieved of the impugned order passed by the Karnataka State Administrative Tribunal at Kalaburagi in application numbers 20923 and 20924 of 2023. Aden ಎರಡು application.
ಎರಡು, my lord,
To quash the impugned departmental inquiry. ಎರಡು ಅಪ್ಲಿಕೇಶನ್ ಏನ್ರಿ?
ಇಲ್ಲ ಒಂದೇ ಸ್ವಾಮಿ ಹಾಕಿದ್ದು, ಅದು 2 ನಂಬರ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾಕೆ?
ಮೇ ಬಿ ಬಿಕಾಸ್ 2 prayers.
ಎರಡು ಪ್ರೇಯರ್ ಕೇಳಿದಾರೆ ಅದಕ್ಕೆ.
2 prayer
ಚಾರ್ಜ್ ಶೀಟ್ ಅಂತ ಹೇಳಿ.
articles of charge, but only one application is. Only one application was filed.
Next para. Departmental inquiry was initiated against the petitioner. Having regard to certain observations and remarks passed by the learned district and session judge, Yadgir in his judgment in sessions case number 17 of 2010. Full stop. ಯಾವ್ದು ಅದು paragraph number?
42 to 52, madam. Page 112,
41 to 52, my lord. That is page number 133 of the learned single judge order.
One not five onwards, madam. Page 105, paragraph 42.
Paragraph number 41 of the judgment commences with the heading dash hakondo flaws and lapses committed by the investigating officer. PW 17 Rajkumar, son of Lakshman Vajantri. Stop. Vajantri. It is held in the said judgment that the investigation of the officer is not only defective investigation, but also unfair investigation. Full stop. It was observed that the investigating officer has not attempted to produce the material before the court in which TomTom Auto the TomTom Auto where the accused had come to the incident spot to commit the murder were not produced. Full stop. It was held that it is not impossible for the investigating officer to trace out the owner of the auto. Full stop. The investigating officer did not conduct the spot panchanama on the very same day. When the alleged incident took place. The investigating officer has not cited one Suresh as witness, who is the circumstantial witness for discovery of weapon. Full stop. The investigating officer did not record 161 statement of PW6 and CW7 immediately after he came to know that they are the eyewitnesses. Full stop.
64. Sorry, ಇದೆ four.
In this manner, several defects were found in the investigation, and the learned sessions judge expressed his anguish that due to the defective investigation and unfair investigation, the court is constrained to pass an order of acquittal against the accused persons. Full stop. In paragraph number 50, having regard to the observations made in the judgment, the learned judge found it necessary to direct the higher police officers direct the Superintendent of Police and the Inspector General of Police to take action against the investigating officer for the lapses. Full stop. It is the contention of the petitioner that consequent to such observations and remarks in the judgment, show cause notice was issued to the petitioner, and thereafter articles of charges were also issued invoking Rule 6 of the Karnataka Police bracketed disciplinary proceedings closed 1989. Full stop. However, the petitioner filed a writ petition before this court in WP number 205082 of 2014, seeking to expunge the adverse remarks in the said judgment. Full stop. Accordingly, the writ petition was allowed. On 27th of March 2019, accepting the contention of the petitioner that the remarks were passed by the learned judge without affording an opportunity of hearing to the petitioner. Full stop. Accordingly, the adverse remarks were expunged by this court, by the learned single judge. Full stop. Thereafter, the petitioner filed the application before the Karnataka State Administrative Tribunal. Challenging the initiation of inquiry by order dated 28/1/2013 and sought to quash the charge sheet dated 11/2/2013 and further sought for a writ of mandamus to consider the petitioner's representations dated 31/5/2023. Full stop. Stop. However, the tribunal held that the petitioner herein sought to challenge the two orders of initiation of inquiry and the charge sheet after lapse of 9 years. Full stop. It was held that in terms of section 21 of the Administrative Tribunals Act, challenge should be raised within a period of 1 year from the date on which orders are passed, from which the impugned orders are passed. Full stop. As regards the contention of the petitioner that the departmental inquiry having been initiated only in terms of the judgment passed by the Sessions Court, and since the adverse remarks were expunged by this court, the departmental inquiry should be dropped, the tribunal is of the opinion that the initiation of inquiry is not only based on the orders passed by the Session Court, while it is based on the preliminary report of the Deputy Superintendent of Police, Yadgir. Stop. Consequently, the tribunal did not accept the contention of the petitioner. And on the other hand, directions were issued while disposing of the applications that the departmental inquiry shall be concluded within a period of 4 months from the date of receipt of a copy of the order. Full stop. Next para. Learned counsel for the petitioner seeks to place reliance on a judgment of the Honorable Supreme Court in the case of Pawan and Chandra versus Rajasthan High Court and another in civil appeal number 7033 of 2001 dated 21/4/2009. Full stop. However, learned government advocate points out that in the said judgment, the initiation of departmental inquiry was not based on any observations in any judgment of a competent court. Full stop. It was based on the adverse remarks in the annual confidential reports. Full stop. The learned counsel for the petitioner has sought to place reliance on judgments of several other high courts in the case of Pramod Srivastava versus State of Chandigarh in ಯಾವ್ದು ಇಂಡಿಯನ್ ಕಾನೂನು ಇದೆಲ್ಲ ಇದು
WP number, WPCR number ಅಂತೀವಿ 472 of 21.
in writ petition
Yes.
bracket CR number 472 of 2021. The learned judge has noticed the judgment of the Honorable Supreme Court in the case of Muhammad Naeem, the state of UP versus Muhammad Naeem. Mostly ಇದು AR 1964 SC 703 ಇರಬೇಕು ನೋಡ್ಕೊಂಡು ಹಾಕಿ. Wherein 3 tests were laid down in the matter of consideration of expunging of adverse remarks made against persons or authorities whose conduct comes for consideration before the court of law. comma, as follows. A, whether the party whose conduct is in question is before the court or has an opportunity of explaining or defending himself. B, whether there is evidence on record bearing on that conduct justifying the remarks, semicolon, and C, whether it is necessary for the decision of the case as an integral part thereof, comma, to advert on that conduct. Full stop. It has also been recognized that judicial pronouncements must be judicial in nature and should not normally depart from sobriety, comma, moderation, and reserve. Full stop. Next paragraph. The learned counsel would also submit that there are several judgments of the Honorable Supreme Court and this court, comma, including P.V. Mahadevan versus M.D. Tamil Nadu Housing Board, bracketally 2005 close 6 SCC 636. Where it was held that protracted inquiry should be avoided, not only in interest of government employee, but also in public interest and inspiring confidence in minds of government employees. Full stop. It was also held that mental agony and sufferings of the delinquent officer due to protracted disciplinary proceedings would be much more than punishment. Full stop. It was also held that for the mistakes of the department, comma, the officer should not be made to suffer, and accordingly the charge memo was quashed. Full stop. Learned counsel would therefore submit that having regard to the admitted fact that the charge memo was issued in the year 2013 and till date enquiry has not been concluded, comma, it is a fit case where the disciplinary proceedings must be quashed. Full stop. Next para. However, learned government advocate would submit that the petitioner cannot dispute the fact that during the pendency of the writ petition filed by the petitioner in the year 2014, comma, orders of stay were passed by the learned single judge, and therefore the proceedings could not be proceeded with. Full stop. It is only after the disposal of the writ petition on 27th of March 2019 while expunging the adverse remarks, comma, opportunity was available to the department to proceed further. Full stop. Therefore, the petitioner cannot contend that there is a delay in concluding the proceedings. Full stop. It is further pointed out that after orders were passed by the tribunal directing that the proceedings shall be concluded within a period of 4 months from the date of receipt of a copy of the order, after having received the orders of the tribunal, notice was issued to the petitioner. On 26/9/2024, 24/9/2024, calling upon the petitioner to give a written reply or objections to the charge memo, within a period of 4 days from the date of receipt of the notice. Full stop. It is pointed out from several other such notices which are filed along with the memo dated 22/10/2024 that despite such notices being issued, the petitioner has not submitted the written objections to the charge memo. Full stop. On the other hand, the petitioner has given 2 replies, one on 25/9/2024 and another on 8/10/2024, giving excuses for not being able to participate in the inquiry proceedings and for not filing the written reply to the charge memo. Full stop. Learned government advocate would therefore submit that the petitioner cannot allege that the delay has happened on account of the department. Full stop. It is very clear from the replies given by the petitioner that he is reluctant to participate in the proceedings, and on the other hand, he is trying to make allegations against the department for the delay. Full stop. Learned government advocate would submit on instructions that if a date is fixed by this court and the petitioner files his written reply to the charge memo, thereafter, within a period of 3 months, the inquiry will be concluded. Full stop. Next para. Having heard the learned counsel for the petitioner, the learned government advocate, and on perusing the petition papers, this court finds that although the petitioner was able to get the adverse remarks expunged at the hands of the learned single judge in the writ petition filed by him, nevertheless, no directions were sought, and neither was it directed by the learned single judge that the departmental inquiry should be terminated or should be concluded within a time frame. Full stop. Even before the Karnataka State Administrative Tribunal, although a prayer was made by the petitioner challenging the charge memo and departmental proceedings, nevertheless, the tribunal did not accept the contention of the petitioner. Full stop. The tribunal came to a conclusion that although it is true that the show cause notice and charge memo was issued consequent to the adverse remarks found in the judgment of the Sessions Court, nevertheless, the initiation of departmental inquiry was not based on the adverse remarks alone. Stop. It was found that a preliminary report was submitted by the Deputy Superintendent of Police, Yadgiri, and based on the material collected and the preliminary report, the departmental proceedings were initiated against the petitioner. Full stop. The judgments cited by the learned counsel for the petitioner is regarding the expunging of the remarks, adverse remarks. Full stop. Those judgments will not be of any help to the petitioner, since admittedly the adverse remarks have been expunged at the instance of the petitioner in a writ petition filed before this court. Full stop. Nevertheless, if there is sufficient material available indicating that due to the lapses on the part of the petitioner, an accused person has gone scot-free, the department is duty bound to proceed against such officers for the lapses. Full stop. In fact, the learned judge in the judgment in paragraph number 50 has pointed out to various directions issued by the Honorable Apex Court in such cases where lapses are found on the part of the investigating officer. Full stop. It has been pointed out that it would be the duty of the department to take action against such investigating officers for their lapses, since even a minor lapse would translate into a judgment being rendered in favor of the accused persons. Full stop. Surely, such an act would not be in public interest, if the lapses of an investigating officer would translate into a judgment in favor of the accused persons. Full stop. That being the position, this court is not inclined to accept the submission of the learned counsel for the petitioner that the departmental inquiry itself should be closed. Stop. Next para. Further, having regard to various notices issued by the respondents and the two replies given by the petitioner, it is clear that the petitioner is seeking to protract the proceedings and not the department. Full stop. Therefore, comma, this court is of the considered opinion that a specific time frame should be fixed to conclude the proceedings, and at the same time, necessary directions are also required to be given to the petitioner to cooperate and participate in the proceedings. Full stop. Next para. For that purpose, the next date of hearing of the proceedings shall be November 4th, 2024. Full stop. Before the next date of hearing, petitioner shall give a written reply or objections to the charge memo. Full stop. Thereafter, the proceedings shall go on day to day, and the proceedings shall be concluded within a period of 3 months from 4/11/2024. Full stop. With these observations, the writ petition stands disposed of.
Correct.
Appeal number 32.
May I make request for, instead of fourth, my lord, you ask me fifth, my lord. Fourth, he has to attend before the. Fifth.
5/11.
Great.
Appeal number 32, Anand Ture.
My lord, this appeal is preferred by owner of the offending vehicle, my lord.
Huh?
This appeal is preferred by the owner of the offending vehicle,
Huh?
whereas,
Delay of 23 days.
yes, my lord. Notice may be issued, my lord.
You're seeking enhancement.
No, my lord, I am for the offending vehicle, owner, offending
owner?
vehicle, yes, my lord. The liability is fixed upon the owner.
Hmm.
There is no insurance on the vehicle.
Hmm.
The claimant has already filed a EP before the trial court, my lord.
ಮತ್ತೆ
There is
ಏನ್
a-
ಮಾಡ್ತೀರಾ?
There is a possibility of settlement, my lord. In the meanwhile, notice may be issued.
Saka,
Please, my lord.
issue notice to the respondent.
Appeal number 33, Ganesh Chandra Kalaburagi.
Patents appeal, your lord. There's 10 days delay.
Huh?
There is a delay of 10 days, your lord. Right.
Issue notice.
No, notice is already,
ಆಗಿದೆಯಾ?
notice ಆಗಿದೆ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. Or they are not unrepresented.
Served. All of them. All three.
All set.
Sorry. You have to call for trial court records?
That is, I have filed written statement. I couldn't let evidence, your lordship. That is the only issue, because I have taken contended that that's.
Asking for remand.
Yes, sir, that I have not taken contention of one of the properties my mother purchased in the name of in my name by my mother and self-acquired property. And one more point, your lordship, the defendant number counterclaim also allowed.
You are the plaintiff, huh?
I am the defendant.
You are the
I am
defendant.
defendant number one, your lordship.
So, suit for partition is allowed.
Allowed.
Huh?
Yes, your lordship.
Huh?
Wherein, your lordship, the
There are other defendants also.
also there, your
They have
lordship.
participated.
Yes, one of the defendant number 4 who has filed written statement consenting the plaintiff.
Proceeding.
Consent WS has been filed.
Huh?
He has made counterclaim, yes.
So
That
there was
counterclaim
no
also,
opposition.
I have challenged it, because as the valuation of that counterclaim is less. For that matter, your lordship, that appeal is pending before the honorable single judge, your lordship. One more appeal is filed challenging the counterclaim.
ಏನು counter claim?
Defendant number 4, she also sought for share in that property. Her claim also allowed. That counterclaim is also allowed.
Huh?
share in the property,
Ah.
one more share, that counterclaim which he has made, that is allowed. Separate
Counterclaim
appeal.
ಏನ್ರಿ?
As partition suit,
ಹೌದು. ಹೌದು.
separate,
No, defendants also can ask for a share.
yes, you are.
ಹಾ.
Being agreed by that also, one separate, for avoiding the technicalities, one separate appeal is also filed for that.
ಎರಡು appeal file
ಎರಡು appeal file ಮಾಡಿ, that is pending before the honorable single judge, your lordship. There's valuation of that is.
ಹಾ.
Where ಅದ್ರಲ್ಲೇನೋ notice ಹೋಗಿದೆ, notice also directed to be served in that appeal also, that is also, that appeal is also pending, your lordship.
No, but that is before the learned single judge.
Yes, your.
ಹಾ.
Here in this case, my specific contention was that the, one of the property number 193, which were purchased by my mother in my name, your lordship, defendant number 1.
ಅದರ್ ಇನ್ನೊಂದು ಅಪೀಲ್ ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಅವರು.
ಇನ್ನ ಅವ್ರ ನೋಟಿಸ್ ಇನ್ನ ಬಂದಿಲ್ಲ ಅದರಲ್ಲಿ. ಬಂದಿಲ್ಲ.
Let us see them.
Yes.
Learned counsel for the appellant submits that the appellant has also filed a RFA
2,65,000. 2024.
2,000,065
Yes, you.
of 2024.
Yes, you.
In respect of the counterclaim of defendant number
4.
4. Stop. However, the said appeal is pending before the learned single judge. And notices have been issued in that appeal also. Stop. Next para. Release this matter on 11th of November.
Yes.
Let us see. Allenad appear adre.
Yes.
We can ask them to enter appearance here also, and thereafter we can ask for necessary directions at the hands of the Honorable Chief Justice for clubbing the matters. Yes.
Because they are proceeding with the FDP, final degree proceeding is,
Huh?
final FDP is proceeding.
ಎಷ್ಟು ಬೇಗ ಏನಾಗುತ್ತೆ ನೋಡೋಣ.
Much.
34, Adlur Satyanarayana.
Challenging the preliminary decree, my lord. There is a challenging.
1131 days delay.
Delay is there.
Issue notice on IA number 1 of 2020.
For 35, Vishal Pratap Singh.
My lords, and my please. My lords, here I'm seeking an application for suspension of sentence in this matter. And I had the benefit of bail during the trial, my lords. And objections are also filed.
ಹೌದಾ?
Objection.
ಹಾ.
So, my lords, in this matter, the very brief facts of the case is, initially the case was registered as an accident. Subsequently, my lords, another complaint was produced before the court saying that it's not an accident, but it was a murder, where this appellant apparently using his vehicle had caused a head-on collision with the vehicle in which the deceased were traveling. And as a result, they died. So they have turned this whole accident into a case of a murder matters. And the manner in which they have turned this entire accident case into a murder case has no foundation at all, absolutely. The prosecution says the motive for causing the murder is because the people who were traveling in the car, the deceased, one woman, and this appellant apparently were in love. And because she married somebody else, he became a jilted lover. And he could not accept the fact that she had married him. As a result of it, he caused this accident. That is the prosecution's case. But to establish this, my lords, there is no material. They say three things would come into picture, my lords. The first thing is, initially there is no suspicion of any such activity. There are no eyewitnesses in the case.
initially prosecution has projected one person as an eyewitness, but subsequently after his deposition, it was found that he was not an eyewitness to the case. The people who were traveling in the car also have not seen this person. So this case absolutely has no eyewitness. Even though this accident has caused on the street with so many people, nobody has identified this person as the person who was driving the vehicle. So that is one ground I have. Prima facie ground I'm talking.
But it is a fact that there was an accident
It is a fact that there was an accident.
and this person died in that accident.
Yes,
Is
Doublement.
yes.
that incident you can't deny.
I am not denying that accident. In fact, I am saying that it's an accident only.
The question is whether
I have caused that accident.
that's all.
That's all.
It is done wantingly.
ಅಂತ ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ.
There.
That's case of the process.
Therefore, and you also are aware
My lords,
that the presumption that is available for the accused while
Yes.
granting bail is different, and that presumption is now lost.
presumption is not law now. Now it is.
It is now lost. So therefore, you can't say I had the benefit of bail at that point of time.
Yes.
I will satisfy your lordship through the judgment of the Honorable Supreme Court. Yes. With your permission, may I?
Independently, you will have to now say.
Independently, I have to say yes.
So
Now-
it cannot, your argument cannot be based on the bail earlier grant.
Allah, that's the part. That's the
Yes.
part. Now, if I may permit to present these authorities, with your permission, first. This is a judgment where, my lords, the law on suspension of sentence is discussed by the Honorable Supreme Court. And they have gone through the judgment from 1931 onwards till 2016 when this order was passed. My lords, if I may have to take your lordship to, well, the whole judgment, it's a very short, but yet it has discussed everything. And it says, my lords, the last one, I'm reading directly the final conclusion, which is on paragraph number 22. My apologies, my lord, I have not numbered the page numbers. Paragraph 22, taking into consideration overall view of the matter and in particular offense alleged and sentence imposed, and further taking into, this is also a murder case. This is also 302 offense only. Into consideration the acquittal of other accused persons who were also charged in the same offense as that of the appellants, and further taking into consideration the conduct of the appellant during the trial before the circuit court when they were on bail. In our view, High Court would have suspended the sentence and granted bail to the appellants. Therefore, this court would be justified that Article 1 of the Constitution in interfering with the discretion exercised by the High Court. We therefore suspend the sentence and direct the appellants to be released on bail on each one of them, executing bond with true solvent, shows to satisfaction of additional district sessions. Here, my lords, the principal contention was they were on bail during the trial. High Court refuses them bail, saying that see this is not available. Then they go to Supreme Court. Supreme Court, they go through the entire judgment from 1931 onwards till 2016 and comes to a conclusion that their conduct. Now, a special case in my situation is the entire trial ran for 10 years. This was a very lengthy trial, and I was arrested, the lordship. I was arrested, my lords, on. If I may draw your lordship's attention to the synopsis, which is on page 15, synopsis of the trial court judgment, which is on page 15. Ali, arrest of accused is 23/6/2014 ಅಲ್ಲಿ ನನಗೆ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ. And I was released on bail on 23/2020. So 6 years I was in prison as an under trial. Then, my lords, the eyewitness was examined. Eyewitness was called and he was examined by the trial court. And based on the deposition given by the eyewitness, this honorable court, a single judgment, Lord Justice Arvind Kumar, my lords, he was the one who was granted bail. He said that he was not an eyewitness because he has very clearly deposed that he had come little late and he has not seen the incident. Therefore, we say that he was not in view of this, there are no eyewitness in the case. Insofar as motive is concerned, that is also not established. Therefore, I grant him bail anta bail kotbidtare. So, my lords, 6 years I have spent in the trial, in the judicial custody. Now, my lords, and I was granted bail after the merit of the case. And now, my lords, I am convicted. And conviction is entirely on the basis of some unknown entity saying that some 5-6 years back, this particular girl who had died and this particular person, they both had love affair. Assuming, assuming that they had, where the prosecution's burden of the prosecution is to prove that that particular relationship was in continuing, was in existence at that relevant time.
Girl is killed.
Girl is killed. Both. Girl and their husband had died.
Double.
Both have died. And in that very car also, there were two other persons also. And they have not identified this person. That is one thing. Now, so prosecution
Identified.
not identified.
Andre?
Appellant, ಇವನೇ ಆ ವೆಹಿಕಲ್ ಓಡಿಸ್ತಾ ಇದ್ದ ಅಂತ ಐಡೆಂಟಿಫೈ ಮಾಡಿಲ್ಲ ಅವ್ರು. ಕಾರಲ್ಲಿ there were 4 people in the car. 2 have died and 2 other people who were inside the car, they did not identify that this person was driving the car, nor other people have identified that he was the car. So my lords, so the first burden on the prosecution during the trial and even now also, because it's a continuation of trial, would be to first establish that he is the person who was driving the vehicle. Now, this is one part. The second part, my lords, would be
What happened to the FIR registered by the police?
that was for accident case.
Against whom?
Against unknown person. Against FIR, my lords. Initially, it was registered as an accident against an unknown person. Against an unknown person.
Unknown person. So they did not know which was the vehicle that
Who-
was
yes.
involved in the accident.
Yes, my lords. Then subsequently, somebody else says, 4 years back, 5 years back, I was about to marry this woman, but apparently this girl with whom I was about to get married, she said, I am in love with some other person. Therefore, you please don't accept my proposal. That is what he says. Then he says, therefore, I believe that maybe this accident is caused by him. Manta un helta. That becomes the foundation for another complaint. So 2 complaints were filed in this case. One complaint was an accident complaint. The subsequent complaint was this story, this background story comes into picture. But that was a long time back. It is on the burden of prosecution that a stale relationship, even if I have to give up,
Whose is the vehicle involved in the accident?
vehicle does not belong to this appellant also. It belongs to some other person. Yundu Allah.
Belong to you.
Yundu Allah. He is also not the one. In totality, prima facie, also in view of the fact that a judgment is also before your lordship, and also the fact that for 6 years he was also in judicial custody and 10 long years the trial had gone. My lords, this is a 2024 matter. My lords, I deserve, and I have a wife who is dependent on me, young wife. So therefore, my lords, and I belong to a BPL card. And more importantly, my lords, I belong to Kurba community. The girl belongs to Reddy community. The incident has happened in Shahapur, where that particular community is dominant. I can't afford to get in trouble with those people. Because that is Shahapur is a belt belong to this powerful dominant this thing. I belong to Kurba community. I can't afford to fight with these people. This is a reality. So my lords, now they are saying that I involved with that woman. I told them not to marry her. I threatened them, and then lots I caused this accident is little preposterous in my respectful submission to the court. Of course, court reserves the discretion to say that this is not the way to present it, but this is the reality of our society also. So therefore, my lords, in view of this fact, in view of the fact that it's a case where first it was an accident case, subsequently based on some third party who has no locus, based on his statement, a complaint, second complaint was taken into consideration, and it was an accident case converted into a murder case. And my lords, eyewitnesses are not there, motive is not proved, and nobody has identified me. My lords, in such a scenario, my lords, and this matter being a 2024 matter, and since I have already spent 6 years in prison, and the Honorable Court, High Court, has granted bail after looking into the evidence examined by the witness, prosecution itself, has granted me bail. So therefore, my lords, I carve out an exception to the present situation and seek suspension of sentence and grant of bail, post-conviction. Actually, that is my submission.
Yes, my lords. My first submission would be what my friend has argued, that this citation in 2009, wherein the benefit of bail. Now the apex court held in several decisions that, my lords, during the pendency of the trial, when the accused was on bail, that is not the criteria to grant a bail. I'll submit in next date of it. And another submission would be 4 members were traveling in a car. Amongst them, 2 were died. And one lady and her daughter seriously injured the moment the cruiser and Indica car, when they were traveling in Indica,
this accused driving a cruiser intentionally hit dashed on them.
Land cruiser,
Yes, ma'am.
land cruiser.
No, no, it's cruiser vehicle that hired purchase.
ಇದು jeep ತರದ್ ಬರುತ್ತೆ.
Yes, that. So question of identification on that particular moment does not arise. And even though this accused has broken 2 marriages of this particular Arati who died in the accident, and those were also examined by the trial court and they have supported the case of the prosecution. And as far as his bail granting is concerned, my lords, eyewitness, of course, he partly supported the case of the prosecution. On that basis only, he was granted bail by the Honorable single judge. But that is not the criteria. All the witnesses, the persons engagement were broken by this accused. They were not examined by that time, my lords. And IVO was not examined, doctor was not examined, and the parents of the deceased, both the deceased, were not examined. So that is not the criteria to grant. And they was categorically in a verbatim, they have deposed and they have supported the case of the prosecution. But presently, I don't have any depositions on that, my lords. It may posted on first week or second week of next month, my lords. So I'll collect it and I'll elaborate. And even along with that, I'll submit a citation of Apex.
Reserved for orders.
Please,
I'm grateful to your lordship.
I may be permitted to submit a citation on that,
Yes, yes.
please.
I
Number 36, Sivanand Patil. First appeal, my lord. The suit of the plaintiff was decreed. The suit was one for partition and separate.
So I have entered caveat for respondent number 192, plaintiffs.
The first appeal,
yes,
suit for partition and separate position was
yes.
decreed. My submission was that there was already a partition way back in the year 1987. 87 ಅಲ್ಲಿ mutation ಆಗಿವೆ. Certain documents that were not filed by me then also, I have also filed it now here by additional documents. That this property.
You are the defendant in the suit.
I was the defendant number 4 in the suit, madam. So I was the only contestant defendant. My contention was that there was already a partition earlier in the year 1987. And mutations were effected and it was also acted upon because pursuant to these mutations in their individual names, two of the parties, two of the family members of the suit again fight a battle. They file a suit for a particular property of that property belonging to them. They file a suit. So that indicates that the partition was already acted upon.
It means that if you are contending that there was a prior partition.
Yes, ma'am.
And in that partition, this portion of the property
one suit property was given to me.
has fallen to your share.
Yes, ma'am.
That is only one item of the suit schedule.
One item of the suit.
There are other items. also.
There are other items.
So
that I have no
You
objection.
are concerned only with
Only one item.
that item of the
Yes.
suit. What
One.
is the
With regards to other items that were allotted,
interim prayer you are asking for?
interpret, let the final decree, drawing a final decree be stated.
ಅಷ್ಟೇ ತಾನೇ?
Lead question is that, my submission is that, my lord, whatever.
ಆಯ್ತ್ರಿ.
Drawing of the final decree, I am not asking for the stay of the.
If you don't even want to consider the appeal on merits,
There is.
a regular first appeal,
Yes.
that too. And if you are permitted to proceed to draw the final decree. Then Council Sri Deepak V. Bharat has entered appearance for response number
192, plaintiffs.
Issue notice to the other respondents. Next para. Till the disposal of the appeal, the final decree shall not be drawn up.
Much.
Appeal number 38, Mrs. Aspari.
Claimant has also filed a appeal and another company appeal is also pending, my lord.
List this matter along with the MFA so and so so and so.
My lord, notice to respond number 8 may kindly, I'll take notice to respond number 8. Unserved
ಯಾವ್ದ್ರಲ್ಲಿ?
for 8, respond number 8, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ?
In this case only.
Respondent.
Appellant,
You are appearing for the appellant, isn't it?
yes, man. I have to take notice for the respond number 8, man.
ಹೌದು.
Issue notice to respond number 8.
Issue notice ಆಗ್ಬೇಕಾ? ಆಗಿದೆಯಲ್ಲ. Notice ಆಗಿದೆ. You
I'll
have to take steps. A week's time is granted. ಮುಂಚೆ a week's time is granted to the appellant to take steps for service of notice on respond number 8. ಅದಾದ್ಮೇಲೆ list this matter along with so on so. ಅದು ಅವರು ಡೆಪಾಸಿಟ್ ಆರ್ಡರ್ ಆಗಿದಾಗ್ಲೇ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಯು ನಾಟ್ ಫೈಲ್ಡ್.
Deposit, I'll produce acknowledgement. Deposit before
At the same time, acknowledgement for having deposited 50% of the award amount shall be filed by the appellant.
Yes.
Yes.
Appeal number 39, government advocate.
I'm appealing for the respondent's
notes.
Huh?
IF for CD may be kept open, my lord, and IF for stay may be considered, my lord.
As earlier similar matters has been passed, but this.
Same orders.
Yes.
All the same orders. Yes.
Appeal number 40, admission matters, PP Ambedkar.
Matter is called out. There is no representation for either of the parties.
R2,
This matter,
R2, I'm appearing.
I accept the learned government advocate. Release this matter on 6th of November.
Please.
Appeal number 41, DP Ambedkar.
Matter is called out. There is no representation for the appellant. Release this matter on 6th of November.
Appeal number 42, Manvendra Reddy.
Petition was summarily dismissed that my land has been utilized by government without paying compensation.
Same type.
Same time. If you see the order, my lord,
ಅದು ಯಾವ್ದು ನಾವು ಮಾಡಿದ ಆರ್ಡರ್ which is that order? Writ appeal number?
ಮೊನ್ನೆ ಮಾಡಿ.
In this matter, my lord.
Huh?
Page number 84, my lord, for a moment.
Double 017.
The total extent of land was 28 acres, 28 guntas.
Yes, my lord.
Ah.
Otherwise, some of the land was acquired.
Ah.
Remaining 1
For
acre 18
construction of jail.
jail, my.
Ah.
1 acre 18 guntas left out, my lord. There was a decree suffered by them. A specific direction, a decree is passed. Page number 73, my lord. Download. We have gone to civil court. Civil court decreed the suit, given a direction to acquire the property. Since then, I am moving from pillar to post. Tahsildar has also given a report. Assistant commissioners abruptly, yes, sir, it is no land is there.
Huh?
Every assistant commissioner annexes 80. As my learned friend is pointing out, of page 84.
This judgment was passed on 11th of August 2003.
Yes, my lord, from that one we are moving pillar to post, acquire it. No steps has been taken it. And the learned single judge, without looking all the documents, as
ಅವ್ರು ಯಾವ್ದು document point out ಮಾಡಿದ್ದು?
ಅದೊಂದು 84 ಅಲ್ಲಿ page
Number 84.
84.
ಹಾ.
ಏನು ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರ.
ಹಾ?
ಈಗ 27 ಎಕರ್ 10 ಗುಂಟ ರಸ್ತೆ ಇದೆ ಅಂತ ಹೇಳ್ತಾರ.
ರಸ್ತೆ ಮತ್ತು ಖರಾಬ್.
ಮೊಟ್ಟು ಖರಾಬ್ ಅಂತ ಹೇಳ್ತಾರ. What is the basis? And
That road is formed on which property?
That's why, my lord, that is Tahsildar the order, my lord, kindly see, my lord, page number 81. ಇದಕ್ಕೆ ಮಾಡಿ you only considered to that one also.
81 ಅಲ್ಲಿ
my lord, ಒಂದೇ ನಿಮಿಷ.
ಹಾ.
ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕನ ನಿರ್ದೇಶಕರು ಕಲಬುರಗಿ ಅವರು ಉಲ್ಲೇಖ 3ರ ಪತ್ರದನ್ವಯ ಭೂಮಾಪಕರು ನಿಯಮಾನುಸಾರ ಅಳತೆ ಕೆಲಸ ಪೂರೈಸಿ ಸ್ಕೆಚ್ ನಕಾಶೆ ತಯಾರಿಸಿ ವರದಿಯನ್ನು ಸಲ್ಲಿಸುವುದಾಗಿ ತಿಳಿಸುತ್ತಾ ಸದರಿ ವರದಿ ಮತ್ತು ಸ್ಕೆಚ್ ಲಗತ್ತಿಸಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಸರ್ವೆ ವರದಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಅನುಭವದ ಪ್ರಕಾರ ಶ್ರೀ ಪಾಂಡುರಂಗ್ ರಾಮಚಂದ್ರ ಇವರಿಗೆ ವಿಸ್ತೀರ್ಣ 1 ಎಕರೆ 18 ಗುಣ ಜಮೀನು ಹಾಗೂ ಕೇಂದ್ರ ಕಾರ್ಯಗ್ರಹ ಇವರಿಗೆ ವಿಸ್ತೀರ್ಣ 27/10 ಜಮೀನು ಪೈಕಿ 14 ಎಕರೆ ಪೋಟ ಖರಾಬ್ ಎ, 10 ಎಕರೆ 10 ಗುಂಟ ಪೋಟ್ ಖರಾಬ್ ಬಿ, ಬಾಕಿ ವಿಸ್ತೀರ್ಣ 26 ಗುಂಟೆ ಜಮೀನು ಇರುತ್ತದೆ. ಇದರಲ್ಲಿ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ ಹಾದು ಹೋಗಿರುತ್ತದೆ ಎಂದು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಇದಕ್ಕೆ ಶ್ರೀ ಪಾಂಡುರಂಗ್ ರಾಮಚಂದ್ರ ಹಾಗೂ ಕೇಂದ್ರ ಕಾರ್ಯಕರ ಅಧಿಕಾರರು ಒಪ್ಪಿ ಸಹಿ ಮಾಡಿರುತ್ತಾರೆ. They only agreed and signed the sketch and all. Thereafter, my lord, that is Assistant Commissioner order.
If according to the revenue records, if the petitioner had 28
acres, 28 gunta.
28 acres, 28 guntas in survey number 51.
Yes, ma'am.
Huh?
Please, ma'am.
And undisputedly 27 acres, 10 guntas were acquired.
Acquired.
Huh?
Yes,
There is
my lord.
still 1 acre, 18 guntas
That
left.
remains.
That is also acquired and kindly see para number 5 of the learning single
If you
judge.
acquired, you will have to produce the documents to show it is acquired and compensation is paid.
Page 51, my lord.
ಮುಗೀತಲ್ಲ ಅಲ್ಲಿಗೆ?
ಇಲ್ಲ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಜಜ್ಮೆಂಟ್ ಹಾಕಿನ ನಾನು page 51.
LAC appeal.
27 acres 10 guntas se compensation ಕೊಟ್ಟ.
Paragraph number 2, it is
Yes.
the case of the appellants that they were the owners of land bearing survey number 51/1, measuring 1 acre 18 guntas, and survey number 51/3, 53 acres 32 guntas, totally 27 acres 10 guntas.
So this much only acquired, 27.
What documents have you produced to show
Decree, my lord.
that the total extent of land was 28 acres, 28 guntas?
Page 38, my lord.
38.
Yes. My ROR. Standing in my name.
And the Tahsildar also has said,
Yes.
This Kharab
according to
land,
the records, it is 28 acres, 28 guntas.
yes, ma'am. That is not, Kharab is 24 guntas, my lord.
Huh?
24 guntas is Kharab land.
ಆಯ್ತು.
So that is, my lord, belongs to the, my lord, government. That is observation made by the learned single judge, my lord. Para number 5, my lord.
What about a decree?
The writ petition would indicate that land bearing number so and so Nandipur consisting of 28 acres, 28 gunta, wherein the land to an extent of 27 acres, 10 gunta has been acquired for the purpose of establishment of a central jail, and remaining extent of 1 acre, 18 gunta of the land stand in the name of the petitioner. However, pursue the records would indicate that 1 acre, 18 gunta of land has been utilized for the purpose of construction of the Kalaburagi Jevarigi main road. As such, remaining 1 acres 18 gunta stands in the name of the government. That's why, my lord, I am requesting your lordship, my lord, to produce these documents.
ಅರ್ಥ ಏನ್ರಿ?
Idರಲ್ಲಿ,
Ah?
unless, my lord, there is acquisition proceeding,
Ah.
but the government name cannot be entered. 1 acre 18 gunta, my lord.
Therefore, you either have to produce documents
Yes,
to
sir,
show
that's why.
not only 28, not only 27 acres, 10 guntas were acquired, the remaining 1 acre, 18 guntas were also acquired, and compensation has been paid.
Not that.
They specifically suffered a decree, my lord.
Adene.
ಇಲ್ಲ ಡಿಗ್ರಿನೇ 70th
Has been utilized for the purpose of construction of
road.
Kalaburagi, Jevargi main road ಅಂದ್ರೆ ಅರ್ಥ ಏನು?
Except Karab land, my lord. Maybe they standing in the name of the, my lord, including the Karab land, that 1 acre 18 gunta, including Karab land of 34 gunta. That is the, my lord, in the assistant commissioner order, my lord, that is, my lord, mentioned in the Karab land also 34 gunta.
ಖರಾಬ್ ಲ್ಯಾಂಡ್ ನೋಡಿ, ಎ ಖರಾಬು, ಬಿ ಖರಾಬು.
ಅದೇ ಅದು ಎರಡು ಇದಾವೆ ಸರ್.
ಎರಡು ಟೈಪ್ ಇದೆ.
B, my lord, he has no right to claim that one. Only A Karab land, my lord, he has right. But that's why, my lord, this, before the Honorable Single Judge, my lord, we have not produced any document by filing the statement. I am getting the instruction, my lord, to produce the document to show that, my lord, how, my lord, government land name is stand in the name of the, in the, to the extent of 1 acre 18.
ಬರ್ಕಂತಾರೆ ಸರ್ಕಾರದ್ದು
ಇದೆ,
ಅವ್ರು ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಕೊಂತಾರೆ.
Unless proceedings, unless proceedings, my lord, that cannot be, my lord, enter the name of the government.
My lord,
But there must be proceedings, my lord, for that is the reason. There must be some proceedings, my lord. On the basis of the proceedings only, my lord, enter the name of the government.
ಏನ್ ಟೈಪ್, what type of proceedings?
But that's why, my lord, I'll get the documents, my lord, enter records.
What kind of proceedings can be there?
Not, my lord, acquisition proceedings, formation of the Jevarigi road, but that will be, my lord, part of the record. Enter the name of the, my lord, government land.
Even if you say it is acquired and road is formed, ಅದಕ್ಕೂ compensation ಕೊಡ್ಲೇಬೇಕಾ?
ಅದನ್ನ ಕೊಟ್ಟಿದ್ದಾರೆ ಇಲ್ಲ ಅಂತ ನೋಡ.
If it is a different acquisition.
But if it is paid or not, that all documents will be produced before the court.
This statement of the learned single judge itself shows that it has been utilized.
Utilized in the sense, my
How
lord.
can you utilize without
That's why
acquiring the property?
after the proceedings, my lord, that was utilized. That is the meaning.
Tahsildar itself has given a report 82, my lord, page number.
ಏನ್ proceedings? What is this annexure G?
Sumran,
So it is only a communication made
yes.
to the assistant commissioner.
You,
But adರಲ್ಲಿ these facts are narrated.
he made the application for Tiddupadi, my lord. He given the application to the Tahsildar for correction of the entry in the records of right. Kind of see Vishaya, my lord. Kalaburagi ತಾಲೂಕಿನ ನಂದಿಪುರ ಗ್ರಾಮ so and so 28 acres 28 gunta ಜಮೀನನ್ನು ಪಾಣಿ ತಿದ್ದುಪಡಿ ಮಾಡುವ ಕುರಿತು. He only given the application.
ಯಾರು?
He petitioner.
ಎಲ್ಲಿದೆ?
This is the
In
application.
all the three reference, there is no such request made by the petitioner.
Without the documents. ವಿನಂತಿಸಿಕೊಂಡಿದ್ದರಿಂದ ಖಂಡಿಸಿರುವ ಪ್ಯಾರಾ ನಂಬರ್ 1 ಮಾಡುವಂತೆ get the records, my lord.
You have shown the degree of the court also, the learned single judge.
Unless, my lord,
Degree.
proceedings, my lord, we cannot use it.
And Tahsildar has also given a report that 1 acre 20 gunta is 82 page number, man.
They would not have participated in that suit proceedings.
Yes, probably.
Have they participated?
I will say.
Usually ನಮ್ಮ ಸರ್ಕಾರದ ನೌಕರರು ಯಾರಪ್ಪ ಬರೋದೇ ಇಲ್ಲ, ಸೂಟ್ಗಳು ಬರೋದೇ ಇಲ್ಲ, ಸಾಧ್ಯನೇ ಇಲ್ಲ.
ಎಕ್ಸ್ಪರ್ಟ್ ಇರ್ಬೋದು.
ಏನೇನು ಬರೀ ಹೈಕೋರ್ಟ್ ಬರ್ತಾರ ಅಷ್ಟೇ. ಸೂಟ್ ಅಲ್ಲಿ ಅವರೆಲ್ಲ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಲ್ಲ.
ಇಲ್ಲ ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ, AGP is appeared.
ಅಲ್ಲ ಅಪಿಯರೆನ್ಸ್ ಹಾಕ್ಬಿಟ್ರೆ ಆಲ್ದು ನೋ ಎವಿಡೆನ್ಸ್
Yes,
ಡಿಫೆಂಡೆಂಟ್ಸ್ ವರ್ ಪ್ಲೇಸ್ಡ್ ಎಕ್ಸ್ ಪಾರ್ಟೆ
yes.
ಅಷ್ಟೇ.
ಅದಾದ್ಮೇಲೆ continually we are, and even Tahsildar has made spot inspection. He has given a report.
Read that judgment of the Supreme Court in respect of one old lady.
Yes.
Vimla Bai versus State of
Please
Madhya
read that,
Pradesh.
Yes, yes.
Some 100 years,
Yes, my lord, that without, my lord, proper
Having
proceedings.
regard to Article 300A, it would be impermissible for the state to contend. ಇಲ್ಲ ಇಲ್ಲ ಅದು ಪಾಣಿ ನಮ್ಮ ಹೆಸರು ಬಂದ್ಬಿಟ್ಟಿದೆ ಕೊಡಕ್ ಹಂಗೆಲ್ಲ ಹೇಳಕ್ ಸಾಧ್ಯನೇ ಇಲ್ಲ. You have utilized a portion of the property belonging to a private person without acquisition proceedings, you will be forced to pay the compensation after determination.
Yes, that is true, my lord. So, my lord, I'll get the records, my lord, and place the same before lordship, my lord. If that is, my lord, all following the procedure, my lord, we use that land, my lord, then, my lord, he is not entitled at all.
Barkole. It is the contention of the appellant that even in terms of the revenue records, the total extent of land in survey number 51/1. ಬರೀ 51 ಅಂತಿದೆ ಇಲ್ಲಿ.
ಇಲ್ಲ, one. I'll, 51.
51
Ah.
is 28 acres, 28 guntas, including 24 guntas of kharab land. And admittedly, acquisition proceedings were initiated for construction of
Jail.
Central jail.
the central jail and 27 acres and 10 guntas of land were notified and acquired for that purpose. Full stop. The petitioner also does not dispute the fact that he has received compensation for the land acquired.
Yes, ma'am.
And in the LAC matter, this information is available.
Yes.
Full stop. However, in respect of the remaining 1 acre, 18 guntas of land, without acquisition, the same has been utilized by the respondents, and therefore the petitioner filed the writ petition seeking necessary directions to initiate acquisition proceedings and pay compensation in respect of the 1 acre and 18 guntas of land belonging to the petitioner, utilized by the respondents. Full stop. Attention of this court has been drawn to the RTC at annexure A, which shows that even as per the revenue records, 28 acres and 28 guntas are found in survey number 51. Full stop.
And there also a decree. Suit, man.
ಅದೇ 2003 ಅಲ್ಲಿ ಮಾಡೋದು ಡಿಗ್ರಿ ಅದು, ಬಟ್ ದೇ ಎಕ್ಸ್ಪರ್ಟೇ, ಬಟ್ ಅದಕ್ಕೆ ಇವ್ರು ಅದು ಏನು ಮಾಡ್ದಂಗೆ ಸುಮ್ಮನೆ ಕೂತ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಎಕ್ಸ್ಪರ್ಟ್ ಆರ್ಡರ್ ಅದು.
ಅದ್ರೊಳಗೆ ಮ್ಯಾಂಡೇಟರಿ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಪೇಜ್ 73.
Even according to the communication made by the Tahsildar.
Yes.
Kalaburagi Taluk at annexure G to the Assistant Commissioner it is clear that 1 acre and 18 guntas of land remained after acquisition of 27 acres and 10 guntas. Full stop. It is also stated in the communication that a national highway has been formed on the remaining portion of the land. Full stop. The respondents are therefore required to place all material to show how they are in possession of the remaining extent of 1 acre and 18 guntas, even if a national highway has been formed on the said extent of land. Stop. Next para. Release this matter on 7th of November.
Please.
43, Achinam Mahajan.
It's a direction to submit the report. The respondent was directed to submit report.
Again, report, please.
Copies. Court amount. Yeah.
Yes, ma'am. As per the direction we are conducted and
What is the property? What is the matter?
What has happened, my lord? Project displaced persons were allotted certain sites. The original
Sites.
yes, ma'am. The original allottee was one Shobha. Allotment in the name of Shobha was allotted in the year 1988, specifically on 2/8/1988. One particular site was allotted to one Shobha. In the year 2004, my lord, after a good, my lord, 10, 12 years, she sells the plot in favor of one Basavaraj. And my lord, after 1 year, I purchased the property, my lord, from Basavaraj. It is not as though, my lord, it is a overnight, my lord, allotment and then immediately a sale. I am a purchaser, my lord, of that particular plot. I am the petitioner before the learned single judge. And I have seen, my lord, that the Hakkupatra issued by the Tahsildar, it was standing in the name of the Shobha and then Basavaraj for quite some time, more than 1.5 or almost 2 decades. Then I ventured to purchase this property. I obtained construction permission, my lord. I have put up shops and everything. Another disgruntled, my lord, allottee, he files a complaint. That complaint, my lord, was taken for consideration by the deputy commissioner. Deputy commissioner passes an order cancelling both the Hakkupatras, my Hakkupatra as well as the Hakkupatra of the contesting private respondent who had made a complaint. That was challenged by me, my lord, in the writ petition, holding that the deputy commissioner
Allotment was made, allotment of the site was made by whom?
by, my lord, the KNNL in favor of, my lord, the project displaced persons. Now,
The land belonged to whom? The sites, yeah, the sites were formed by whom?
sites were formed by, my lord, the
Avare ಮಾಡ್ಕೊಟ್ರು.
there was a certain, my lord, the land was submerged. For those persons who have lost their land, certain sites were given.
ಗೊತ್ತಾಯ್ತು.
Now KNNL gives the site.
Usually they will not form the sites. But I don't know.
they will only form.
ನೀವೇ ಮಾಡಿದ್ರಾ?
ಇಲ್ಲ,
ನೀವೇ sites form ಮಾಡಿದ್ರಾ?
KNNL.
KNNL ಮೇಲೆ.
Yes, yes. You formed the sites. Yes. You allotted it. So in your records, you have the information that it was allotted to Shobha.
It was through the Tahsildar, my lord.
Allotment is made by the Tahsildar, not by the KNNL.
That is why
Formation, it was made by Tahsildar. my lord.
formation.
It was by
Will
Tahsildar.
not be formed by KNNL,
It was, my lord, the land belonging,
formed by the government.
I stand corrected, my lord, it was allotted by the Tahsildar.
Ah.
Then, my lord,
So in the records of the Tahsildar, information is available that it was allotted to Shobha,
yes,
and thereafter one person purchased and this person has purchased
Yes,
it subsequently.
Yes.
That information is available.
that information is
There is
available.
no dispute about that at all.
Yes.
Issue is that, my lord, as per the direction of this honorable court, petitioner is encroached the property of sixth respondent by encroaching the property of sixth respondent.
Sixth respondent
Sixth
is the
respondent.
neighbor.
Allala, now we are municipality.
Huh?
We are the municipality, my lord.
Sixth respondent is municipality.
Illa, fifth respondent is the municipality.
Then who is the sixth respondent?
Another allottee of another land,
Ah,
and this appellant herein has, my lord, in the garb of purchase of the property of that original grantee, he has now put up construction trespassing, encroaching this portion of property, which is
what
not
was purchased only was 30
30
into
into
40.
40. He has put up structures in that land which was allotted to the sixth
It
respondent.
has gone beyond 30, 40.
He has gone beyond. That is the dispute here. Nobody is disputing his title to that 30, 40.
So what happened to the spot inspection report?
Please,
That- yes,
I will
sir.
submit.
If the copy could be made available, my lord, I will.
Court permits, my lord, I will submit.
Kodri,
Na court, first court ge submit. I'll.
ಕೊಡಿ ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ. ಹಾ, ಏನ್ ಹೇಳ್ತಾರೆ ಅದ್ರಲ್ಲಿ?
My lord, may I read, my lord?
Yes.
ಇಂದು ದಿನಾಂಕ 29/8/2024 ಮುಂಜಾನೆ 10:30 ಗಂಟೆಗೆ ಬೀದರ್ ಜಿಲ್ಲೆ ಹುಮ್ನಾಬಾದ್ ತಾಲೂಕಿನ ಹಳಕೇಡ್ ಪುರಸಭೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿರುವ ಕಾರಂಜ ಪುನರ್ವಸತಿ ಯೋಜನೆ ವಾರ್ಡ್ ನಂಬರ್
ಅದೆಲ್ಲ ಬಿಡಿ.
ಲಾಸ್ಟ್ ಪ್ಯಾರ, ಮೈ ಲಾರ್ಡ್, ಕಂದಾಯ ಶಾಖೆ ಸಿಬ್ಬಂದಿಯವರ ಸಮ್ಮುಖದಲ್ಲಿ ವಿನ್ಯಾಸ ಸರ್ವೆ ನಂಬರ್ 7 ಮತ್ತು 8 ಅಂಗಡಿಗೆ ಖಾಲಿ ನಿವೇಶನ ಶ್ರೀ ಶ್ರೀನಿವಾಸ್ ತಂದೆ ತುಕಾರಾಮ್ ಇವರ ಪರವಾಗಿ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಬೀದರ್ ರವರ ತೆರೆದ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 7 ಮತ್ತು 8ರ ವಿಸ್ತೀರ್ಣ 13x40 ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡಿದ್ದು, ಸದರಿ ಹಂಚಿಕೆಯು ಮಾನ್ಯ ತಹಸೀಲ್ದಾರ್ ಹುಮ್ನಾಬಾದ್ ರವರ ಕಾರ್ಯಾಲಯದಿಂದ ವಿತರಿಸಿದ ಹಕ್ಕುಪತ್ರದಂತೆ ಶ್ರೀ ಶ್ರೀನಿವಾಸ್ ತಂದೆ ತುಕಾರಾಮ್ ಸಾಕಿನ್ ಡಾಕುಳ್ಗಿ ಇವರಿಗೆ ನಿವೇಶನ ಹಸ್ತಾಂತರಿಸಿರುವಂತೆ ಆದೇಶಿಸಿರುವ ಮೂಲಕ ಸದರಿ ಆಸ್ತಿಯು ಶ್ರೀಮತಿ ಸರಸ್ವತಿ ಗಂಡ ಭೀಮಶೆಟ್ಟಿ ಮೀನ್ಕೇರಿ ಸಾಕಿನ್ ಹಳಿಕೆಡ್ ಬಿ ಇವರು ಶ್ರೀ ಶ್ರೀನಿವಾಸ್ ತಂದೆ ತುಕಾರಾಮ್ ರವರ ಹೆಸರಿನಲ್ಲಿರುವ ನಿವೇಶನ ಅಂಗಡಿಯಲ್ಲಿ ವಿಸ್ತೀರ್ಣ 13x40 ಅಡಿ ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಇದು ಪಂಚರ ಸಮಕ್ಷಮ ಒತ್ತುವರಿಯಾದ ಅಂಗಡಿ ನಿವೇಶನ ಅಳತೆ ಮಾಡಿ ಒತ್ತುವರಿಯಾದ ಸ್ಥಳವನ್ನು ಕೆಂಪು ಬಣ್ಣದಿಂದ ಗುರುತು ಮಾಡಲಾಗಿದೆ.
So you have participated in the
Yes, my lord.
Right.
By issuing notice to the both the parties.
I have
and if it is found that you have put up construction beyond 30-40,
Lord, what is
you
the,
are liable to remove the.
I am liable, if that is the case, my lord, I am liable to remove. But if lordship kindly sees, except for the 30-40, my lord, there is no measurement. What is the size of the plot? What is the construction size? Entire stretch, what is the construction? There are no details are forthcoming.
ಏನ ಅಂಗಡಿಗಳ ಇದು?
Six
ಈಗ
shop
30-40 ನಲ್ಲಿ,
Huh?
if your lordship kindly, my lord,
Shops
peruses
are
the entire
constructed.
paragraph,
beyond the land.
there, it starts from a particular point, it ends at a particular point. This is the entire stretch of construction. In this construction, this is the encroached portion, and then one can ascertain. Appear, my lord, the report, my lord, appears to be, my lord, not complete. Anyway, my lord, I am permitted, my lord, to go through the report, my lord, have a word with my client and my lord, then make.
ಏನ್ರಿ ಹಿಂಗೇನ್ರಿ ಪ್ರಿಪೇರ್ ಮಾಡೋದು ರಿಪೋರ್ಟ್?
ಪ್ರಾಪರ್ ಆಗಿ ಮಾಡಿ ಸರ್.
ಹಾ?
ಎಷ್ಟಿದೆ ಅದನ್ನ?
See, if you are to find out whether this person has encroached, you have to give the full picture.
Yes.
ಏನು, what is the
Total measurement.
if it's found in one road, what is the measurement of the properties there? ಇವ್ರದ್ದು ಎಲ್ಲಿ ಬರುತ್ತೆ, ಅವ್ರಿಗೆ ಅಲಾಟ್ ಮಾಡೋ ಸೈಟ್ ಎಲ್ಲಿ ಬರುತ್ತೆ, ಎಲ್ಲ ಪೂರ್ತಿ ಇನ್ಫಾರ್ಮೇಶನ್ ಶುಡ್ ಬಿ ಮೇಡ್ ಅವೈಲಬಲ್. ದಿಸ್ ಇಸ್ ನಾಟ್ ದಿ ವೇ. ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡೋದು ಅಂತಂದ್ರೆ, ಇಫ್ ದೇರ್ ಆರ್ ಮೋರ್ ದೆನ್ ದಿ ಪಾರ್ಟೀಸ್ ಹಿಯರ್, ಒಂದು ಬಾಜುವಲ್ಲಿ ಇನ್ನೊಬ್ರು ಯಾರೋ ಪಾರ್ಟಿ ಇರ್ತಾರೆ, ಇವ್ರ ಬಾಜುವಲ್ಲಿ ಇನ್ನೊಬ್ರು ಯಾರೋ ಪಾರ್ಟಿ ಇರ್ತಾರೆ, ಆಲ್ ಆಫ್ ದೆಮ್ ಶುಡ್ ಬಿ ಕಾಲ್ಡ್. Proper measurement should be taken. as to what is the site allotted to this person. 30-40 ಎಲ್ಲಿದೆ, ಅದ್ರ ಪಕ್ಕ ಏನ್ ಪ್ರಾಪರ್ಟಿ ಇದೆ, ಇವ್ರ ಪಕ್ಕ ಇರೋ ಪ್ರಾಪರ್ಟಿ ಯಾರ್ಗ್ ಅಲಾಟ್ ಆಗಿತ್ತು, ಇವ್ರಿಗೆ ಅಲಾಟ್ ಆಗಿತ್ತಾ, all information should be available.
This honorable court notice on 31st of July has in fact stated that the inspection has to happen with reference to the boundaries in the sale deed.
Correct.
I don't know if
I read that. I read
If-
that.
if this
That is
report
why I
shows
asked
that
you
it
what
is-
happened to this spot
Was not
inspection report.
properly,
We are not given the copy.
Huh?
was not
This is
properly.
not the way a spot inspection report has to be submitted. Barkole. Who has done this? Tahsildar,
Chief Officer,
Chief Officer.
Municipal. Fifth respondent.
This sixth respondent is your neighbor?
One submission I may be permitted to make, my lord. The plot number, my lord, in the Hakkupatra is not reflecting. And the earlier round, my lord, his Hakkupatra itself is cancelled. He has not challenged that order.
This honorable court has, my lord, set aside and remanded the
I'm-
matter.
I'm-
Then the order is now passed, which he is agreed by and filed
no,
as
no.
petition.
No, I had approached the honorable court, my lord, insofar as my Hakkupatra is concerned, my lord, that order was set aside. It was sent back, my lord. He never questions, my lord. The locus standi, my lord, of this respondent, matter, my lord, requires, my lord, consideration. My respectful submission is, in detail, my lord, I have produced all the documents. What I am agreed by, my lord, by the order passed by the Learned Single Judge, my lord, gist of the matter, I may be permitted. I am directed to approach the civil court.
There is no doubt that you have purchased
Yes,
40 into 40
yes,
site.
yes.
But if you have put up construction beyond 30-40 site,
Lord, I am certainly will
you
not
are
be,
liable
yes,
to
I will certainly not be in a
demolish
position to-
the,
yes. I will not be, my lord, in a position to justify my,
and
yes,
you also are required to leave the setbacks.
that is true, my lord. That is true. That is true, my lord. There cannot be any dispute with respect to that.
My lords may also see that in the earlier round of litigation where the earlier person, predecessor of the appellant herein filed the writ petition, this honorable court kindly see at page number 104 annexure M. At page number 117 and 118. Learned Single Judge had directed my lord to hold a fresh inquiry by issuing notice to all. Then, my lord, that inspection and everything has happened once. Now, this is only.
No inspection had happened. No inspection had happened. Kindly.
This is now almost the third round. my lord.
No.
He wants an inspection at the hands of this honorable.
Probably the
court.
learned senior counsel, my lord, is not appraised regarding the factual aspects. No physical inspection or, my lord, was done on the ground.
Kindly
I'm
see page
sure about that.
117 and 118. At page 117 at the last note, in this background, second respondent deputy commissioner is required to examine as to whether plot number 4, which was allotted in the year 1988, can be taken as an allotment under the scheme. Thereafter, take appropriate action in respect of other 3 plots, which are secured by third respondent family. All these aspects are to be examined by the deputy commissioner.
Insofar as the merits of the case, my lord, the matter, my lord, my humble requires consideration. Insofar as this allegations of encroachment is concerned, my lord, there has to be a proper report.
Now, my lords may see the learned single judge has in fact said, has recorded that to say that you are within your boundary or there is no encroachment, whatever, your remedy is to go before the civil court. That's the only order part. So, my lord, if he wants to agitate all his civil rights here, it is not his case that he is entitled for, my lord, anything. We are not disputing.
You filed the writ petition.
My lord, I filed the writ petition, challenging the order passed by the deputy commissioner.
ಏನ್ order?
Hakkupatra, the Hakkupatra which is issued in favor of.
They sought to cancel it.
That is, my lord, cancelled. And my
Not,
lord, yes,
to cancel the original
yes,
Hakkupatra.
yes. And after that,
in favor of
yes,
your
yes.
vendor's vendor.
yes, that is cancelled. And my lord, without, my lord, setting aside the order passed by the deputy commissioner, I am, my lord, directed to go and approach the civil court. My plaint will be rejected on the day 1. Because my entire rights are based on the Hakkupatra.
For the learned single judge held that it would not be possible to permit them to cancel it now at this stage.
No, learned single judge, my lord, does not disturb the order of, my lord, cancelling the Hakkupatra. and directs me to, my lord, to go to the civil court. In the absence of Hakupatra, which is my title document, I will have no legs to stand before the civil court.
Please read paragraph number 11, page number 116.
The operative portion of the order, my lord.
Page number 11, sorry, para 11. Para 11.
Page 116 is an earlier round of litigation.
But there are certain facts there. Please read that paragraph number 11.
Paragraph number 11, my lord, in WP number.
Page
2.
116, sir.
Please, I'm sorry. The authorities are required to examine whether the allotment made in favor of respondent number 3 in the year 1988 can be revoked at this stage. In the present case on hand, this court is of the view that the action is grossly delayed and the action is said to be initiated beyond the reasonable time, particularly in view of the fact that the allotted plot was transferred several times during this period. Obviously, in the faith that it is not encumbered by rights, the authorities are required to take action within reasonable time, and this time must be reckoned reasonably, not only by the order, not only in order to preserve the rights and advantage of a party, party possesses, but equally to protect each party from losses he ought not to suffer. Thus, when an action is sought to be taken after inordinate delay, it has to be examined from the point of view of the party who might suffer losses, though he is not directly responsible warranting actions. However, the family of the third respondent is entitled for allotment of one plot, and the material placed by the Tahsildar indicates that there are other 3 plots which are allotted. In this background, the second respondent deputy commissioner is required to examine as to whether the plot number 4, which is allotted in the year 1988, can be taken as an allotment under the scheme, and thereafter take appropriate action in respect of those 3 plots which are secured by the third respondent family. All these aspects are to be examined by the second respondent deputy commissioner, bearing in mind the third part that the third party rights are created, and after securing permission from the competent authority, the petitioner has put up construction. The second respondent deputy commissioner requires to redo by holding fresh inquiry by issuing notice to all the interested parties to take appropriate action thereon. So, my lord, my rights are protected by holding that, my lord.
Respondent number 3 there.
My lord, I am the petitioner in that case.
Petitioner. And they sought to cancel the allotment
Yes.
of respondent number 3.
No, cancel, my lord, my allotment.
Respondent number 3 ಅಂತ ಹೇಳ್ತಾರಲ್ಲ.
ಅಲ್ಲ, ಅವ್ರ allotment cancel ಆಯ್ತು, ನಮ್ಮ allotment cancel ಆಯ್ತು.
Number 3 is vendor.
Now, Honorable, my lord, the learned single judge, my lord, my lord, the tenor of the order, if your lordship kindly sees, is to make an inquiry. The allegation was, sir,
My lord,
permit me.
clarification, my lord.
Permit
Respondent
me.
number 3 was Shobha, his own vendor.
Yes.
Ah.
Now, the tenor of the order, if your lordship kindly
So
sees.
you were not a party at that point of time.
I was a party, my lord. I was the petitioner.
Saraswati.
Saraswati, my lord, is the petitioner, appellant herein and the petitioner in that writ petition. Since, my lord, there was a direction in that writ petition to include, my lord, my vendor and my vendor's vendor, my lord, they were brought on record as Shobha and, my lord, Basuraj.
All these sites were allotted by the Tahsildar.
By the Tahsildar.
To the project displaced persons.
Project displaced persons.
Shobha also claimed as a project displaced person.
Yes.
This Srinivas
Yes.
or Tukaram, his father, also claims as a displaced person. Is it correct?
Yes.
Mr. Government Advocate.
Subsequent to this, my lord, there is one more fact I want. Kindly see page 142. This is the joint inspection report submitted by the Tahsildar, the ADLR, Assistant Commissioner, and the Executive Engineer of KNNL. All the 4 officers are here. They give a joint inspection. It is not that there was never a joint inspection of the spot. This is at page 142.
And what is the outcome?
That is, kindly see at the page 142. They say, ಅನಧಿಕೃತವಾಗಿ ಒತ್ತುವರಿ ಆಗಿರುತ್ತದೆ ಎಂದು ಜಂಟಿಯಾಗಿ ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ. Last line. He has encroached that.
Encroached ಅಂತಂದ್ರೆ ಇವಾಗ ಇವತ್ತು ಹಾಕಿರೋ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ 13x40 ಅಂತಾರೆ. ಅಂದ್ರೆ ಬಿಯಾಂಡ್ ದಿಸ್ he has encroached about 13 feet.
That is the only case. We are not disputing his title to 30x40 which he has purchased from Shobha.
ಮತ್ತಿನ್ನೇನ್ರಿ?
And
What
this
is
report
left?
also says that there is an unnumbered
If
law.
admittedly you
Yes,
have gone beyond your entitlement,
My lord,
then you are
yes, my lord, yes.
required to remove it.
There cannot be any quarrel on this point.
ಅಷ್ಟೇ.
There cannot be any quarrel. Let there be a proper, my lord, inquiry on the ground. This cannot be, the report cannot be, my lord, accepted, my lord, the manner in which it is presented before your lordship.
They were, the parties were present, my lord.
If I may request your lordship to kindly record the submission made, my lord, it may be placed on record.
That order has been set aside. The order of the deputy commissioner has been set aside.
It has not been set aside, and I am directed to formulate the civil court by the learned single judge. Now, the whole grievance, my lord, is in the light of the fact that once the Hakupatra itself, my lord, is set aside, what, my lord, right do I have, my lord, to go and approach the civil court?
Which is the order?
Page 143.
That is the latest order.
My lord, the latest order, my lord, is at 18, page number 18, my lord.
18. So you have put up 6 shops.
I have put up 6 shops.
You were agreed of the order dated 23/1/2024. That is passed by the deputy commissioner.
Yes, wherein, my lord, my Hakupatra itself is
Where is
cancelled.
that?
Operative portion 145.
Annexure V.
The order is based on earlier inspection report.
That is only in respect of the encroached portion. The order of the deputy commissioner also is regarding the encroached portion only.
No, the deputy commissioner, my lord, cancels the Hakupatra, my lord.
No. To remove the encroachment ಅಷ್ಟೇ, to hand it over to sixth respondent. ಪೀಠಿಕೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅಧಿಕಾರಿಗಳ ಜಂಟಿ ತನಿಖಾ ವರದಿಯನ್ವಯ ಶ್ರೀಮತಿ ಸರಸ್ವತಿ ಅವರು ಶ್ರೀನಿವಾಸರವರಿಗೆ ಹಂಚಿಕೆಯಾದ ನಿವೇಶನದಲ್ಲಿ ಅತಿಕ್ರಮಣ ಮಾಡಿರುತ್ತಾರೆ. ಕಾರಣ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಯವರು ಸದರಿ ಅತಿಕ್ರಮಣವನ್ನು ತೆರವುಗೊಳಿಸಿ ನಿವೇಶನವನ್ನು ಶ್ರೀನಿವಾಸರವರಿಗೆ ಹಸ್ತಾಂತರಿಸುವಂತೆ ಈ ಮೂಲಕ ಆದೇಶಿಸಲಾಗಿದೆ. There is no cancellation of your.
Before that, my lord, page number 144, my lord, second paragraph from below. ಸದರಿ ಕಟ್ಟಡದಲ್ಲಿ ಈತನ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಪರಿಷ್ಕರಣಾ ಅರ್ಜಿದಾರರಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಕಾರಂಜ ಯೋಜನಾ ಭೂಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆ ಭೂಸ್ವಾಧೀನ ಕಾಯ್ದೆ 1984 ಕಲಂ 4(1) ಹಾಗೂ 6(1) ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಶ್ರೀಮತಿ ಶೋಭಾ ತಂದೆ ದೋಂಡಿಬಾ ಇವರ ಮನೆ ಮುಳುಗಡೆಯಾಗಿದ್ದಿಲ್ಲ. ಆದಾಗ್ಯೂ ಕೂಡ ಇವರಿಗೆ ಸುಳ್ಳು ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿ ಸದರಿ ಅವರಿಗೆ ಮನೆ ಕಾರಂಜ ಯೋಜನೆಯಲ್ಲಿ ಮುಳುಗಡೆ ಆಗದೆ ಎಂದು ಸದರಿ ಶೋಭಾ ರವರಿಗೆ ಕಾಯ್ದೆ ಬಾಹಿರವಾಗಿ ಡಾಕುಳ್ಕಿ ಗ್ರಾಮದಲ್ಲಿ ಪ್ಲಾಟ್ ಸಂಖ್ಯೆ 4 ಅನ್ನು ದಿನಾಂಕ 2/8/1988 ಹಕ್ಕುಪತ್ರ ಮಂಜೂರಿಸಿ ವಿತರಿಸಲಾಗುವುದು ಕಾನೂನು ಬಾಹಿರವಾಗಿರುತ್ತದೆ.
ಇರ್ಬೋದು. But the deputy commissioner will have to state under which power he is trying to cancel this allotment. And ultimately, in the operative portion, nothing has been said regarding cancellation of the allotment. It is only to remove the unauthorized encroachment.
Let there be a proper, my lord, inquiry on the ground, my lord, so that it can be resolved.
Yes, sir. Then it counsel.
In fact, one of the original grantee, Shobha, she has, her entire family was entitled to only get one allotment. There are 4 or 5 persons of that family who are seeking allotment. That is what is referred there. Luckily, my lords, for him, that is not cancelled.
No, no, to my good fortune, my lord, this is the first allotment.
Huh?
To my good fortune, this is the first allotment. All the other allotments are subsequent to this allotment. If the other,
Kindly see page number 165.
it is always, my lord, entitled family, my lord, will be, should be, my lord, the first allotment should be protected.
In terms of the directions passed by this court on 31/7/2024. Taking into consideration of this one, sir. Learned counsel. Next one, for respond number 5, TMC, Allikeda B has filed a report along with photographs. Stop. Copy of the same is served on the learned counsel for petitioner as well as learned counsel for respond number 6. Full stop. However, on going through the clear ಆಗಿ ಇದೆಯಲ್ರಿ 13 into 40 feet you have encroached ಅಂತ.
My lord, there has to be a, my lord, measurement of the entire stretch. This is, my lord, the property, he has exceeded to this extent, my lord, there has to be some explanation.
Page 142 is the inspection report, my lord, that is not overcome by the appellant here. Any proceeding till now.
That is still more defective. This,
You
this
are aware.
Even challenge.
You are aware that you have encroached on the neighboring property. How many times asked for
that report, if your lordship kindly see, is at least in this, my lord, at least the measurement is shown.
I said,
In that report, there is not even measurement is shown.
speaking, you will have to leave setbacks also. If you ask for further directions like this, we will be constrained to direct them
That is true.
to ensure that even setbacks are left.
Lord, I'll do one thing, my lord. I'll personally visit the spot, my lord, and take the, my lord, the stock of this situation.
ಮಾಡಿ ಯಾಕಂದ್ರೆ ನಾವು ಮತ್ತೆ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ರೆ ನಾವು we will give these kind of direction where you will have to further suffer.
My lord, I'll
Of you. You also will not be able to put up construction like this. ಪೂರ್ತಿ 30-40 construction ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
6, respond 6. But this annexure T is, my lord, by the 4 authorities, my lords. They have stated that, my lord, there is an approach.
The learned counsel for the petitioner. Appellant. Appellant. Seeks for a short accommodation to secure instructions and make submissions. Full stop. Next para. In the report, it is stated that the petitioner has encroached upon 13 into 40 feet beyond the actual entitlement of the petitioner, whose property measures 30 into 40 feet. Full stop. Next para. Release this matter on 5th of November.
Please. Thanks, my lord. Highly obliged, my lord, for the gracious consideration.
Seal number 44, Rajesh Daddamani. Seal number 44.
That is called out. There is no representation for the appellant. List this matter on 11th of November. Mikidikella date put.
Those matters where even your lordships have heard
Batch
and
matters.
how this,
ಏನದು?
ಅದರಲ್ಲಿ regarding the primary schools, graduate primary school teachers recruitment notification.
Huh?
Regarding 371J notification and the residual parent care. The Jacob Patel sir has appeared and made a submission. In fact, other side has not us to reply.
ಅದೇ
No.
ವಿಜಯ್ ಕುಮಾರ್.
With my lord's kind permission, my lords.
Ah.
My lords, are directed us to verify whether it is possible to accommodate the candidates from one district to another. Lord,
Yes.
it appears this issue is already considered in another matter in writ appeal number 305/2023 by your Honorable High Court, my lord. That matter is disposed of. Though that issue, no finding was given,
that very matter is subject matter of an SLP in the Supreme Court, my lords. And I have furnished a copy of the application statement of objections. I request my learned friend, the government advocate, to place it before my lords now. Page number 6, my lords. May draw my lords' kind attention to the additional affidavit which we have filed in another matter. Page number 6 of that affidavit, my lords. I'd like to draw my lords' attention to 13C, which is the second last paragraph. Please, my lords. May I read it, my lords?
Yes.
Please. It is also submitted that since different notifications were issued for each of the 35 districts, the districts referred to here are educational districts, my lords. Candidates who have applied in one district cannot be considered in another district merely because vacancies may be available in the other district. Well, the stand taken by the state in this particular case is that the recruitment is district wise. So application is also invited as for each particular district. So candidates who make an application for to appear for an exam and to seek to be selected in a particular district can be considered for appointment only in that district and none other, my lords. So this stand we have taken, we placed it on an affidavit, and my lord, this is a state stand. We cannot go back on that, my lords. And anyway, my lords, further I'd like to submit, my lords, that is not their case before the tribunal. That is not their case before my lords also. That is not their prayer also. They have not challenged the notification, nor any such condition has been challenged in their writ petition or the application. So my humble submission is the matter may have to be heard on merits. A date may be fixed, my lords.
See, Mr. Additional Advocate General.
Please.
The learned senior counsel made that submission only to reduce the extent of damage that could be caused if this court were to consider the action of the state in going on changing the rules during the process of recruitment.
Please.
The law is well settled.
Please.
That you cannot change the rules during the course of the game. Once the rule is set, you will have to play only as per the rules.
Please.
But in spite of that, they are saying, all right, you have made several changes only to benefit the candidates under 371J. It's all right. We are not worried about that. But to the extent that you are now trying to restrict the claim of the petitioners, that they will be considered only where they wrote the examination in that district. That will operate too unfavorably against them.
My humble
that is
submission
why
is,
they have made that submission.
Please.
If
I
you
understand.
want
About
the-
my lord.
If you want this court to consider on merits, there is no difficulty.
Please.
They will raise this issue that you have changed the rules of the game again and again.
Please, please.
Which is not
Please.
permissible in law.
That is their case, my lords. We have addressed that issue in the tribunal and we have succeeded, my lords. It is the similar matter is pending before the.
ಅವ್ರಿಗೆ ಬೆನಿಫಿಟ್ ಕೊಡಬೇಕು ಅಂದ್ಬಿಟ್ಟು ನೀವು ಅಷ್ಟೊಂದೆಲ್ಲ ಚೇಂಜಸ್ ಮಾಡಿ ಪಾಪ
ಇಲ್ಲ ಖಂಡಿತ ಇಲ್ಲ ಸ್ವಾಮಿ ಆತರ ಇಲ್ಲ ಕಾನೂನು ಆತರನೂ ಇಲ್ಲ. We'll be able to demonstrate that there is no.
Consider this request made by them.
ಅಲ್ಲ
participation only in the district where they wrote the examination. ಅಷ್ಟಾದ್ರೆ ಸಾಕು. That benefit is more than enough for them.
ಅಲ್ಲ, see, my humble submission is we have already taken a stand that cannot be done. If that has to be there has to be a relook on that, my lord. It will have to be a policy decision by the state. On 4 hour time kodi swami. Now I'll write to the government again, and in view of the observations made by my lord, I'll find out if it's possible for the government to consider such a request.
That is what we said in our previous order.
ಅಲ್ಲ ಲಾಸ್ಟ್ ವೀಕ್ ಆಗಿದ್ದು. ಲಾಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ತಾವು ಟೈಮ್ ಕೊಟ್ರಿ. ಅದಕ್ಕೆ I found out that they told me that we've already taken a stand in another matter where such a similar issue, such a ground was raised.
There is nothing wrong. You may say, yes, we have taken this kind of a stand. There is no.
It's under the same recruitment notification for the same recruitment under the same notification.
In the judgment that you read out, that was also read out by the learned senior counsel that day. It was rendered by His Lordship Justice Sanjay Gowda, isn't it?
ಇಲ್ಲ no, my lords. I have not placed reliance on
the judgment.
ಇಲ್ಲ ಇಲ್ಲ, ನಾನು ಜಡ್ಜ್ಮೆಂಟ್ ಓದಿಲ್ಲ ಸ್ವಾಮಿ.
ಇವಾಗ ನೀವ್ ಯಾವ್ದು ಹೇಳಿದ್ರಲ್ಲ
ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದು ನನ್ನ ಅಫಿಡೇವಿಟ್, ಸ್ಟೇಟ್ಸ್ ಅಫಿಡೇವಿಟ್.
ಇದಲ್ರಿ, ಬಿಫೋರ್ ದಿಸ್ ಯು ಸೆಡ್ ಇಟ್ ಹ್ಯಾಸ್
ಹ್ಮ್.
ಆಲ್ಸೋ ಬೀನ್ ಕನ್ಸಿಡರ್ಡ್ ಇನ್ ಅನದರ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
No, that is a division bench judgment, my lords. Division bench judgment, division bench judgment.
ಯಾವ್ದದು?
Division bench judgment in writ appeal number 305 of 2023.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯೇನ್ರಿ?
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೆ. ಇನ್ನೊಂದು ಪಿಟಿಷನ್ ಇದೆ ನೋಡಿ, ಇನ್ನೊಂದು ರೆಡ್ ಪಿಟಿಷನ್
ಕೊಡ್ರಿ ಇದ್ರೆ.
ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಆಗಿ
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯೇನ್ರಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವರು which judgment they are referring here.
305.
My lords may be correct, my lords, in the sense that the writ appeal 305 of 2023 is a matter pertaining to this particular recruitment notification. His Lordship Justice Sanjay Gowda's matter, it is in relation where a challenge was to Article 371J appointment by to KPCL. I am not placing reliance on that judgment at all, my lords. I am not placing reliance on that judgment at all. ಅವ್ರದ್ದು ಇದೆ ಸ್ವಾಮಿ, my lords are correct, my lords are right. Our judgment is there in relation to Article 371J. And that judgment also is subject matter of a writ appeal, my lords, which is also pending consideration.
Government advocate, please serve a copy of that judgment on the learned counsel. Let them also go through that one. Please serve a copy on the court.
Please.
Let us see.
Allah, my lords, I am not placing any judgment with regard to the request made by the petitioner's counsel. No judgment I am placing before my lord, my lord. I am stating that this is the stated stand of the government. I could fish out these papers.
ಗೊತ್ತಾಯ್ತು. We also want to see what is that judgment that you were referred to earlier. That a judgment has been rendered in this regard ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ನೀವು.
No, my lords. My lords, I beg for my lord's forgiveness. This matter, this issue came up. This issue was considered, but the final order was passed only with regard to jurisdiction, where the Honorable Court held that the appropriate forum would be the tribunal. That matter is subject matter of SLP. That order of the division bench was challenged before the SLP, and that matter is still pending consideration. My lords, my humble submission is my lords could pass an order with regard to this particular issue. If my lords were to consider this as a separate issue and pass orders, my lords, yes, we will be bound by it. But as on today, the stated stand of the state is that it is impermissible because the recruitment notification itself refers to each district separately. That's all that I am making submission, my lords. I am not saying that we are not ready to consider or we will not consider. If my lords direct us, we are bound to consider.
We have said so in the previous order.
ಅಲ್ಲ, ಅವ್ರ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಅವ್ರು ಅಟ್ಲೀಸ್ಟ್ ಅಮೆಂಡ್ ಆದ್ರೂ ಮಾಡ್ಲಿ ಪೆಟಿಷನ್. ಪ್ಲೀಡಿಂಗ್ಸ್ ಇಲ್ಲ, ಅಪ್ಲಿಕೇಶನ್ KT ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ, ಹೈಕೋರ್ಟ್ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲೂ ಇಲ್ಲ, ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ನಮ್ ನೋಟಿಫಿಕೇಶನ್, ಸುಮ್ನೆ ಒಂದು ಆಡ್ ಸಬ್ಮಿಷನ್ ಇಸ್ ಮೇಡ್.
No. We have said learned senior counsel Shri Jaykumar S. Patil appearing on behalf of the petitioner submits that although the petitioners are aggrieved of the action of the respondent state in issuing notifications after notifications, changing the rules during the course of the recruitment process, nevertheless, their immediate grievance is regarding a clause imposed in the later notification restricting the rights of the petitioners for selection only in the districts where they have written the examination.
Please.
ಇದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ we have said.
ಅಲ್ಲಲ್ಲ, let them make it up. My humble submission is, if that is the request from the court, let them place it on record. We will file our objections. On that case, I could request the state to file their objections. My lords could adjudicate the matter on that issue also.
It is not the question of your filing objections, sir. You will file objections to the entire writ petition, not about this one. The submission.
4 weeks time kodi swami.
So that it will enable the state government to reconsider only this aspect of the matter.
There will be cascading effect
by issuing notifications after notifications.
Illa swami, my humble submission, that is not true. If we will be able to demonstrate that is untrue, there is only one change in the notification, and that also does not amount to a change. I will be able to demonstrate. We have only followed the law. We have only followed the law through and through, my lords. We will be able to clearly demonstrate
and I'm convinced, I'm hopeful that we will be able to convince my lords that the state standard is being constitutional and legal. Besides that, my lords, with regard to this issue, because my lords have directed us, I am duty bound to bring it to notice of the state government again. I will implore the authorities to have a relook, but the difficulty would be, my lords, other districts where other recruits or applicants are there, their rights also will be affected if we try to take one set
Sir,
of
how it will
candidates.
be affected, sir? You have given them enough and more room.
ಅಲ್ಲಲ್ಲ ಎಚ್ ಕೆ ಅಲ್ಲ, ಇವ್ರು ಕೇಳ್ತಿರೋದು ಬೇರೆ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಅಲ್ಲಿ, ಔಟ್ಸೈಡ್ ಎಚ್ ಕೆ ಏರಿಯಲ್ಲೂ ಕೇಳ್ತಿರ್ತಾರೆ. ವೇರ್ ಎಚ್ ಕೆ ಇಶ್ಯೂ ಇಸ್ ನಾಟ್ ಅಟ್ ಆಲ್ ದೇರ್, because they have more marks than some other students in Mandya, they may seek appointment there. ಅಲ್ಲಿ ಮಂಡ್ಯಲ್ಲಿ ಎಚ್ ಕೆ ಇಶ್ಯೂ ಬರೋದೇ ಇಲ್ಲ. ಲೋಕಲ್ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಅಡಿಷನಲ್ ಲಿಸ್ಟ್ ಪ್ರಿಪೇರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಫಾರ್ ಸೆಕೆಂಡ್ ಇನ್ ರ್ಯಾಂಕ್, ಥರ್ಡ್ ಇನ್ ರ್ಯಾಂಕ್ ಅವ್ರು ಪ್ರಶ್ನೆ ಮಾಡ್ತಾರೆ.
These people have already written examination in a district where they are not actually residing.
They can choose any district.
Your notification. They have gone by your notification.
They have come to,
they have sought to make the best use of the opportunity that was initially granted. ನೀವು ಆಮೇಲೆ ಅವ್ರು ಚೇಂಜ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ, ನಾವು ಚೇಂಜ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. They have misread it. ನಮ್ಮ ಸಾಫ್ಟ್ವೇರ್ ಅಪ್ಲಿಕೇಶನ್.
We have understood the grievance of the petitioners. If you want to take this opportunity and they are secure instructions and make submission, you please make it. We have already passed such an order.
Sorry, I would pray for 4 weeks time in that case.
4 weeks, sir. 4 weeks ಹೆಂಗಾಗುತ್ತೆ? Not possible. 4 weeks we will decide the matter itself. There is no difficulty for us.
Please.
And one more submission that we have filed the memo along with the tabular form that where the petitioner's rights were prejudiced due to the change. In elaborate, we have filed it because of already we mentioned it in the ground. Again, we filed it to elaboration.
May I seek my lord's indulgence? May I seek my lord's indulgence for a moment, my lords?
Yes.
My lords, here is a case, in brief, here is a case, 100 seats are there, hypothetically. Please, my lord, let's leave the HK issue aside. 100 seats are there, 50% of the seats are reserved. Candidates who come under the reserved category have secured more marks, and they should be given seats in the merit category, open category. What has happened initially, they have asked people, where do you want to go? Which category do you belong to? They would have written so and so. So first rank student from a particular reserved category is placed in that category itself, which is opposed to the directions of the Honorable Supreme Court. My lords have also consistently held a candidate who secures higher mark first has to be filled in the open list. After the open list is filled, reserved categories are filled later. That is the settled principles of law. That is the constitution. ಇಲ್ಲಿ ಏನಾಗಿದೆ, ಇಲ್ಲಿ ಇವ್ರಿಗಾಗಿರೋ ಪ್ರೆಜುಡಿಸ್ ಇಷ್ಟೇ ಸ್ವಾಮಿ. ಇವ್ರಿಗಾಗಿರೋ ಪ್ರೆಜುಡಿಸ್ ಬೇರೆ ಏನಿಲ್ಲ, ರೂಲ್ಸ್ ಚೇಂಜ್ ಮಾಡಿಲ್ಲ. ಇಲ್ಲಿ ಕಲ್ಯಾಣ ಕರ್ನಾಟಕ ಏರಿಯಲ್ಲಿ ಇಲ್ಲಿ ಹುಡುಗರು ಓದೋದಕ್ಕಿಂತ ನಾವು ಚೆನ್ನಾಗಿ ಓದ್ತೀವಿ ಅಂತ ಹೋಪ್ಫುಲ್ ಆಗಿ ಬಂದಿದ್ದಾರೆ. there is no difficulty with that. Local students have scored more marks than them and secured seats in the open category. That is why they are saying no, that cannot be done, because we were under the impression that open category is meant for non-locals only. So ಅದರಿಂದಾಗಿ we have been prejudiced. ನಾವು ಬೇರೆ ಕಡೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ಕೇಳ್ತೀರಾ. That is their case. ಇದನ್ನ ಮತ್ತೆ ರೂಲ್ಸ್ ಚೇಂಜ್ ಮಾಡಿರೋದು, ಮತ್ತೆ ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿರೋದು ಎಲ್ಲ ತಪ್ಪು ಸ್ವಾಮಿ. ಅದು ತಪ್ಪು, ಆ ಥರದ್ದು ಏನು ಇಲ್ಲ. ಬೇಕಾದ್ರೆ I'll be able to clearly demonstrate.
We have recorded that one and we have said you have sought for some time. I don't know anywhere that day, I don't know whether you were able to at least, but you should have downloaded this order and you should have seen it.
ಅಲ್ಲ, ನಾನು ನೋಡಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಅದರಿಂದ that is why I placed this.
That is the only submission that we have recorded.
ಅಲ್ಲ ಸ್ವಾಮಿ, I understand my lords. I want to show my bona fides. I have taken extraordinary pains to locate this document from another disposed of matter and I am placing it before my lords. This is the stand of the state. I will again request the authorities to have a relook if possible, and if the authorities are agreeable, I'll place the same before my lords, my lord. Otherwise, this could be treated as another issue in the matter, and the matter could be heard finally is my submission, my lords.
Having regard to the observations made by this court in the previous order dated 15/10/2024, the learned additional advocate general is once again requested to secure instructions and make submissions.
Please
release this matter on
11th, my lord.
11th of November.
Please oblige.
Bill number 58, my lords, on submission.
Kella date ಕೊಡ್ತಾರಪ್ಪ, we can't do anything.
ಅಲ್ಲಲ್ಲ,
Last time argument ಆಗಿದೆ. Kindly my lords, sir. Short date may be.
Date ಕೊಡ್ತಾರ್ರಿ ಅವರು. That's what we said.
ಸರಿ ಸರ್ ಕರ್ತಾರೆ ನೋಡಿ.
ಬಂದೆ ಬಂದೆ.
ಕೇಳ್ರಿ ಅವ್ರಿಗೆ ಸ್ವಲ್ಪ ಏನೋ ಡೌಟ್ ಇದೆ.
23 ಮ್ಯಾಟರ್ ಅದಲ್ರಿ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಂಡ್
ಅಲ್ಲ ಒಂದು ಡೇಟ್ ಯಾಕಂದ್ರೆ ನಂದು ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲವಾಗಿತ್ತು ಅದು.
ಅದಕ್ಕೆ
ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲ ನೀವು ಹೇಳ್ರಿ ಅದಕ್ಕೆ
4 weeks.
ತೋರ್ಸ ಈ ಬ್ರಾಂಚಿಗೆ ಆದ್ರೆ ಬೆಳಿಗ್ಗೆ ಆದ್ರೆ ಏನ್ ಪೇಪರ್ ಪ್ಲೇಸ್ ಮಾಡಿದ್ವಿ, ಯಾವ WP ಇಲ್ಲ ಹಾಕಿದ್ವಿ, ಒಂದು ಇದರಲ್ಲಿ ಬಂದಿದೆ. ಹೇಳಿ ಬ್ರಾಂಚ್ಗೆ ಹೋಗಿ ಹೇಳಿ ನಾ ಒಬ್ಬ WP ಬ್ರಾಂಚ್ ಫೋನ್ ಮಾಡಿ ಏನಿದೆ
28ಕ್ಕೆ 29 28ಕ್ಕೆ 29 ನವೆಂಬರ್ದು ಇಲ್ಲೇ
ಏನಿದೆ ಬೋರ್ಡ್ 29 ಸ್ಟಾರ್ಟ್ ಇತ್ತು ಬೋರ್ಡ್ ಇಲ್ಲಿ. ಹಾ ನವೆಂಬರ್ನಲ್ಲಿ ನವೆಂಬರ್ನಲ್ಲಿ 6th 7th ಸಿಕ್ಸ್ ಕೊಡೋಣ. ಹಾ 57 ಏನ್ ಬೇಕು ಇಲ್ಲ ಮೇಲೆ ಹಾಕಕ್ಕ ಜುಡಿಷಿಯಲ್ ಆರ್ಡರ್ಸ್ ಬೇಕು. ರಿಜಿಸ್ಟ್ರಿ ಲೆವೆಲ್ ಮೇಲೆ ಇಲ್ಲಿ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಯಾವಾದ್ರೂ ಕೂಡ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬರ್ತದೆ. ಕಡಿಮೆ ಆಗಲ್ಲ.
ಈಗಾಗಲೇ 25 ಆಗೋದು. 6 ತಾರೀಕು ಈಗಾಗಲೇ 20 ಅದು 6 ತಾರೀಕು ಈಗಲೇ 20
ಬಸಪ್ಪ ಆ WP ಬ್ರಾಂಚ್ ನಂಬರ್ ಒಂದು ಡೇಟ್ ಮ್ಯಾಟರ್ ಇದೆ ಅಂತ ಹೇಳಿ ಆ ಕನ್ಸರ್ನ್
ಅಲ್ಲೇ ನಂಬರ್ ತೋರು
4149 ಫೋನ್ ಮಾಡಿ ಬಾ ಅಂತ ಹೇಳಿ ಹೇಳ್ಬೇಕು. ದೂರ ಬರುತ್ತೆ